Yes.
Happy Vijaya from all of us.
Same to you. Same to all of you. Happy Vijay and everything in between. Yes.
My lord, I was mentioning one Pathad circuit bench matter.
Please
I
hand over.
mentioned it before vacation, but time.
No, hand it over.
Lots of kindly.
Whenever the file comes, we'll just.
Before you stop, my lord, thereafter matter of not called and sent to the vacation bench, my lord. And again send my lord the bench matter, my lord, to the before your lordship.
Not taken up by the vacation bench.
No, my lord.
Hand over this.
My lord, may I have a lordship leave to move an urgent listed motion, my lord? I'll file it tomorrow. Today, my lord. Kindly may I to appear.
Tomorrow, very well. Leave the
May I permit to mention one application I moved before the vacation.
application, please hand over.
I will directly to appear before lordship subject to your convenience. Vacation.
Yes, yes.
There's a quantum application, my lord.
Subject to your lordship.
Yes,
Is all the matters, please hand over the list.
My lord, this is the one inclusive of a new motion, my lord.
Hand over. All the list.
My lord, I have certain urgencies, my lord, because, my lord, I am.
Upgradation, you are seeking upgradation. Mr. Senior, I am coming back to you.
Yes.
Upgradation, why? What is that? This?
The grandfather property is grandson. Thereafter, grandfather filed an application with the learned against his son, but not grandson. The district magistrate cancelled the said deduct. It has made a representation.
Not so urgent. Not so urgent. No upgradation. No upgradation.
Your lordship, অনারেবল জাস্টিস অভিজিৎ গঙ্গোপাধ্যায় ভ্যাকেশন বেঞ্চে একটা অর্ডার দিয়েছিলেন, যেটা কালকে 17 তারিখে ব্যাংকের রিপোর্ট সাবমিট করতে বলেছে।
এটা আমার লিস্টে নেই।
আপনার লিস্টে নেই, এটা ভ্যাকেশন বেঞ্চে করেছিলাম। অর্ডারটা একবার দেখে নিন। আমি তাহলে কালকে ম্যাটারটা
এটা কালকে লিস্টে দিবে। It will we'll try to keep it in tomorrow's list. If the file comes, it will be in tomorrow's.
Thank you.
Oh, Mrs. Sinha,
Yes,
sorry.
my lord, the bid was opened on 4th November, my lord, and my lord, I was declared L1, my lord. That will be appearing from the chart, my lord. And thereafter, my lord, on the same day, they have changed the terms and conditions of the slab.
This is a new matter. It is appearing in the list, or it's a.
My lord, I have already obtained leave from the
It
vacation
is
bench.
appearing in my list.
No, my lord. If this can be taken up, my lord, tomorrow, my lord, I have already issued notice, my lord.
Tomorrow, no. I will definitely include. Will let us see.
For upgradation, this report filed on 21st December 2022.
Upgradation standing that side, I said no. Oh no, it was someone else. I'm sorry. No, somebody else. Yes, what is the urgency?
Urgency, my lord, on 14 October 2022 at 3 p.m., shop of the petitioner at Bowbajar was cracked but damaged by the fall of Metro Railway. There the petitioner made representation, made the publish a list for giving compensation. My item 11. But till now, I am not getting compensation. My
Not so urgent.
But several times mentioned, my lord,
No,
matter was filed 2020.
It is in the list.
My lord.
No upgradation. No further upgradation.
My lord, item number 49 of my lord's daily list. The urgency is I am the developer and an association has been purportedly formed violating the West Bengal Apartment Ownership Act. Like Form A, they have submitted that has many discrepancies, and now the urgency is they are trying to forcibly hand over the maintenance duties from me. I have not formally hand over the duties because that has been formed with many discrepancies. My lord, the urgency is they are trying to take over the maintenance duties and they are trying to usurp the maintenance charges from the flat owners from 1st December on.
No upgradation. No upgradation. Sorry. Call on the list.
Appellate side daily list. Item number 1.
My lord.
What to be mentioned?
Yes. I am for the respondent, my lord. My lord, as per your lordship desire, my lord, I have issued a notice to the advocate appearing for the petitioner that it was hard on such and such date and his lordship was directed. My lord, it is the thing is that a stereotype thing. Like all the borrowers, these borrowers also finding so many faults of recovery proceeding of the bank. And my lord, it is Bank of Baroda, my lord. And my lord,
so you have filed a Section 14 application.
Yes, Section 14 application.
What is the relief you seek in the writ petition?
No, I am not the writ petitioner. I am the respondent.
What is the relief they're seeking?
Relief, actually, the grievance is that time when the writ petition was filed, that time the DRT2 was not functioning. DRT3 was not functioning. But now...
so you said it should go before the DRT3?
Yes, nothing remains here. My lord, already essay has been filed there and that is pending. Bank has also filed OA and my lord, the due amount is near about 1 crore.
Sapal, I'll direct this to appear under the list upgraded motion heading tomorrow.
My lord, he is not
No,
interested.
it has to appear from under to be mentioned. I cannot pass a final order.
Yes, my lord, my lord.
It will appear tomorrow as upgraded matters and give a further notice to the advocate for the petition.
My lord, it is very difficult to find it out. He is not practicing here. He is practicing debt recovery, but I will try.
Let's recover time. I'll keep it then on Monday under the
Yes,
upgraded
yes,
motion.
yes. Monday it will be better. My lord.
There is some urgency. একটা order record. There is some urgency in the matter. So it is submitted by learned counsel for the respondent that although the concerned bench of the debts recovery tribunal is functioning, comma, which affords a parallel remedy, comma, the writ petition has been kept pending unnecessarily. Full stop. None appears for the petitioner despite service. Full stop. To afford another opportunity to the petitioner to submit its version, comma, the learned advocate on record for the petitioner is requested to serve a notice indicating that the matter will be listed under the heading upgraded matters on November 20, 2023.
Much okay.
Item number 2.
In this matter, I am appearing
Escape.
on with the petitioner. But I could not, but I am filing the affidavit in reply.
So this is a final getting better. And your lordship is aware, for ticket figure yesterday, we are not. So let it be fixed next week. It's a hearing matter.
Give me a date which suits all of you, Mr. Dr.
Tuesday.
Tuesday is a holiday, Janmashtami probably. So I'll keep it on Wednesday then. I'm sorry, Jagadatri Puja. So 22nd Wednesday.
And reply file may be kept. Opposition and reply both.
Opposition, affidavits in opposition and reply filed today be kept on record. Full stop. Let the matter be listed for hearing under the upgraded matters heading on November 22, 2023.
Grateful.
Thank you.
November 22.
Item number 3.
Yes.
My wishing you lordship Shubha Vijay.
Same to you. Same to you. Same to all of you. Thank you, Dr. Sir. Yes. Yes, Mr. Haldar, what is it?
Is a tenant
Yes.
applied for new electric connection and the CSC made reply that is the annexure P2 page 10. Paragraph number 2. After our site inspection on such and such, you had been advised to identify in consultation with other owner applicant a suitable common place of shifting of the existing service at the above premises. My lord, I am the tenant. I need electric connection.
What is the occasion for shifting?
So far, the connection given, we have got no objection to be. What happened? You have made an inspection. We found that it is open to, there is no specific meter shed. There was already an existing meters there, and it is open to rainwater. And there is every chance of electrocution. We have requested to make a proper meter board there, either on that place or to some other suitable place.
Shahara, the difficulty is that existing position that is already catering to electricity connection for the landlord.
Not only landlord, there is also other consumer also.
So what you are citing, that has no nexus with his application for.
No. So far there is no.
Two different matters.
No, this is different. We are not putting.
Take recourse to your whatever steps you have.
One thing, lordship, kindly appreciate the situation, lordship, come out of the situation, because there is it is open to rainwater.
Dr. Shahara, these are other issues which you have to take care of at the licensee. As the licensee, you give proper notice to all the consumers, but give them electricity connection and take steps. I'll give you liberty to take steps. Write to all the consumers, including them, so that they may take remedial steps.
Lordship,
that has no nexus with this.
No. Kindly made that observation, because under section 53, your lordship knows that the safety measure is to be taken into consideration.
Oh, sure, absolutely.
Yes. On that issue, lordship, kindly take that observation.
Learned counsel,
so that we can take concrete steps.
Learned counsel for the petitioner submits that the petitioner is a tenant in respect of the property and seeks an independent electricity connection, comma, to which the CSC Limited has no objection on principle. Full stop. Learned counsel for the CSC Limited, comma, however, comma, submits that the electricity meters standing at the premises are at a precarious position, comma, since due to absence of any meter shed to protect the meters from the vagaries of nature. Full stop. Next para. However, comma, the issue pointed out by the CSC Limited has no nexus with the right of the petitioner to obtain an independent electricity connection. Full stop. Since such an application has been made, comma, the CSC Limited is duty bound to give the same, comma, subject to compliance of formalities by the petitioner. Full stop. If necessary, comma, the CSC Limited shall definitely be at liberty to take appropriate steps for ensuring safety and security measures, comma, by writing duly to all the consumers, comma, including the petitioner, comma, when given electricity connection. Full stop. Next para. Accordingly, WPA 22452 of 2023 is allowed, comma, directing the respondent, the CSC Limited, to give electricity connection to the petitioner in the petitioner's name at the premises, subject to compliance of all formalities by the petitioner within a fortnight from date. Full stop. Next para. It is made clear that the CSC Limited shall be at liberty, comma, independently from the above order, comma, to take necessary measures for ensuring safety and security at the premises, comma, if necessary, by writing duly to all the consumers, including the petitioner, for the purpose of the latter taking measures to ensure such safety. Full stop. No orders to cause urgency.
Deep level.
Item number 4.
And for the petitioner, Lordship. Lordship,
CS, my lord.
Lordship, petitioner is the occupier of the premises and is carrying on tailoring business. For that, he has applied for industrial connection for the said premises, but no steps has been taken by the CSC authority.
It's a case of splitting of load, my lord.
There is
We
no,
have caused the inspection and we have seen that the petitioner has been enjoying connection from his mother's meter.
that is a domestic connection, Lordship.
And my lord, initially, he was applying for a domestic connection for the purpose of his commercial needs. And subsequently, he has approached for an industrial connection, my lord.
Mr. Ghosh, there cannot be any splitting of load if there is one domestic
No,
connection
my
and
lord,
another.
no, my lord. Because, my lord, we have already communicated him explaining our situation. May I submit the communication?
Yes.
To your lordship?
Previously, you had rejected one application because there are several applications. You have page 10.
Initially, we could not get any access.
No, page 10. Please come to page 10 once, Mr. Ghosh.
Yes,
Para two?
petitioner applied various times, Lordship. We have stated in our petition.
Para 2, you have rejected one of their applications.
My lord, the final reason for rejection has been explained in this communication.
Lordship, that is a domestic, only one domestic connection is existing in the said premises and petitioner applied for industrial connection, Lordship.
For a tailoring shop,
Tailoring, not
petitioner
tailoring shop,
should have approached for a commercial connection.
he is carrying on,
Commercial connection. Why industrial?
he is carrying on the sewing work there, the machine has been set up there, Lordship.
Sewing work machine, does it require an industrial connection?
Very
That
low.
I have to take instruction, Lordship, but he has
No, Mr. Ghosh, splitting of load is not applicable here. Either industrial or commercial, that cannot be said to be a
My lord,
splitting of
if
load.
he applies for a commercial meter, my lord, we will cause a further inspection, my lord, and we will act.
Agreeable to
in accordance with
commercial.
law.
Lordship, we will apply.
Learned counsel for the petitioner contends that the petitioner's application for obtaining electricity on an industrial basis has been refused by the CSC Limited. Full stop. It is contended that the petitioner has been running a tailoring shop and has installed machines for which purpose such connection is required. Full stop. Next para. Learned counsel for the CSC Limited places reliance on a communication dated March 2, 2022, a copy of which is handed over in court today and is kept on record, where the CSC cites several reasons for refusing electricity connection, comma, the primary of them being that there is intention of splitting of the existing load which the petitioner is enjoying from his mother's meter at the same premises. Full stop, next para. From the annexures to the writ petition, it transpires further that another application of the petitioner has been rejected for due to there being multiple applications. Full stop, next para. Be that as it may, comma, it is an admitted position that the previous electricity meter from which the petitioner has been enjoying, comma, in the name of the mother of the petitioner, comma, is a domestic connection, whereas the petitioner wants an industrial connection. Full stop, next para. Thus, comma, it cannot be said that if a new commercial or industrial connection is sought for, comma, the same will tantamount to splitting of load on the ground that there is a pre-existent domestic connection, comma, since the tariff rates for industrial or commercial connections are higher than domestic connection and no effective splitting of load beneficial to the consumer can be obtained in such manner. Full stop, next para. Insofar as the other objection of the CSC Limited is concerned, comma, as expressed in court by learned counsel, comma, the CSC Limited apprehends that for running a tailoring shop and installing machinery thereof, comma, no industrial connection but a commercial connection is required. Full stop. On instruction, learned counsel for the petitioner agrees to apply for a commercial connection. Full stop. Hence, comma, WPA 22464 of 2023 is disposed of by granting liberty to the petitioner to apply afresh for a commercial connection at the premises in question. Full stop. If so approached, comma, the CSC Limited shall process the same and subject to the petitioner complying with all other formalities, comma, give such electricity meter to the petitioner without setting up the objection that there will be an apprehended splitting of load due to pre-existence of a domestic electricity connection in the name of the petitioner's mother. Full stop. No orders to cause, urgent certified copies. No orders to cause এর আগে আরেকটা line. The CSC Limited shall, comma, subject to compliance of formalities by the petitioner, comma, shall give such connection to the petitioner within a fortnight from such compliance.
Initially, an inspection is to be conducted, Milord.
Do everything within
Yeah.
2 weeks.
Milord,
Under
let
the
that
law,
part-
you are to
Milord,
give
let that part also be included in the record.
No, Mr. Ghosh, under the law, you are to give the electricity connection within 48 hours. I've given you 2 weeks instead of 2 days.
Milord,
So do that.
subject to compliance.
Subject to compliance.
Next.
Grateful. Item number 5.
Milord, I have heard the CSC, Milord.
Yes.
Your lordship has directed to file an report, Milord. We have caused an inspection, Milord, and we have found there is no case of any hooking as alleged by the petitioner, Milord.
They alleged hooking against private respondent.
My lord, there is a two premises.
Everything has been explained in my report, Milord.
Copy দাও।
দিলাম তো এই তো
Mr.
Then, my
Haldar,
lord,
this,
let
this
it be not to
no, you have no locus standi to go on further.
Exactly.
You have complained, they have dealt with that complaint. If they say there is no hooking, you cannot insist upon any
and
further.
and the petitioner also was not able to produce any of his documents which we have sought for. That is also indicated in our
My
report.
lord, let it be one day accommodation, my lord. I'll take instruction on this point, my lord.
I'll give you liberty to make a police complaint, and if you make that, they'll be.
Well,
Learned counsel for the petitioner contends that the private respondent has been effecting pilferage of electricity. Full stop. On the last occasion, comma, an inspection was directed to be undertaken by the CSC Limited, comma, pursuant to which a report is filed today. Full stop. Learned counsel for the CSC Limited, by placing reliance on the said report, submits that there is no instance of any pilferage or hooking by the private respondent. Full stop. Learned counsel for the petitioner denies the contents of the report. Full stop. However, comma, the role of the petitioner is at best of a complainant. Full stop. The court cannot permit any further inquiry within the scope of a writ petition, comma, since the licensee itself, comma, upon holding an inspection has come to the opinion that there is no instance of pilferage. Full stop. Next para. without going into the merits of such report, comma, since the licensee is of such an opinion, comma, the petitioner cannot have any further cause of action in the writ petition. Full stop. However, comma, in the event the petitioner is further of the opinion that there is a continuing pilferage, comma, it will be open to the petitioner to lodge a complaint before the appropriate local police station. Full stop. If such complaint is made, comma, the appropriate authorities shall take necessary steps in accordance with law on the same. Full stop. Next para. It's WPA 22772 of 2023 is accordingly disposed of by keeping the inspection report filed today on record. No orders to cause service.
Thank you. Item number 6. I am from the petition lordship.
I
This
appear
is
on
my
behalf of the
affidavit of
CS.
service.
Yes.
Lordship, petitioner is the owner of
পরে
the
ফাইলটা খুলে রেখে দাও, হ্যাঁ? Yes.
petitioner
Owner of-
is the owner of the premises lordship, applied for new service connection, complied with all the formalities including payment of service charges, but due to the objection of the private respondents, CSC authority could not lordship give such connection lordship.
Yes.
My instruction is, the annexure B, was not complied with, did there be a direction, with police help to give the new service
Lordship.
connection and compliance of
Annexure?
B? That is under regulation 46,
Lordship, we will comply.
What is that?
certain agreements, certain load specifications and other things has to be given,
You have to disclose those.
Yes.
Lordship, one annexure B form has to be filled up, we will comply lordship.
Learned counsel for the petitioner argues that due to resistance by the private respondents, the electricity connection sought by the petitioner could not be given. Full stop. Next para. An affidavit of service is filed today and is kept on record, which indicates proper service on all the respondents, comma, despite which the private respondents choose not to appear at the time of call. Full stop. Next para. Learned counsel for the CSC Limited raises a minor technical objection regarding compliance of within single inverted annexure B, single inverted clause by the petitioner. Full stop. The petitioner is agreeable to comply with such formalities as expressed through learned counsel for the petitioner. Full stop. Hence, WPA 23683 of 2023 is disposed of by directing the CSC Limited to give electricity connection to the petitioner within 48 hours from compliance
this is
by the
news.
petitioner, comma, subject to compliance of all formalities by the petitioner, including the formalities as raised by the CSC Limited.
This is a new service connection, let more time be given.
More than 2 weeks. 48 hours is the time limit.
New service connection.
What is the time limit for that? 2 years.
No, will give us around
and a half?
1 week time.
24th.
2 weeks, my instruction 2
We
weeks.
have given you 2 weeks.
No, 2 days, 48 hours, it has given.
I said 48 hours. Oh, sorry. 2 weeks away. I was 2 weeks away. Subject to compliance of formalities, including the compliances as pointed out by learned counsel for the CSC Limited. Full stop. In the event any obstruction is given, it will be open to the CSC personnel to approach respondent number 3, the officer in charge of the Rabindranagar police station, who will grant necessary police assistance and break open any padlock or other hindrance if necessary for such purpose, comma, to ensure that electricity connection is given to the petitioner, comma, at the cost of the petitioner. Full stop. No orders to cause service.
Great.
Item number 7.
শেষ করে যাবে এটাও ঠিক আছে
I appear on behalf of the CSC.
Well, I am for the petitioner. My lord, petitioner is carrying and owner is carrying on business, state license I have annexed and made several application for new connection. And my lord, reply is annexure P4, page 13 of the CS. 12. 12 next before that my lord, annexure
Page 12, এখানে আমার 12 এটা দেওয়া।
page 12 my lord, also kindly see annexure P3. There is an outstanding dues. We are ready to pay outstanding dues.
So why do you prefer the writ petition?
No, but
Your
next,
fees,
next
it will be adjusted from your fees.
no. My next page, annexure P4,
Yes.
they have made elaborate reply, my
They
lord.
kindly come to the fourth paragraph.
Fourth paragraph.
This is, my lord, after the order has been passed by the GRO.
What has happened? Tell me.
If we alleged in respect of
reference number.
splitting of load, the GRO has upheld it, subsequently another application has. Kindly come to the fourth paragraph.
Trace reference number.
We have categorically stated, and we have also given the meter number from whom he is deriving supply.
GRO অন্য reference number এ করেছে।
That is the other reference number. GRO has.
GRO has passed the final order after that.
Yes, one of the order of GRO has been passed.
Draft order.
Yes, well, final order has to be passed right now.
That is in respect
Yes.
to difference.
Cannot get an cannot get a supply.
That is
The GRO has held against you that it's splitting of load.
Difference. That is the difference.
reference number.
Reference number. And here the subsequent applied.
It
And
has to be a different number because earlier they have applied with certain number.
MI says are same.
same.
You are same.
Same.
If there is splitting of load in one application, there has to be same logic applies to a new application. That's why rightly rejected.
Or my lord,
Pass there.
Not my lord.
or let it be referred to the GRO.
No, let it be rejected here. Why
Let
ref-
it be rejected.
Yes, GRO has. Why repeat the exercise again and again?
Ombudsman.
No.
Then ombudsman,
Learned counsel for the
I
petitioner.
have to get electricity, my lord.
You have electricity.
No,
Splitting of load, otherwise, how can they? Splitting of load is the ground.
we have taken down, but.
Learned counsel for the petitioner submits that the petitioner applied for electricity connection, which has been refused by the CSC Limited, comma, prompting the instant writ petition. First up, learned counsel for the CSC Limited places reliance on a communication dated September 12, 2023, which is annexed P4 at page 13 of the writ petition, where the CSC Limited pointed out that a previous attempt by the petitioner to take electricity connection was refused on the ground of splitting of load, comma, which was upheld by the grievance redressal officer. First up, since no challenge has been preferred against the same, comma, the said order has attained finality. First up, next para. Upon a perusal of the materials on record, comma, it transpires that the CSC Limited is correct in submitting that the petitioner has renewed the efforts which were already turned down by the GRO on the ground of splitting of load, comma, by making a fresh electricity connection for the self-same property. First up, next para. Since in view of the above reasons, comma, such effort on the part of the petitioner cannot be upheld. Full stop, next para. Hence, WPA 23686 of 2023 is dismissed without an orders to cost.
Mal, keep your.
Next.
Item number 8.
Not happy for that.
Yes.
Happy for the state.
Yes. What is the matter?
Here, my lord, the tender notice was floated by the respondent authorities for the purpose of construction of a portion of a road, my lord. Petitioner
Construction of
portion of a road, my lord.
road. Right.
Road. My lord, petitioner participated in the tender process, my lord, and found to be successful and completed the work, my lord. Thereafter, my lord, state has taken a policy decision
Yes.
for the purpose of payment of compensation to all the contractors, my lord, due to unusual price rise of bitumen. Price.
You are one of the contractors.
One of the contractors. My lord, for the purpose of claiming that compensation, my lord, I moved a writ application before this honorable court. My lord was pleased to direct the authorities to take a decision in this matter. Thereafter, only hearing was conducted, my lord. But during the course of hearing, my lord, we have detected, my lord, the principal cost of bitumen has not been paid. My lord. And
That's a separate cause of action.
sir, that we have challenged, but that has not been paid, my lord. And in support of that, my lord, we produce, my lord, DPR, detailed project report, my lord, which is, my lord, the part of a supplementary.
There is no arbitration clause in the agreement. Read court, how can the read court decide these issues? These are factual issues. How much has been paid?
I have a maintainable point on this.
What is that, Mr. Galit? Short, not your usual thing.
Not
But,
as usual.
Maintainability point, not your usual thing. Maintainability
69
point,
is a-
very precise.
Very precise means, my lord, it's out and out a money claim, lordship.
Very well. Yes,
page
deal
69
with that first, then I'll hear him at length.
But
Any
page,
claim, yes, why not?
but page 69 is the impugned order, my lord.
We have given the compensation, is unwilling to accept it.
No, compensation is not connected with the
No.
original claim. Take the compensation without
But-
prejudice to your rights.
Without
I'll make
prejudice,
that-
my lord.
I'll make that clear.
As your lordship.
But
And
how
but-
can I enter into this dispute?
But
the other dispute?
we have produced, my lord, the DPR, my lord, detailed project report, my lord, wherefrom it appears, my lord, the cost of bitumen was not even, my lord, the calculated in the DPR, my lord. They are saying it is their internal matter, my lord, they will not consider.
Where is that? Show me.
My lord, the page 69, my lord, second paragraph. May I read for lordship, my lord? Shandip Biswas, sole proprietor of Sukanta Construction, turned up at the hearing as scheduled and placed his oral statement, also submitted his written submission. He stated that he did not get any compensation on account of hike in price of bitumen in terms of order number such and such, and additionally he did not get the payment of cost of bitumen supplied by him against this work. He admitted receiving the full payment as per BOQ specific period schedule as annexed in the contract agreement made between the petitioner and the department. In support of his claim for payment of the principal cost of bitumen, he produced an extract of DPR showing rate analysis involving use of bitumen in DPM and BC being the items of work. Be mentioned here that BOQ specific period schedule containing the rate of different items of work in part of agreement, but DPR is used internally within the department is not part of the agreement.
DPR is authored by whom?
But the executive engineer, my lord. But it is a part of the supplementary.
So it's a question of the evidentiary value of the DPR.
But apparently from the DPR it appears, my lord, if you also kindly turn, my lord, page 99, 20, my lord, a supplementary affidavit, my lord. Page 19, my lord, serial number 12, my lord. Bitumen dense bitumen mechanism 50 mm thick aggregate, my lord, against that blank. And thereafter in clause 13, my lord.
Not blank. There are subheadings under that. Against the subheadings, there are certain amounts mentioned. It's a heading.
But
it's not blank after that.
No, but
that's a broad heading. That's a heading dense between macadam whatever. After that, aggregate everything is given.
But it is related to others, not the cost of the bitumen.
You cannot decide this in writ petition. No, this is absolutely a disputed question of fact. And on what basis, without evidence, how can you decide into this?
And clause 13, my lord, also, my lord, that was not even considered by the authorities, my lord, at the time of hearing, my lord.
Yes, Mr. Galib, why do you say this is not a valid piece of evidence? Factually, you are right, we cannot decide into this. But your only ground of refusal is that it's a DPR is used internally within the department. Even if it is used internally.
We have come up with a detailed instruction in this matter.
Mm-hmm.
Milord, Lordship's, Milord, order was, Milord, kindly see that page 56 of your Lordship's, Milord, brief, Milord. The first writ petition, Lordship, and the order passed therein, Lordship. At page, Milord, 56, Milord.
The 56 is the starting of that. Where is the ordering portion? Let us see.
That is, Milord, kindly sees the
58.
Starting portion, Milord. Submit the petitioners are entitled to compensation.
57 last line.
Work done. And Milord, kindly sees, Milord, the last. Lordship was pleased to direct the respondent number 5, Milord. Kindly sees page 57. Accordingly, WP was disposed of by directing the respondent number 5. Lord, to disburse the amount due to the petitioner for the work done by the petitioners if done in terms of clause 2 of order dated 2007 annexed at page 1 of the present petition. Accordingly, Milord, this particular Milord, upon giving hearing, Milord, at page 69 is the Milord, his end order.
This was with in connection with the enhanced
compensation.
This has no nexus with
price hike in the
this has no nexus with the present claim.
No.
Compensation you have paid. You have
No, he has
tendered.
not
Calculated.
that.
You have tendered. Not your fault.
Now,
But now he says the main thing has not been.
Now he says principal price of bitumen that I have, Milord,
Yes.
purchased, Milord, has not been paid. It is, Milord, it indeed has been. May I take out the submit?
No, Mr. Galib, before going into that,
Lordship.
before going into
There are
that,
judgments, Milord.
before going into that,
Lordship.
Before going into that, please come to page 69. Your only reason is that DPR is used internally within the department, so you have refused to look into that. I'll direct this authority, your authority, to reconsider this with their whatever points they have taken.
That's what
Rehear
I
them.
find, Lordship, because in the instruction they have said, Milord,
Yes.
that we have paid it, but it is, Milord, hidden within the bill which has already been paid to him. Because bitumen, if I hand over,
That is also hidden within your order. That logic is not there in your order. So
may I
there,
hand
there's a
over
double
copy?
hiding. Learned counsel for the petitioner need not. I will not go into that. I'll record my reasons. Learned counsel for the petitioner contends that initially the respondent authorities adopted a policy of disbursing additional amounts to all contractors, comma, in lieu of enhanced rates, comma, as compensation. Full stop, next para. However, comma, subsequently, upon the petitioner moving this court, compensation was directed to be given, at which juncture the petitioner discovered that the original price of the work done by the petitioner was also not paid to the petitioner, for which the present writ petition has been preferred. Full stop, next para. It is pointed out by learned counsel for the petitioner that by an order dated August 22, 2023, comma, the respondent authorities proceeded on the premise that the detailed project report within bracket DPR authored by the executive engineer of the respondents themselves is used internally within the department and is not part of an agreement, comma, thereby precluding a vital piece of evidence to ascertain whether the actual costs were paid to the petitioner. For sub next para, learned counsel for the respondents takes a preliminary objection of maintainability as the claim pertains to a money claim. Full stop. That apart, it is
And disputed question of fact.
that apart, comma, it is argued that the issues raised by the petitioner involve disputed questions of fact which ought not to be decided by way of a writ petition. First up, it is also contended that the payments for the original work done by the petitioner are hidden in the documentation between the parties. First up, be that as it may, comma, it transpires from the impugned order dated August 22, 2023, passed by the respondents, that the respondents did not consider the points now raised by the petitioner or that the amounts were hidden within any previous document, but proceeded merely on the premise that the DPR is used internally within the department. Pushup, it also failed to consider that the DPR, comma, even if used internally, comma, is also a circumstantial piece of evidence to indicate the work actually done by the petitioner and whether actually payments have been made on that such score. Pushup, be that as it may, comma, the respondents have a point in arguing that detailed questions of fact regarding evidence need not be gone into, ought not to be gone into by the writ court. First up, in view of the reasons given above, comma, it would only be appropriate if the respondent authorities are directed to revisit the issue and upon hearing both sides, comma, and as well as looking into all the documents in their proper perspective, comma, come to a come to a detailed conclusion as to whether any further amount is due to the petitioner for the original work done by the petitioner. First up, next para, accordingly, WPA 23752 of 2023 is disposed of by setting aside the order dated August 22, 2023, annexed at page 69 of the writ petition and directing the respondent authorities to give a fresh opportunity of hearing to the petitioner, and upon considering the arguments of the petitioner and all relevant documents in that regard, including the detailed project report relied on by the petitioner, comma, come to a fresh reasoned conclusion as to what amounts, comma, if any at all, comma, are due to the petitioner by way of the work originally done by the petitioner. First up, next para. It is made clear that nothing in this order shall preclude the respondent authorities to disburse the amount due to the petitioner afresh, comma, lieu on account of the compensation for the purpose of enhanced rates. First up, if such tender is made to the petitioner, comma, the petitioner shall receive the same without prejudice to the rights and contentions of the issues involved in the rehearing as directed by this court. First up, it is expected that the rehearing pursuant to this order shall be concluded at the earliest, comma, positively within 2 months from this date. No address to cost urgent
Lordship,
certificate.
may I
Supplementary affidavit filed to be kept on record একটা line দিয়ে দেবেন।
And
Your
affidavit
lordship be
service
kind enough frame
Yes.
the issue with regard to fresh hearing. That is with regard to payment of principal cost of bitumen.
I've said that in my order. And I've made it clear that regarding the enhanced compensation, you will disburse, they'll accept without prejudice to the rights. And this will be only regarding in the all the paragraphs I've stated.
May I pray for one sentence, Lordship? Lordship has not gone into the merit of the case, Lordship.
How can I? I've directed rehearing. After that, I'll go into the minutes. Yes, next.
Item number 9.
9. You are for the petitioner?
Respondent number.
Respondent. Yes, what is the matter?
The facts is nutshell is that, my lord, the petitioner is a borrower. And my lord, bank has preferred a original applications before the DRT.
You are
original.
for?
My lord, I am the advocate on record in this.
You are leading him? Yes.
My lord, regarding this, my lord, 2 OA has been filed by the bank before the debt recovery tribunal. Now, my lord, for quick disposal of disputes with regard to that, the bank has referred these 2 matters to the Lok Adalat, learned Lok Adalat. Remember, they are in the learned Lok Adalat, a settlement is arrived at, and the Lok Adalat passed an award to the defendant. The matter was settled there. My lord, the amount due, the settlement amount was 1,01,70,00,000. Now, my lord, out of that, my lord, in September, it was decided to first payment has to be made 17 lakhs. My lord, in December 29. Well, December 29, it was the petitioner was failed to pay the first 17 lakhs, but the total due has to be paid within a period of 3 months. Now, that has not been. The very next day, the petitioner made a prayer before the bank so that this extension can be given. Now, he decided to pay on that later. They decided to pay the whole sum within a specific period that has been given. That whole.
Who decided to pay? You.
My lord.
I don't understand. You paid for an extension.
I made for an extension of time in terms of that, my lord, because these 3 months has been given by the.
That extension was granted to you?
That was rejected. Thereafter, during the I filed this writ petition, and thereafter
extension for your payment of the rest of the amount.
Not only full, but in one shot I have to pay one.
Is rest of the amount? That is what I'm saying.
Well, rest, the total settlement amount.
Rest of the amount means the total settlement amount.
Now, thereafter, what happened? They have rejected that prayer. But in the meantime, I filed this writ petition. During the pendency, the bank has sent a letter to me by a mail that they are agreed to accept that. That in I have annexed this, my lord.
What remains?
My lord, remains is that, my lord, unless your lordship did this, that is only my client.
Are you agreeable to this?
I got instruction only if they pay in one
one
shot.
That I have prayed,
But
and
only difficulty is they are making payment to third party, which we cannot.
This is, my lord,
Through third party?
Yes.
Affidavit service to.
They have to make a demand draft in favor of the bank by their own. Kindly appreciate,
Yes, you
my
have to
lord.
do that.
Yes.
Do that.
Third party subsequently claim
Third
against
party
the
complications will arise.
my lord, kindly. My lord,
So make the payment tomorrow.
Let it be recorded. Yes,
Make the payment tomorrow. You are ready with the amount, must be. Since you have
the
preferred
matter
it.
tomorrow, my lord. There are 5 times they have defaulted in payment. Kindly
only
keep it
one,
tomorrow,
because
my lord.
tomorrow,
Let
my
them pick the bank draft, my lord. I have taken
Tomorrow,
instruction.
your lordship, kindly, tomorrow is a Friday.
Day after
Kindly
tomorrow?
one week time is given.
1 week.
So just
That's
1
the
week,
difficulty.
and the draft has been given by the issuer will be the
30th
petitioner.
September, the bank had. They.
What have you challenged in the writ? What is the cause of action of the writ petition? They sent a notice.
That is
Past- yes,
not
yes.
maintained.
The-
It is not
No,
maintained.
You sent a notice. What is the?
Kindly see, my lord, page
Your lordship,
18.
kindly see the
This is the
impugned
order
order.
passed
No,
under
let-
the
let- Yes. What is the cause of action of the writ petition?
But the impugned order. That
What is
is at
that? What do
page
they do by that?
page 18, not the impugned order. My lord, the award, your lordship, will find at page 18. Then I made a prayer, that's page 19, and they rejected it. Your lordship will find at page 22.
A settlement was arrived at by the parties before the Lok Adalat. However, the petitioner subsequently sought for an extension to clear the entire dues, which was not granted. The bank subsequently took steps for realization of the amount on which the petitioners have approached this court. In the meantime, however, the bank is agreeable to accept the due amount payable by the petitioner. Learned counsel for the bank submits that the petitioners are attempting to make the payment through third parties, which would create complications. However, the bank is agreeable if the petitioners immediately clear off the rest of the amount directly by way of presentation of bank draft. Next para. The petitioners seek a week ' adjournment for such payment. Next para. In such view of the matter, WPA 23758 of 2023 is disposed of by directing the petitioners to pay the rest of the balance amount in full and final settlement of all dues as agreed between the parties by way of a bank draft within November 24, 2023. Next para. In the event such amount is paid, the bank shall take necessary steps subject to satisfaction of the bank of the veracity of the demand draft, to indicate that all dues have been cleared off in favor of the bank by the petitioners. In default of such payment, however, the bank will be at liberty to take necessary steps for realization of the due amount. No orders to cause urgency.
Only one indulgence, subject to payment of all the dues, let the documents which are lying with the bank.
They'll take all steps. They'll take all steps.
For releasing the documents, only one.
The bank will take all steps, including for full and final settlement of the as well as release the title deeds of the petitioners in their favor. Only subject to their satisfaction, the bank demand draft is valid. Thank you, Mr.
Demand draft is issued by the bank itself. That should
maybe
be
some other bank. May not be them.
No, other bank is nationalized bank if so.
Demand drafts, there are various forged demand drafts for which several cases are pending before various courts of law.
Much of that.
Item number 10.
Yes. Yes. Respondents.
I appear for the
Yes,
petitioner.
so what is the matter?
Yes. Lord, a report is on the basis of a report under the Companies Act to be filed by the Registrar of Companies. A proceeding is initiated without furnishing a copy of the report to me. There are three stages. The first stage, the commencement is with section 206. Once 206 happens, they file they give us certain grounds for the violation. I respond to it. After my response, under section 210, they're supposed to file a report under 208. 206, then 208.
A report under 210.
No. Investigation or inspection under 210. Under 210, there are three grounds on the basis of which a inspection or investigation can be initiated. Lordship is aware, 1A is the mandate that there has to be a report. If I don't get the report, how am I to respond? How would I know?
Have you got a right of hearing?
Yes, I'll tell you, Lordship. 206.
Please take your seat. Yes. 206.
If I may classify, if I may classify it this way.
Yes, 206.
I'll just indicate first.
Indicate.
206. The end point of 206 results in the beginning of 208 report. 208 report culminates into a 210 investigation. I am challenging the 206 end and the beginning of 208. I'm not even on 210 because 210 mandates that there has to be a report, 1A. They are not under 1B or 1C. So there has to be a report. So I take
the report is bad.
I don't know. When I ask for the report,
yes,
they say, no, you talk to the ministry. And by the notification, I'll show your lordship that notification. This power, has been vested in the regional director. So the regional director
now the 206 stage is over.
Yes, over.
208 report is there. You don't have a copy of that.
I hope the 208 report is
So
there.
what have you challenged in the writ petition?
My lord, the 206 end and the report, well, my lord, I don't know whether the report is there.
But you're trying to
Because-
preempt it, the thing. I mean, unless a report is given to you.
My lord, kindly, my lord, just take the writ petition once. They have initiated action against me. And I don't know, my lord, for what I'm being penalized.
So what would your best relief be in the writ petition? Getting a copy of the report?
And my lord, stay of the proceedings till I respond, my lord.
I'll dispose of the writ petition by directing them to give a copy to you.
And my lord, stay till my lord I respond to the report. Otherwise, my lord, I get a report. I'm not being able to respond. I don't know when the report comes, my lord. And there's not even a foundation. If your lordship kindly takes just one, kindly see the 206 report, my lord.
So you said 210 could not have started.
Correct. My lord, kindly have a look at the 206. My lord, these are page 23, my lord, of the writ petition.
Mr. Mitra, let us start backwards. Let us
Lordship.
come to section 2101.
Lordship.
What is the requirement of that section?
Yes.
Let us come to that. Where the central government is of the opinion that it is necessary to investigate into the affairs on the receipt of a report of the registrar or inspector under section 208, such and such, then in
Right.
public interest, it may order an investigation into the affairs of the company.
Correct.
Now, so therefore, 210 does not envisage any copy of the report being
No,
given
but
to
let's
you.
go back to 208.
Let us go back to that. Yes. After the inspection, yes, and other books and papers, submit a report in writing to the central government.
So there's, my lord, inspection
It's
under
internal,
206.
Mr. Mitra, unless any criminal step is taken.
Yes, it's been taken. That's exactly my point.
So before that forum, go before that forum, what step has been taken?
No, the report is not even disclosed there.
What is the step exactly taken against
My lord, if you kindly take, my lord, I've annexed a copy at page 52, annexure P4. My lord, the criminal complaint has been made. And my lord, these are complaints under section 129, read with 143, my lord, which is nothing, and we have explained it. My lord, I'll show you something, my lord.
So, complaint under section 200 initiates a proceeding under the criminal procedure code.
Correct.
In that proceeding, you'll have
But,
opportunity
my lord,
to
if
get the
I am
report.
not getting the report. My lord, just have
contest it.
My lord,
You have a right in that proceeding. You have a right to get that copy of the.
But they've not disclosed. My lord, kindly just have a look at page 25. My lord, there has to be an end to malafides. I'm sorry, my lord, but this can't continue. Kindly have a look, my lord. I was quite amused, may not be a right word, but bewildered. Kindly see the third line. This is my fault. MGT9 is not readable. Hence, the form is defective. This is the ground.
Page
For
25.
Yes, my lord. This is part of the 206 report, my lord.
Not readable, yes.
This is the ground. And this is the basis for the police, the complaint that they've initiated.
This is one of the bases.
And my lord, I'll show you all. I'll show you all.
Section 260 violation.
260 violation saying additional director has not been made a director. And I've given a reply saying he has been made.
If their complaint is frivolous, it will be discarded by the criminal
with
court.
all due respect, I have a right
This is
to get
premature,
the,
sir.
I have a right to get the report. Criminal
You have
action.
a right in the criminal trial. You have a right to get
criminal
it. Not
action
before
is
that.
initiated without giving
It's
me
an
the
internal report. They do an investigation. They file a report. On the basis of the report, ministry forms an opinion, or whatever authority forms an opinion.
If I
Initiates the investigation.
Well, the 208 report is on the basis of the 206 inspection. And with the 206 inspection, which I was showing you at page 23 and 25, well, that's the report to which I have given a reply. Well, once I give a reply, the inspection, the report is almost like an adjudication. And could I not
reply to what?
To this, Millard. Kindly take page 33, Millard, my reply to Millard, the 206 notice. I have, Millard, addressed every issue which has been raised. There is not a single word saying that, no, your explanation is not satisfactory. I could have understood, Millard, they put me on notice. Millard, after all, it's an inspection of my books, my accounts. Every point has been, Millard, addressed. Now, once it's addressed, I would have thought, Millard, the adjudication would be, I would be a party to it. So the result of this, my lord, I don't know. I am left in the
065
dark.
is only they're seeking for the copies of the whatever your documents.
No, but the-
065 is the central government if it satisfied direct inspection of books and papers. The
Correct.
law does not contemplate any hearing on that or adjudication
no,
on
no,
that.
a response. My lord,
Response, you gave your
I-
response.
my lord,
You are not required under law to give a response. You are only required to give the documents which they
which
want.
I have given.
Which you have given.
Which I have given. Now, once I give the documents, my lord, the report thereafter, if
Even a
it
proactive
incriminates,
court cannot enter at this stage.
my lord, but the report, my lord, kindly, my lord, the report, I'll just.
Then everything will be stalled. There won't be any investigation at all, Mr. Mitra. At every stage, if the court
My lord,
interacts and says,
no,
no,
my lord,
you have to give a hearing,
lord,
you have to give a copy of
no,
this
I'm not
report,
asking for a hearing. My lord, you are right that I have to go before the criminal court and
go before the criminal court,
correct.
ask for
My
a
lord,
copy of
all
the
I'm saying is, no, the report is not disclosed there as well. Only extracts are put in their
Have you
petition.
applied, made an application before any criminal
Yes,
court
yes,
as a
yes. No,
criminal
not
proceeding?
before the criminal court, but we have applied to them.
Criminal trial, when the criminal trial commences, you will have all opportunities. Before
My
that,
lord, we have written to them, letters I have annexed, asking for it because
you
these
don't
two
have a
are-
legal right to get a copy of the report at this stage.
My lord, may I just rely on two decisions, my lord?
Decisions are coming your way. So you have to deal with those. Yes.
No, Bombay. But this is a Bombay decision.
Yes.
Sorry. 199 company cases 353.
393.
My lord,
So 353. Sorry.
353. Thank you. And my lord, just before I take you to the decisions,
yes,
my lord, the complaint which was made on the basis of which the 206 inspection or investigation was initiated has been withdrawn.
that is a different aspect altogether. Take that before the criminal forum first. That will be the first
My
point.
lord,
The genesis goes.
there's absolutely no basis that's been withdrawn.
Even
And
if the
there's a
complaint goes,
notification.
there are certain situations where even if the complaint
My lord,
goes,
may not be in this case because these are all curable. These are all curable defects. I appreciate what you are saying. My
you
lord.
have a point.
So, my lord,
Curable. But which paragraph gives?
yes,
Be
yes,
precise, Mr.
yes.
Mitra.
My lord, no, no,
Not a
I won't
detailed
take too
hearing.
much time. Kindly take paragraph 40 and 41.
I'm there. Yes. 40 and 41.
Principle is that has to be an opinion formed. That opinion may be subjective, but the existence of circumstances relevant to the inference as to the sine qua non for action must be demonstrable. It is not reasonable to hold that the clause permits the government to say that it has formed an opinion on circumstances which it thinks exist. Such existence of a circumstance is a condition fundamental to the making of the opinion. When questioned, the existence of these circumstances have to be proved at least prima facie. In that light, if one peruses the powers conferred under the 2013 Act, they are also identical. By Section 206, there is a power to conduct inspection and inquiry by Section 207. Both these powers are to be exercised by the registrar. Then the report has to be made by the registrar, and the registrar or the inspector, after inspection of the books of account or inquiry under Section 206 and other books and papers of the company under 207, shall submit a report in writing to the central government along with such documents, if any, and such report may, if necessary, include a recommendation that further investigation into the affairs of the company is necessary. For that reasons in support have to be set out. We are not concerned with the power of search and seizure of the registrar in terms of Section 209. Then
what is the ratio you're relying on here?
Yes, my lord. That is the
The
ratio.
sections have been set down, the scheme has been set down. What
And
is
my
the
lord,
ratio you're relying? There is no
kindly also, my lord, come to 42.
42 years.
Therefore, a perusal of this section would indicate that the central government must form an opinion. That opinion must be that it is necessary to investigate into the affairs of a company. The central government can act on the receipt of a report of the registrar or inspector under Section 208 or on intimation of a special resolution passed by the company that its affairs are to be investigated or in public interest. Thus, there is a discretion to order an investigation into the affairs of the company. So therefore, my lord,
there is a discussion.
Yes, my lord, so I need to know, my lord, what the report is. Discretion can't be in the air. Lordships are aware of that. a discretion has to be exercised
Have a
on
legal
material.
right to get a copy of the report at the stage of investigation, definitely.
No, now the proceedings have been initiated.
Is the pre-investigation? Yes, initiated.
Under section 200. Therefore, my lord, if
Participate there whenever.
I am, but problem is, my lord, that dual proceedings, my lord, I am not being able to answer because I don't know what is the basis. Report is the basis for the inspection under 210, and it's also, my lord, the end of 206. Report is a midway which connects 206 and 2010.
So your only ground is non-furnishing of a report to you. Not accepted.
And, my lord,
Not
the
able.
initiation of 210 under 210, my lord.
Yes. What is the harm in that? I mean, what is the discrepancy in that? What is the
The
illegality in that?
discrepancy is, my lord, once I have responded, my lord, there's a report or an inspection report, I respond.
Yes.
It's like the report is almost like an order. In this case, my lord, the report is almost like an order because I have responded. What is how has the authority dealt with that response? When I've given those documents, when I've furnished all the particulars, my lord,
Your response to 2065?
Yes.
You need not give a response at all.
No, documents. Response is in the documents which I furnished. I've furnished all those documents.
They need not what hearing on that. There is no scope of hearing at that stage.
No, I am not on. I am not on the hearing.
They ask for documents, you furnish the
Correct.
documents.
I
you
furnish
write
the
two letters
correct.
with that.
Correct.
They're not required to deal with those letters also.
No, not but the documents.
They've given. You
I have
given,
furnished
they
the
form an
documents.
opinion. They initiated.
Yes. Now they form an opinion. They file a report. And on the basis of the report, 200 is initiated. Now, how do I
reject your application?
Just one other decision.
Oh, judgment.
One other decision, Millard.
Yes. What other judgment? You also have certain judgments with you.
No, Milord. I just wanted to highlight certain pages, Milord, and the annexes since Milord.
I'll hear you there. Yes. Since I'm letting him cite the judgments, definitely. Yes.
It's a copy.
Yes. Which portion?
Yes, Millard. Kindly take, Millard, paragraph 4.
Paragraph 4, yes.
A careful perusal of the provisions relating to inspection, inquiry, and investigation of companies under section 206 to 2010 of the Companies Act 2013 indicates that the sequential steps required to be taken by the ROC must be followed before the ROC submits a report in writing to the central government for further investigation into the affairs of the company if necessary. The stage of filing a report comes only after inspection of books of accounts or conducting inquiry under 206 and 207 of the Act. Section 210 is the culmination of this batch of provisions relating to inspection, inquiry, and investigation into the affairs of the company, where the central government may investigate into the affairs of the company if it is of the opinion that it is necessary to do so, and on fulfillment of the conditions under section 210, 1A to C, to the extent of the steps taken by the respondents, including the order under section 2064, dated 4th July 2022, the summons issued thereafter, the hearing given to the petitioners, and the acceptance of the petitioner's response. This is where I am. There is little doubt that the respondents must follow the stepwise compliance of 206 to 2010 of the Act. This is exactly my case.
But your notice is not under 2064. 206 is on a different footing.
Correct.
It says it calls for explanation, for an explanation from you.
Correct.
You respond to that, and then whatever happens. Here, the notice is under 2065.
Correct.
So you are the premise is different from this case.
4 and 5, there's a very thin line. With
very
all due respect.
thick, fat. I mean, it's
4 calls for a response, 5 calls for the documents to be furnished.
Exactly.
So to answer both, to answer the queries raised.
You know the difference between documents and answer.
I appreciate, but
I know you would appreciate. That's why I'm playing on that.
No, but kindly, give me some protection to this extent,
Not at this stage. Later on, if you find out that
yes. I am only let them give a copy of the report.
Not
that I am entitled.
Not at this stage.
Criminal proceedings are initiated.
It's an internal report.
I won't be able to respond even to that proceeding. The allegations made out in that proceeding, I am entitled to know.
Yes, what do you say?
The criminal complaint is of 2020. We are in 2023.
It has been dropped already.
No, number 2, this is a notice, by which my learned friend Stein is affected. is at page 64, which is under section 217, my lord. They have asked for the time to provide the documents. We have asked by this notice, dated 30th of August 2023. Kindly see page 64, my lord. We have provided them, provide us with the documents and the from your end to our office so that we can investigate and we can file an investigation report. They, instead of this, my lord, they send a letter asking for a time, and we at threshold, my lord, we say we won't be able to provide you the copy. Thereafter, my lord, they have, my lord, kindly see the page number, my lord, 80. This is the
So this is at the stage of the investigation. The
yes,
investigation is
the
ongoing.
investigation is ongoing, my lord. And my lord, they have not provided with the documents till date, my lord. They are, my lord, they are now, my lord, harping that at the stage of 206, my lord, they have provided certain documents, my lord. But at this stage, they are bound to provide these documents, my lord, so that we can investigate and this. And my lord, like my lord, what is going on, my lord, against this group of company, my lord, which is mentioned at my lord 80, page number 80. Can you see, my lord?
No, those allegations are the merits we cannot.
There are 150 companies.
Maybe false, maybe correct.
Similar petitions, my lord, are being filed in respect of the companies where investigation are over and winding up proceeding has been, my lord, directed, and winding up proceeding are being, my lord, conducted before the NCLT. So there are a bunch of matters which are my lord, coming before your lordship, my lord, will be coming before your lordship.
No, I'll decide this on its own. Learned counsel for the petitioner contends that a report purportedly furnished by the respondent authorities under section 208 of the Companies Act 2013, thereby incriminating the petitioner on certain allegations, has not yet been furnished to the petitioners, thereby rendering the purported investigation against the petitioner a farce. First up, it is argued that although the petitioner categorically replied to a notice issued under section 206 within bracket 5 of the 2013 Act, the said substantial response was ignored by the respondent authorities and no hearing was given to the petitioners on such count. First up, next para. A precondition of an investigation within the contemplation of section 210 of the 2013 Act, it is argued, is that the principles of natural justice and the procedure delineated under the said act are to be precisely adhered to, which have not been done in the present case. First up, next para. Learned counsel for the petitioner cites two judgments on such count, which will be dealt with presently. First up, next para. Learned counsel for the respondent authorities denies the contentions of the petitioners and argues that the investigation is at the stage when under section 217 of the 2013 Act, certain interrogatories and documents have been asked for by the petitioner, by the respondents. First up, to stall the proceedings, at this belated stage, the petitioners are setting up the defense as indicated above. First up, several other similar matters are also sought to be stalled by the petitioners, it is contended. First up, next para. The first judgment cited by the petitioner is that of a division bench of the Bombay High Court in Parmeshwar Das Agarwal versus additional director within bracket investigation. First up, next para. In the said judgment, the division bench laid down the principle incorporated in the relevant provisions of the Companies Act 2013. First up, it was observed that the principle is that there has to be an opinion formed which may be subjective, but the existence of circumstances relevant to the interference as to the sine qua non for action must be demonstrable. First up, it was observed that in such light, if one peruses the powers conferred under the 2013 Act, they are also identical. First up, by section 206, there is a power to conduct inspection and inquiry by section 207, both of which have to be exercised by the registrar. First up, the court went on to observe that the central government must form an opinion which must be that it is necessary to investigate into the affairs of a company. First up, the central government can act on the receipt of a report of the registrar or inspector under section 208 or on intimation of a special resolution passed by a company that its affairs are to be investigated or in public interest, full stop. Thus, comma, there is a discretion to order an investigation into the affairs of the company, full stop. A perusal of the said judgment, comma, however, comma, does not indicate anything to support the contention of the petitioners that a copy of the report had mandatorily to be handed over to the petitioners at the stage of investigation. Full stop. Next para. The other judgment of a coordinate bench of this court dated November 18, 2022, passed in Sri Radhe Tea Plantation Private Limited and another versus ROC, comma, West Bengal and others, also deals with the provisions of sections 206, 207 and 210 of the 2013 Act. First up, the learned single judge observed that a careful perusal of the provisions relating to inspection, inquiry and investigation of the companies under section 206-210 of the 2013 Act indicates that the sequential steps required to be taken by the ROC must be followed before it submits the report in writing to the central government for further investigation into the affairs of the company if necessary. First up, the learned single judge also went on to hold that the stage of filing a report comes only after inspection of books of accounts or conducting inquiry under sections 206 and 207 of the Act. First up, the learned single judge, inter alia, observed that to the extent of the steps taken by the respondents, including the order under section 206 within bracket 4, therein was concerned, the summons issued thereafter, the hearing given to the petitioners and the acceptance of the petitioner's response, there was little doubt that the respondents must follow the stepwise compliance of sections 206-210 of the Act. Full stop. Next para. However, although the petitioners seek to argue that the said observations indicate that a hearing was required to be given to the petitioners, the learned single judge, while passing the said judgment, was considering the provisions of a notice under section 206 within bracket 4, which contemplates information or explanation to be sought from the alleged recalcitrant company and its officials. First up, next para. As opposed to subsection 4, subsection 5 of section 206 does not contemplate or envisage any explanation, which might require a hearing or an opportunity of explanation to be given to the petitioners. Subsection 5 merely envisages that the central government may, if it is satisfied that the circumstances so warrant, direct inspection of books and papers of a company by an inspector appointed by it for the purpose. Full stop. Although the petitioners might have given a response in writing to such notice, the same is not contemplated or even required under the law at all. Full stop. The only duty of the petitioners was to furnish or provide an inspection of the books of accounts of the company or class of companies on the intimation of the central government. Full stop. Hence, we cannot read into the said innocuous provision of furnishing documents or giving inspection a right of hearing to the petitioners. Full stop. In fact, if at every pre-investigation stage of inquiry, rights of hearing have to be incorporated on an overly inflated conception of odi alteram partem, no investigation would reach its logical culmination at any point of time, and it will provide a handle to companies which are subject to such inquiry stroke investigation to stall the proceedings indefinitely. First up, in the present case, the respondents have the ROC has furnished a report initiating an investigation, which is already ongoing to the stage that documents have been required to be furnished within the contemplation of Section 217 of the 2013 Act by the respondent authorities. Full stop. In the event the petitioners are to take any contention as regards non-furnishing of any report, or for that matter any other relevant document to the investigation, the appropriate stage for the same is the criminal trial, which would or has been initiated under Section 200 of the where is that provision? Sorry, that complaint page.
Yes, that's
200.
Page 52, my lord.
52. Thank you. Thank you. Section 200 of the Code of Criminal Procedure, which has already been initiated by the respondent authorities. First up, next para. However, at this stage, there is no occasion or legal right of the petitioners to insist upon furnishing of a copy of the report filed by the ROC under Section 208. Full stop. Next para. The document, along with other documents, may at best be necessary at the stage of criminal trial, when it will be open to the petitioners to ask before the appropriate judicial forum for copies or inspection of such documents to enable them to contest the case properly. Full stop. However, at this stage, there is no scope of interference with the investigation. Full stop. Accordingly, WPA 23787 of 2023 is dismissed without an order to cost. Sorry.
Grateful, my lord.
Item number 11.
Item number 11, I beg to appear on behalf of the petitioner.
Yes.
But at the very outset, I tender my apology because of the fact that the synopsis inadvertently,
Please take the microphone. Synopsis?
Inadvertently, my lord, the synopsis of a different matter has been annexed to this petition. My lord.
Anyway, what is that?
My lord, the matter is that, my lord, I am a senior citizen. My lord, I was working in CM in Coal India, wherein in the year 2014, I opted for special female voluntary retirement scheme. As a result, my son got the employment. Thereafter, my lord, for 1.5 years, I was maintained by my son. Now, all of a sudden, on and from the year 2016, this maintenance stopped. I asked her, tried to amicably settle the issue of maintenance, but it could not be. So I filed an application before the Section 125 application, which has subsequently been withdrawn, subsequently dismissed as non-prosecution. I also filed an application under Section 5, under the Maintenance Tribunal, under the maintenance of parents and senior
So
citizens.
what was dismissed? What you called?
The 125 application. My lord, an order has been passed in my favor in the year 2022. Today, I am seeking a direction upon I addressed representation to the authority saying that you kindly take steps for implementation of the order passed by the maintenance tribunal. So this is the relief which I am seeking today, my lord.
Before the same authority, that tribunal?
Before the tribunal.
It has the power to implement?
It has the power. My lord, kindly take note of. My lord, may I just hand over a copy? An order, it is supposed to pass an order under Section 9 of the Act. My lord, Section 9 will be on the left-hand side.
Yes.
And the implementation of the
Section
order,
11 is enforcement.
my lord. I have made representation. A year has passed, but till date I am being unable to enjoy the benefits of the order.
So you are wanting for that execution implementation application to be decided immediately?
Immediately.
Yes, I'll definitely write.
My lord, my prayer at page 16, I have also my lord, it starts from page 15. The representative to forthwith take.
I'll direct the application, your pending application under Section 11 of the Act, which is pending in connection with this case number, to be decided immediately, disposed of immediately.
Yes, my lord. The applications and representation, my lord, will find from page 28 onwards.
Page 30 is the
Learned counsel for the petitioner contents আচ্ছা, এটা এইভাবে শুরু করবেন।
May I file my affidavit of service?
Yes. Affidavit of service filed today be kept on record. Full stop. The facts of the case in a nutshell are that the petitioner applied for maintenance under the Maintenance and Welfare of Parents and Senior Citizens Act, 2007, and was favored with an order directing the private respondent number 5, the son of the petitioner, to pay maintenance as per the direction of the concerned tribunal. Push up, the private respondent having flouted the same, the petitioner applied under section 11 of the 2007 Act for enforcement of the said order, which application has been kept pending inordinately. Push up, upon hearing learned counsel for the parties, it transpires that the petitioner is justified in making the arguments as outlined above. Full stop. Indeed, in the event enforcement applications are kept pending indefinitely, the very purpose of granting relief to senior citizens and parents as envisaged under the statute would be frustrated. Full stop. Accordingly, WPA 23830 of 2023 is disposed of by directing the presiding respondent number 4 by directing the respondent number 4, that is the presiding officer of the Maintenance and Welfare of Parents and Senior Citizens Act Tribunal.
It will be tribunal.
Act কতটা হবে না, এটা by directing respondent number 4, the presiding officer of the Maintenance Tribunal and
SDO.
Subdivisional officer, Barakpur, to dispose of the application of the petitioner under section 11 of the 2007 Act before the said authority in connection with case number 22 of 2019 before the said tribunal as expeditiously as possible and positively dispose it of within December 22, 2023. Full stop. Next para, it is made clear that the above direction is peremptory and mandatory, and the tribunal shall act on the communication of the learned advocate for the petitioner, coupled with a server copy of this order, without insisting upon prior production of a certified copy thereof for the purpose of compliance. After line add, I'm adding a line. It is made clear that the merits of the respective contentions of the petitioner and the private respondents, however, are not being entered into at this stage. বইটা ফেরত হবে।
Item number 12.
Out of. Yes.
I'm appearing on behalf of the petitioner.
What is the matter?
I'm for the private respondent, father, and the senior citizens.
But I appear on behalf of WPS.
Yes, what is it?
My lord, this is more of a similar case in
Similar to which case?
Which your lordship has adjudicated prior before. It is that the petitioner is son of the private respondent. There was a family dispute arose between father and son. Father left the premises and directed the authority respondent to disconnect my electricity connection. All the electricity connection. Previously, I have moved one writ application and it was adjudicated in my favor, directing the authority respondent to give me fresh electricity domestic connection in my name. Now I have preferred this petition to for having fresh electricity connection for running my business in the same said premises in my name, which has been rejected. My prayer has been rejected by the authority respondent. Kindly, if your lordship comes to page
He is now praying for industrial cuts.
26. Yes, my lord. Because from page 27 is a chart which was previously handed over by the authority respondent in the previous read. It depicted.
Others connection is still there.
No, my lord. Every connection is disconnected, except which was freshly installed by the authority in adherence of the last order passed by this honorable court.
So due to this objection, they're not giving the connection.
Yes, my lord. Only ground is objection by the father.
Let us hear then. Yes.
Lordship, actually,
No, let
father-
us hear the electricity company first, then I'll come back to them.
And we kindly come to paragraph 4.
Read petition. Yes. What does it say?
Kindly see at page 4. Your petitioner further states that there are several electricity connection and meter in the said premises, mostly of which are in the name of the father, respondent number 5, and some are in the name of the separate tenants. There is one specific electricity meter in the name of the respondent number 5, which is the father, and three-phase electricity connection meter being such and such. Installation number such and such, which your petitioners used for the purpose of.
He has one other connection. He has one other
No,
connection.
there is only, according to my instruction today, my lord, there is only one commercial connection, my lord, which is in the name of the father. My lord, we cannot
This
give.
person does not have a domestic connection.
Yes, he has. Pursuant to the order of this honorable.
You said there is only one connection.
My lord, that is a commercial connection. He is now asking for a.
I'm not interested in commercial. There are how many connections in the premises in total? His father's commercial connection, his domestic connection.
Yes.
Give him a commercial connection.
My lord, the difficulty are two commercial connection in one building, my lord, we have
different persons, different their relationship is strained.
My lord, that for that, my lord, I have to take instruction, and if necessary, we have to inspect also.
My lord, kindly
The
come.
Oh, you cannot argue. now. Sorry.
The
Yes.
commercial connection, my lord, there is some difficulty. If this is feasible, my lord.
What difficulty?
My lord, my instruction is, my lord, in one build premises, my lord, two commercial connection, maybe.
Different persons, different having different capacities.
Yes.
Other son, that relationship, they have not severed. It cannot be severed in law, but it's strained. Yes, father. What do you say?
Lordship is ousted me from my house. The property is my name. He's taking.
You are not residing there,
It's because he's ousted me.
but your
And he
commercial
invite-
connection is still there.
Lordship, and also there is a trade license also in my favor. And he
Why
also-
didn't you file a civil suit against him?
Lordship, I am a poor person. My business is stopped because I'm ousted from the property.
When were you
And he's
ousted?
enjoying
When were you ousted? When were you ousted?
before 2 years. Till 2 years.
Before?
Last 2 years. I'm
Last
ousted.
2 years.
Lordship.
You never filed any
Lordship,
eviction suit.
because my business is stopped. I am at the financial condition is very bad.
That's why that is the
Or-
reason for filing a suit.
Lordship,
If you have not taken any steps, you suffer.
Lordship, I am ready to file the.
You cannot object to his getting commercial connection. How
because
can
of the
you?
fact, Lordship,
He's
this is my
residing there,
property.
admitted.
This property is mine. He is enjoying entire
That's
property.
a civil dispute to take out.
Lordship, because there is also they are not taken no objection from me because they are taken also got the trade
No,
license.
Mr. Mukherjee,
Trade
no
license.
Only thing, my lord, technically, my lord, may I
Not
assert-
technically.
my lord,
No technically.
two commercial connection in 1 minute. May I come back with
What
an
is the difficulty? Tell
inspection?
me.
My lord, my specific instruction is two commercial connection in 1 million. My lord, we have to check the.
I override your technical, unless it's technical. Actually, there's
My
any
lord,
part.
my lord will give me a week's time. Keep it
No,
next
no.
Thursday, my lord.
No.
Let us come back, my lord, with the report, my lord, whether it is feasible or not. Otherwise, I will not stand in the way.
You have to give me one solid reason, Mr. Mukherjee, today itself, why it is not feasible.
My lord,
If you can't give that reason,
my lord, please,
unnecessarily, I won't keep
my lord,
matters.
two commercial connection, my lord, in one
To
building.
what?
My lord, whether it is feasible or not, in respect of the safety and.
If there can
security.
be several commercial shops in one building,
My lord,
why
this is
can't several?
my lord, this is a dwelling house. That is the
What
difficulty.
is the difficulty? You have already given a commercial connection.
My lord, one is there. My lord, two
This is a
commercial
ridiculous
connection.
objection.
My lord, two commercial connection,
No.
my lord.
My lord.
Counsel for the petitioner submits that the petitioner has a strained relationship with his father, the private respondent. It is further submitted that previously, pursuant to an order of court, the petitioner was able to get a domestic connection at the premises and now seeks a commercial connection there. It is also submitted that the father of the petitioner has already left the premises and there cannot be any impediment to give a connection to the petitioner on the basis of the objection of his father, which is the sole reason cited by the electricity distribution licensee. Next para, learned counsel for the private respondent contends that the private respondent has been ousted by his son, the petitioner, illegally from the premises, despite having a trade license and a commercial connection at the premises, for which the private respondent has objected. Next para, learned counsel for the WBSCDCL submits that he requires further instruction and contends that it is not possible technically to give two commercial connections at the same premises. Full stop. Next para. The court does not, however, find any reason to give further time to the WBSCDCL to take instructions, since not a single technical reason has been given why two commercial connections cannot be given to the same premises. Full stop. On the same logic that one commercial connection has already been given to the private respondent at the self same premises, there is nothing to prevent the WPACTCL to give another similar connection to the petitioner whose relationship is admittedly strained with the consumer of the existing commercial connection. Full stop. Insofar as giving several connections to the same premises is concerned, there cannot be any logical impediment there as well, since already the WBACTCL admits that that at least one commercial connection to the private respondent and one domestic connection to the petitioner are functioning and operating at the same premises itself. Full stop. Thus, the the flimsy pretext on which the electricity connection is being refused cannot be entertained. Accordingly, WPA 23954 of 2023 is allowed, directing the WBSCTCL to immediately process the application for commercial connection of the petitioner and raise a quotation to that effect within a week from date. Full stop. Upon compliance of all formalities by the petitioner, including the payment of the quotation price, the WBSCTCL shall, within a week from compliance of such formalities, give such commercial connection to the petitioner at the premises in question. Full stop. If any obstruction is raised by the private respondent and or his men and agents, it will be open to the to the WBSCTCL authorities to approach the concerned local police station for adequate police assistance, which shall be given by the officer in charge, inspector in charge of the local police station, by acting on a server copy of this order at the cost of the petitioner, if necessary, by breaking open any padlock or other hindrance if put up to prevent the WBSCTCL personnel to give such connection to the petitioners. Full stop. Next para. It is made clear that the civil disputes between the petitioner and the private respondents have not been entered into on merits here, and it will be open to the private respondent as well as the petitioner to canvass and agitate the such disputes between themselves before a competent forum court. No orders to cause urgency.
My lord, just one interest. I have sought for industrial connection, not commercial.
যেখানে কমার্শিয়াল বলেছি সেখানে ইন্ডাস্ট্রিয়াল করে দেবো। ইউ অলসো এনজয় কমার্শিয়াল কানেকশন অর ইন্ডাস্ট্রিয়াল?
Industrial.
কমার্শিয়াল যেখানে যেখানে বলছি কন্ট্রোল ফাইন্ড করে কমার্শিয়াল গুলো ইন্ডাস্ট্রিয়াল করে।
My lord, may I hand over every service? I'm grateful.
I'll come back in 10 minutes for the next one.
Item number 13.
Milord, I am for the petitioner, my lord.
Not this week, Milord.
No.
I am for
No
the
time.
petitioner, my lord.
Mr. Avinash Kankani is
No,
appearing
no,
on
no.
behalf of
No,
Bar
you're there.
Council of India.
No time, sorry, no.
Milord, he's Milord suffering.
Upgraded matters, no time. Yes.
Milord, he's
I am for the
suffering
petitioner, my lord.
Suffering from what?
viral infection, Milord. He is suffering, Milord, from viral infection, Milord. Medical certificate is also.
You have brought the medical certificate.
Yes,
Hey,
my-
refuse, I'll
For this,
refuse with or without the certificate.
Milord, he is on.
Where will
on
next
his
week then?
my
On
lord,
the prayer of the respondents, the matter is adjourned till next week and shall retain its heading.
my lord, affidavit
Affidavit of service.
service.
Service file to be kept on record.
Item number 14.
Yes, who is for the petitioner?
But I am appearing for the petitioner, my lord.
Yeah, for the
This is,
10.
my lord, my affidavit of service.
all have been served?
My lord, we have served everybody.
Yes, what is it?
My lord, the petitioner is a member of scheduled caste community.
Hmm.
And he was granted his scheduled caste certificate in 2011. His certificate, my lord, is annexed at page number 32 of my petition.
Hmm.
My lord, in 2021, a member of my locality abused me, and hence I lodged a FIR against him, and several sections of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 were incorporated. Thereafter, my lord, in the charge sheet, those sections were removed, and only the IPC sections were given, and thereafter I filed a Narazi petition. Accordingly, an order was passed by jurisdictional court, and a supplementary charge sheet was directed to be filed. In supplementary charge sheet, again, those sections under the Prevention of Atrocity Acts were incorporated. And thereafter, my lord, this respondent number 10 staged another association of scheduled caste to file a complaint against me about the validity of my caste certificate. A complaint against my caste certificate was filed.
No, your complaint, respondent 10 was the accused in your complaint.
My lord.
Very well. So he did what?
My lord, he staged respondent number 9 to file a complaint against me, against the validity of my caste certificate.
Why did you say he staged?
My lord, because there is a nexus, we have pleaded that.
All right, very yes.
My lord, because
caste certificate was challenged.
If my caste certificate goes, then automatically those sections will go and he'll go scot-free. Thereafter, my lord, since my caste certificate was challenged, I was and a complaint was filed against the before the SDO. The complaint, my lord, is appearing at page number 54 of my application.
Right.
Pursuant to the said complaint, SDO called for a hearing, directed me to appear before him for a hearing. I appeared, my lord, and I submitted all my certificates before the SDO. He was satisfied, and that complaint was not taken any further. My lord, thereafter, in 2023, I came to know that the same respondent number 9 has also filed a complaint against my caste certificate.
So that complaint was dropped
My lord,
formally.
there was no further proceedings. According to my knowledge, my lord, after that hearing, nothing further happened in that complaint by SDO.
Then what happened? Another complaint?
My lord, another complaint before the National Commission of Scheduled Caste was filed by respondent number 9. And National Commission of Scheduled Caste, my lord,
First complaint was before whom?
Before the SDO, who is the authority to cancel my caste certificate under the Act.
Right.
And the second complaint was filed before the National Commission of Scheduled Caste, and my lord, they held a hearing or minutes come hearing wherein I was not served any notice and I was not present. In that minutes of hearing, my lord, of 21st April, which is appearing at page number 56, the
You
National
have served properly the National Commission?
My lord,
Very.
I think they are represented. No. My lord, we have served, my lord, service is there.
Well, yes. You have checked up good service on them.
My lord. Not only one, respondent number 9 service has been returned as addressee not found. Apart from that, everybody service has been delivered on 9th of October 2023.
Right.
My lord, then in National Commission for Scheduled Caste, my representation, the representation of respondent number 9 was taken up for consideration. I was not given any notice of such hearing, and the National Commission summoned the SDO or directed SDO to file certain reports. In the reports of SDO, my lord, the SDO clearly mentioned that several witnesses were questioned, and they all testified that I am the member of scheduled caste community. That report was set aside by the National Commission, saying that those witnesses on a subsequent dates, they have gone back on their statement, and they have themselves verified that I am a member of general caste and not a scheduled caste community. My lord, no notice of such hearing was given to me. In that hearing, my lord, in that minutes, my lord, the National Commission directed the SDO to set aside and cancel my certificate within 7 days, failing which National Commission will take action against the SDO. And solely relying upon that recommendation of National Commission, on 4th of May 2023, the SDO cancelled my caste certificate without any other reason apart from the
Please
reason.
show me first the direction of the National Commission and then the impugn order.
Kindly, my lord, comes to page number 56.
Yes.
My lord, the minutes of hearing may I place, my lord?
Right. Please.
The representation dated 7th-9-2022 from Sri Swapan Kumar Das, Secretary, Paschim Banga Bauri Samaj Unnayan Samiti, was received regarding request for proper inquiry of fake caste certificate. My lord, earlier, my lord, I submitted that another complaint was filed before the SDO by this Swapan Kumar, respondent number 9, and a hearing was given to me pursuant to that complaint. That complaint, my lord, was of 2021.
SDO gave you a hearing, but before this, this commission did not give you
I
any
was
hearing.
not present, my lord. See the members present.
Any notice was given to you?
No, my lord. I have not received any notice.
Anyway.
My lord, that complaint was of 2021, pursuant to which I received a notice of hearing by from SDO on 23rd May 2022. And since that complaint did not fructify, another representation of 7th September 2022 was filed by Respondent number 9 directly.
Have you got a copy of the SC/ST Act, please?
My lord.
I mean, have you got an extra copy?
My lord, I have.
Otherwise, তুমি একটা আনিয়ে নাও। SC/ST Act একটা আনিয়ে নিতে পারো।
My lord, I have a copy.
Thank you. Yes. Under which provision was this exercise done?
My lord, the National Commission, according to me, my lord, has no jurisdiction whatsoever to question the validity of my caste certificate. Only a scrutiny committee formed under the West Bengal.
Yes, they have to file a report.
1994 Act, my lord, they have a power to challenge or look into the validity of my caste certificate. My lord, this exercise, my lord, was done without any jurisdiction as per me.
Well.
My lord, kindly comes to page number 56 again. So, my lord, this is the second complaint of respondent number 9 after his first complaint was not taken any further. And representation dated 7th September 2022 from Sri Swapan Kumar Das, Secretary, Paschim Banga Bauri Samaj Unnayan Samiti was filed, received regarding request for proper inquiry of fake caste certificate issued by SDO of last 6 months. My lord, this last 6 months, my certificate, my lord, was issued in 2011. So, my lord, this representation was only with regard to the certificates issued in last 6 months, means not from January 2022 or March 2022 to September 2022. Then, my lord, in the second paragraph, the petitioner further stated that the action taken report submitted by the SDO Asansol Sodor, bearing memo number such and such, are improper, vague, meritless, and made with an oblique motive, in which point number 5A to 5D, wherein the documents submitted by Sri Amardeep Kumar and Sri Deepak Kumar Shah. My lord, I am Amardeep Kumar and my father is Deepak Kumar Shah. That is caste certificate issued by the member, mayor in council, Asansol Municipal Corporation, resident, and caste certificate issued by councillor ward number 19 are void ab initio, as the same issuing authority through letter dated 2nd March, 21st March and 5th February stated that personally they don't know about the caste or category of Sri Amardeep Kumar and Deepak Kumar. This was taken into consideration. Then the next line is very important. After that, they declared to the best of their knowledge the said persons belong to general category. Then for the 5E, wherein it is mentioned that field inquiry has been conducted by the BCW inspector, backward class inspector, it is stated that 5 witnesses confirm that both of them belong to SC community. A field inquiry was done wherein 5 witnesses confirmed about my identity.
The
that
next
was,
line says those same witnesses declared.
It is pertinent to mention that same witnesses declared in writing that Sri Amardeep Kumar, Deepak Kumar Shah belongs to general category, and statements given by BCW inspector regarding the caste certificate Sri Amardeep Kumar is Shah, not Shah, and belongs to general category. So there is a contradictory report. Everything is happening behind my back. Thereafter, my lord, on further reading, the petitioner further stated that till date, DM Paschim Bardhaman and SDO Asansol Sodor Paschim Bardhaman have not submitted any documentary evidence of the issuance of the caste certificate of Sri Amardeep Kumar bearing caste certificate number such and such, and Sri Deepak Kumar bearing caste certificate number such and such. My date of my caste certificate is written there, 2011, and the complaint was only with regard to caste certificates issued last 6 months. The petitioner and above mentioned respondents appeared before the commission on 21st April 2023, and it was briefed by the respondent that investigation of 17 candidate was taken up, after which certificate of Umesh Kumar was recommended. This is not related to me. In view of the above, the commission observed that Sri Amardeep Kumar bearing certificate number such and such and Sri Deepak Kumar Shah bearing certificate number such and such, as per the documentary evidence, the SC certificates are found fake. What documentary evidence was considered is not there. The commission strongly recommends the district magistrate Paschim Bardhaman to cancel the fake certificate issued to Sri Amardeep Kumar and Deepak Kumar immediately within 7 days and submit the report to this commission. Please take note that then the tone is of threat, that in case of district administration fails to implement the recommendation within the stipulated time, this commission is at liberty to exercise the power conferred on it under Article 338 of the Constitution of India and files atrocities case against the against the concerned authority, including Section 4 of the Scheduled Caste and Scheduled Tribe Atrocities Acts as amended from time to time. Furthermore, the next paragraph is also important. The commission recommends remaining 17 alleged certificate for 17 alleged fake certificates. A caste scrutiny committee of 7 to 9 members district level needs to be constituted. Then means they are admitting that a caste scrutiny committee in West Bengal is not present. Hence they have usurped the power of caste scrutiny committee, although the statute does not provide any power of caste scrutiny committee to be transferred to the National Commission of Scheduled Caste. This is also a recommendation to constitute a caste scrutiny committee. Based on this minutes of 21st April, which was signed on 1st of May 2023 by the Vice Chairman of the National Commission, the certificate issuing authority, that is the SDO,
give me the page.
4th of May, page number 73 to 75, it's there. The order is a bit
very illegible.
Then thereafter I have
there are typed,
given a typed copy.
Right. Have you checked up personally the typed copy?
I have typed it personally.
Right. Thank you so much. Yes.
We also have a copy, no? But we also have a copy which is a bit legible.
No, this is sufficient. The typed copy is sufficiently legible.
On 4th of May, SDO says, receive minutes of hearing dated 1st May 2023 with a file number such and such from National Commission for Scheduled Caste issued by Sri Arun Haldar, Honorable Vice Chairman of National Commission of Scheduled Caste, duly forwarded by the Section Officer of National Commission for Scheduled Caste and communicated by POCAM DW.
That has been just
communicated.
Yes.
On perusal of the above minutes of hearing, it reveals that the observation issued by the National Commission of Scheduled Caste on the basis
yes,
of the...
I've seen. What is your full name, please?
Mr. Rahul Kumar Singh.
Mr. Singh, I've looked into it. Yes.
So
the entire thing, it has been set out, and due to that recommendation, sole ground
was the recommendation of the National Commission, and no further hearing or
you have challenged this here.
I have challenged this. I have challenged the minutes, and I have challenged this communication as well.
What could be the best provision for the National Commission to interfere here? You make arguments for them. What could be their best argument?
National Commission, according to their power, National Commission has the power to inquire into specific complaint with respect to deprivation of rights and safeguard of scheduled caste.
Please give me the section once.
That is rules framed under Article 338 of the Constitution of India.
Right.
And that says that National Commission has the power to inquire specific complaints.
No, but under this act, there is nothing to.
No, Milord. This is a state act. National Commission has no power under this act.
Right. So should we hear them now?
The power to cancel under the act is only with the issuing authority, and issuing authority also has to act on the recommendation of the scrutiny committee,
which is section
9 of the
Act
1994 Act. West Bengal Scheduled Caste and Scheduled Tribes Identification Act 1994, and there is also a rules which lays in detail what will be the procedure once such complaint is received. I am to be given around at least 3 hearings before my certificate can be cancelled. And here I was not heard even once. I was not even aware of this proceeding which was happening behind my back.
What is the rule?
Rule 3 of the West Bengal Scheduled Caste and Scheduled Tribe Identification Rules 1995.
Right. Yes.
My place rules.
Yeah, rule 3 years. Yes, right. It's there. So nothing regarding the National Commission at all.
Milord, no, Milord. Milord, so in my humble submission, Milord, National Commission acted wholly without jurisdiction, and no hearing was given to me. My principle of national justice was violated, and Milord, everything was done to circumvent my FIR. And Milord, subsequently, what
Your
has
FIR regarding that complaint.
that person, and subsequently, after my cancellation of my caste certificate, another FIR has been lodged against me, wherein I have been implicated in under the sections of Prevention of Atrocity Act 1989.
For fake.
Not, not for fake. But a third person has accused me of doing some acts which are punishable under the.
The third person is a scheduled caste person, and
That-
you are a general category. So
Now, Milord, I am a general category, so I can be implicated in that. So, Milord, that was my urgency to come before your lordship, because I can be arrested now after illegal cancellation of my certificate.
very well. Yes.
I appeal for the respondent number 10. That the main answer is for the
Then you are the complainant.
No, I am not the complainant. Respondent number 9 is the complainant. But I am the accused, Milord, in which case against whom, Milord, the Atrocities Act has been leveled. Oh, we are appealing for the 9 and 10. Yes, Milord, I am appealing for the 9 and 10. Yes, 9. Respondent number 9 also lost the complaint, Milord, against the petitioner before your lordship, Milord, before the National Commission.
You are appealing for 9 and 10. That therefore there is a presupposition that he is correct. So you are motivated by 10.
Milord,
You
so
are
far now
represented by the same council.
Yes. Milord, kindly see, Milord. Now today, Milord, so far as this cancellation is concerned, the
Yes.
cancellation was done by the SDU.
Cancellation was done by the SDO at the behest of the National Commission.
But
Only on that ground.
SDO has applied his independent mind, Milord.
Show me that. Show me the application of mind first, then independent. Independence I don't find at all, not even mind.
But, so
It's
far as-
entirely the mind of the National Commission.
Can you see, Milord, third paragraph? Page 74, third paragraph.
Yes.
Milord, it says, Milord,
Read it out for me. Third paragraph from the.
Arun Haldar, Honorable Vice Chairman, National Commissions for the Scheduled Caste, has stated in his observations such and such.
Then quotation starts,
the
quotation ends the next page.
The quotation starts, ends the next page.
So that is the mind of the National Commission.
Now, Milord, hence, in his recommendation, the Honorable Chairman, National Commissions for the Scheduled Caste clearly is directed to cancel the certificate issued to the Sri Amardeep Kumar and Devak Kumar Shah within 7 days. Otherwise, the Commission will file an atrocities case against the concerned authority, including Section 4 of the Southern Search. Therefore, I, the subdivisional officer, Asansol Caste Certificate.
Therefore is the reason, only reason.
Therefore is the
That is the independence in the application of.
Now, the issue caste certificate issuing authority on the basis of the recommendation made by the National Commission cancel this. Now, can you see, the my learned friend is saying that no notice of hearing was given. Can you text page 56 once?
56, yes.
Oh, sorry. No, page 55.
Right.
But this is the notice of hearing was given on 23rd of May 2022. This says hearing of notice, whereas the civil caste certificate bearing number such and such, subcaste number such and such, Nunia was issued by this office, resident of such and such. So a complaint has been submitted. You have
This is the SDO notice on the previous occasion.
This is the SDO's notice. On the basis of this notice, subsequent order was passed. This is the notice issued on can you see on 23rd of May 2022, and this order was passed by the SDO on 4th of May 2023.
So where is the caste scrutiny committee report?
Now, so far as caste scrutiny committee is concerned, that's why I requested your lordship, Mr. Basumoli is appearing for the SDO. Now, perhaps he is appearing for the
As usual.
As usual. Now, kindly see the power. So
you also admit as usual.
As usual, he appears for the state, na?
No, not that.
Now, kindly see, let us see the relevant rules. Where the power of the National Commission is where the National Commission
that is very important.
Yes. Can you text this, Milord?
Can you give a copy to your learned friend also?
But I have
book.
Yes.
In this book, we'll get. Can you see, Milord, the rules of procedure of the National Commission for Scheduled Castes? Now, Milord, your lordship, state way, Milord, comes to Milord. That is, Milord, Rule 2.7. May I place it?
Yes,
The
please. Yes.
chairperson may call for any records on any matter
which he or she considers important and may take decisions on it himself or herself, or if necessary, place it at the meeting of the commission. Now, my lord, your next, my lord, I will be referring to, my lord, chapter 3, my lord, rule 7. Investigation and inquiry by the commission. As you also got in. It is not.
Yes, got it.
Investigation and inquiry by the commission. The commission shall function by holding sitting and the meetings at any place within the country, and also through its offices at the headquarters and in the state offices. The members of the commissions, including the chairpersons and vice chairpersons, shall function in accordance with the procedure prescribed under these rules. Next, 7.1. The commission may adopt any or more of the following method of investigations for inquiring into the matters falling within its authority. The commission directly by an investigation team constituted by the headquarters commission through its state offices, state agencies, or by institution of the department funded by the central government or by statutory bodies. Next, 7.21. 7.2A1, I'm just pressing. The commission may hold sitting for investigation into the offences relating to the safeguard, protection, welfare, and development of the scheduled caste for the inquiry into the specific complaint for which the commission decided to make investigations or inquiry directly. Such sittings may be held either at the headquarters of the commissions or at any other place within the country. So, my lord, 7.21. Power has been given under 7.21. The commission may conduct inquiry. The power has been given. It is not that the commission has conducted inquiry without having any jurisdiction. Now, 7.2A2, it says the sittings of the commission would be held after giving the due notice to the parties intended to be heard and due publicity of notices to the general public. Care should be taken to see the members of the scheduled castes who are affected in the matter under investigation or inquiry are given due information through the notice or publicity. Next, my lord, 7.2A3. When a decision for direct investigation is taken, an officer not below the rank of investigations or research officers or section officers along with the necessary maybe your logical institute. So, my lord, what I am saying, submitting my lord, it is not the case, my lord, the commission is not having any power. Commission is having the power, and the power is vested to the commission in view of Article 338 of the Constitution of India. Now, let us see, my lord, the Constitution of India once.
Yes.
Article 338.
Constitution. Was it 338?
338.
Right.
Lord, your lordship, Lord, kindly comes to Article 338, Clause 5B. I just placing, Lord, one Clause 5B.
Yes.
Your lordship, Lord, Clause 5 starts, Lord, it is a duty of the commission. Then I'm placing B. To inquire into the specific complaint with respect to the deprivation of the right and safeguard of the scheduled castes. So, Lord, in my responsible submission, Lord, this covers the entire thing. If anybody lodged a complaint against anybody that he has been claiming, Lord, to be a scheduled caste and taking benefits, depriving other scheduled caste communities, members of the other scheduled caste communities, then it comes under the, Lord, in my responsible submission, Article 338, Clause 5 and B. And in read with, Lord, this 7.2A1, Lord, the commission has the power, Lord, to make an inquiry, Lord, on the basis of the complaint lodged by any individual stating, Lord, the deprivation of the benefits to the scheduled caste or scheduled tribe communities have been made at the instance of somebody. Now, Lord, kindly let us see some factual aspect of the matter. Kindly see, Lord, the caste certificate.
I won't go into that article.
Kindly, two things I will show. Here, Lord, the caste certificate, so far as son is concerned, the caste certificate issued to him earlier. Father caste certificate issued subsequently. Well, this is a factor. Well, caste certificate can be issued. Well, kindly see. Well, there are certain procedures laid down in the Identification Act itself and the rules.
Certificate of the father was issued subsequent to the son.
Yes. Scassi, San, Sa-
Mr. Tiwari, issuance of the caste certificate does not convert the caste on that person.
Yes.
It's the other way around.
Yes.
Suppose
absolutely.
I am of a particular community or a caste, my father is also a person of that community or caste. If I get the caste certificate first, in that event also I remain of the same caste and my father remains of the same caste.
No problem.
Conferment of the caste certificate does not is not equivalent to conferment of the caste. I had my caste, my father had my caste.
Yes,
Maybe
absolutely.
the certificate was issued later.
Certificate was issued.
That does not matter.
Milord, before issuing the certificates, there are certain procedures. Procedure is not the procedures has been prescribed in the act itself. Milord, kindly see, Milord, kindly take this.
No, we
act.
cannot go into that.
But these
Because
things,
we are
Milord,
on jurisdiction.
number one jurisdiction. Second
I am
is
palpably of the opinion that you did not, the commission, national commission did not have jurisdiction. So if I hold so, unless you are able to satisfy me otherwise, if I hold so, then this question I cannot
Milord,
enter.
so far as commission jurisdiction is concerned, Milord, I submitted before your
Article
Lordship,
338
Article
is there,
338,
the rule is there.
and Milord, this rules of procedures.
Yes, yes, rules are also there.
These are the two things, Milord. I cannot improve my case, Milord. These are the things that stated in the act.
No, very well argued, Mr. Theory,
Yes.
but
Now, Milord, so far as power exercised by the commission, Milord, commission has the power in my responsibility, Milord, in view of these two articles and the rules framed by the commission itself. Milord, these are the constitutional body, Milord.
Rules actually reflect the powers in
Yes,
the,
absolutely. Rules actually reflects the power of
Right,
Milord, which has been provided in Article 338.
Same language.
Same language. And Milord, so far as Milord, violation of principle of natural justice is concerned, Milord, your Lordship, Milord, counsel is not an unruly horse. Milord, suppose, Milord, a person is obtained a certificate by producing a fake documents. Milord, can he improve his case, Milord? Even a right of hearing is given to him. Well, I am asking the question to myself. Today, Milord, the 5 person has intimated that he is belong to scheduled caste community or scheduled type community. These 5 persons who had made the inquiry intimated that the commission, no, they do not belong to the scheduled caste community. They belong to general community. Now, Milord, if
Mr. Tiwari, tomorrow if I cancel your, if I am the bar council, I cancel your certificate of practice, and I say you produce a fake certificate, do you have the right to have a right of hearing?
Milord, so far as right of hearing,
You were saying he is fake, and you were saying he does not have a right to defend himself.
No.
This is bordering on ridiculous. Why bordering on?
So
It's
far as-
beyond ridiculous.
So far as Milord, if I obtain my LLB certificate or
By fraud, I am
by
saying that
fraud.
you have obtained by fraud.
Fraud.
And I am saying because you have obtained by it's circular, not even circular logic.
Your
It's
Lordship is saying,
peculiar logic.
your Lordship is saying I have obtained it by fraud.
I say that you
Yes.
have obtained by fraud, and
Fraud.
I say, how can you have a right of hearing? Can it do that?
No, no, sir.
National Commission itself is saying that you have obtained a fake
National
certificate.
Commission is saying, Milord,
And
on the-
National Commission is saying because you have obtained a fake certificate, I feel
National
so, you
Commission
don't
is-
have a right of hearing.
National Commission is saying, Milord, on the basis of the person whom, Milord, he has given a certificate. Milord, what
In an
happened?
absolutely shady proceeding, those persons who have given them written certificates, you say National Commission says no. Those very persons have said that they don't belong to this caste. And that is the only premise. Without them having any opportunity to hear those people say so or to controvert them, nothing.
Milord, so far
What
as
is
that
happening, Mr. Tiwari?
so far as that part is concerned, Milord, your Lordship, Milord, kindly consider, Milord, kindly ask Milord, Mr. Basumoli, Milord, to produce certain documents.
He is not for the National Commission.
He is not for the national. He is, Milord, the ultimate.
Complied. He'll say I'll comply with the National Commission.
Ultimately, Milord, he has, Milord, cancelled the caste certificate. National on the whatever may be the direction, Milord, direction has been given by the National Commission. He could have said that these are the genuine caste certificate, Milord, obtained under after complying all formalities.
He could not.
He could not. He
Instead of-
cancelled it.
Instead of him having the ignominy of saying so, I'll say that.
Now, Milord, kindly consider two things, Milord. One is, Milord, your Lordship, whenever your Lordship only on the point of jurisdiction, Milord, I submitted, Milord, so far as jurisdiction point, Milord, I have nothing to say. But so far as factual aspect of the matter is concerned, Milord, your Lordship, kindly visualize the situation. Today, X has obtained the certificate, Milord, by committing fraud on somebody, some authorities. Now, Milord, whether that X should be given an opportunity of hearing or not. Number one. Second point, Milord, whether a person who himself, Milord, committed fraud in obtaining, Milord, certificate is liable to get or is entitled to get any opportunity of hearing.
He's the only person who should be given a right of hearing.
Milord, if it is
The only person who has to be
in my experience, if it is on prima facie, Milord, if it is found that he has obtained the certificate by committing fraud, Milord, in my response, that it does not deserve to get, Milord, any right of hearing. Milord, if fraudulent activities, Milord, cannot be ratified by any court of law. Milord, if kindly consider, Milord, so far as, Milord, this part is concerned, Milord, if somebody, Milord, gives some related, so far as while issuing the, Milord, caste certificate, number one, there is a referee number one. Referee number two, they are supposed to submit their report. In their report, my lord, they must disclose that these are the relatives, they belong to scheduled caste community, and on the basis of that report, the authority concerned will examine it, field verification will be made, and thereafter, my lord, certificate will be issued. My lord, these are the process. Whether these processes were at all, my lord, conducted by the appropriate authority or not, that is to be looked into, my lord.
Same allegation.
And my lord, what is the basis?
Yes.
Today, my lord, your lordship, my lord, kindly consider, my lord, what is the basis? Today, I have been entangled in a criminal case, alleging atrocity on the Scheduled Caste and Scheduled Tribe Act.
Yes.
Now, my lord, it is not the case, my lord, it is not a counter case, counter class case. My lord, it has been inquired, and ultimately, on the basis of the report submitted by an authority, my lord, this has been done. So these are my submissions.
Learned counsel for the petitioner contends that the petitioner, being a member of a scheduled caste, had obtained validly a scheduled caste certificate in the year 2011. Take your seats, Mr. In the year 2011. Push up. However, much subsequently, the petitioner made certain allegations and lodged complaints against respondent number 10 for having violated the provisions of the West Bengal Scheduled Caste and Scheduled Tribes The Prevention of Atrocities Act is different.
No, West Bengal Scheduled Caste, Scheduled Tribes, Prevention of Atrocities Act.
Under the West Bengal Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, push up.
Not West Bengal.
It's not West Bengal.
West Bengal about it. Under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, push up next para. Subsequently, a proceeding was initiated, which instigated the respondent number 10 to set up respondent number 9, who represents a body apparently speaking about the cause of scheduled castes, to lodge a complaint against the petitioner, seeking a cancellation of the scheduled caste certificate given to the petitioner. A hearing was given by the concerned SDO to the parties, including the petitioner, and before the SDO, several documents and other materials were produced, which led the SDO to come to the conclusion that the scheduled caste certificate was issued validly to the petitioner. However, the proceeding was not advanced further. Much subsequently thereafter, apparently on the instigation of the respondent number 9, the National Commission for Scheduled Castes had, without giving a prior notice of hearing to the petitioner or any opportunity to the petitioner to make out his defense, by a minutes of hearing annexed to the writ petition, directed the concerned authorities of the state to cancel the scheduled caste certificate of the petitioner, in blind deference thereto, without applying its independent mind, the concerned SDO cancelled the scheduled caste certificate of the petitioner, prompting the petitioner to prefer the instant writ petition. Learned counsel submits that the National Commission does not have any authority under the Constitution or any law to usurp the powers of the concerned SDO and the state authorities, who are responsible for undertaking inquiries regarding cancellation of caste certificates. Next para, it is argued that even the recommendation of the National Commission admits that there has been no formation of a valid caste scrutiny committee at the district level, which was the relevant authority on the basis of whose report a cancellation of caste certificate is to be effected in the state. Next para, that apart, it is argued that even in the minutes of hearing of the National Commission dated May 1, 2023, it is categorically indicated that the same was initiated on a representation dated September 7, 2022, regarding a request for proper inquiry of fake caste certificate issued by the concerned SDO, Asansol, for the last 6 months. However, the petitioner's caste certificate was issued as long back as in the year 2011 and as such could not have fallen within the ambit of the inquiry at all. Full stop. Next para. Learned Counsel places reliance on the relevant provisions of the rules of the concerned rules and the Act of 1994, that is the West Bengal Scheduled Castes and Scheduled Tribes within bracket identification bracket close Act, 1994, to argue that the procedure as contemplated therein has no role for the National Commission at all. Full stop. Next para. Moreover, despite a previous complaint having not succeeded, the SDO acted dehorsed the law in reversing its previous stand and cancelling the certificate of the petitioner solely on the ground of the purported recommendation by the national body, which did not have jurisdiction or authority to so recommend. For some next para, despite service, none appears for the National Commission for Scheduled Castes, although the respondent numbers 9 and 10 and the state authorities are substantially represented through council. Full stop. Learned Counsel for the respondent numbers 9 and 10 argues that on facts, the petitioner palpably obtained a fake scheduled caste certificate and a person committing fraud on the authorities does not have a locus standi to have a further hearing on such count. Full stop. Next para. Learned Counsel places reliance on the provisions of Article 338, in particular sub-article within bracket 5 within bracket small b thereof, to argue that the National Commission has sufficient authority and power to adjudicate individual cases of complaints as well. Full stop. On such count, Learned Counsel also places reliance on the provisions of the rules of procedure of the National Commission for Scheduled Castes, published in the Gazette of India, extraordinary, dated June 15, 2009. Full stop. Next para. Certain peculiar features of the present case strikes at the very root of the matter. Full stop. Next para. The only authority which is capable of cancelling a caste certificate duly issued to a party, to a person, is the authority as stipulated under the 1994 Act. Full stop. Under Section 9 of the said Act, if the certificate issuing authority is satisfied that a certificate under the Act has been obtained by any person by furnishing any false information or by misrepresenting any fact or by suppressing any material information or by producing any document which is an act of forgery, it may cancel, impound or revoke such certificate in such manner as may be prescribed. Full stop. Next para. The corresponding rules of 1995, in particular Rule 3 thereof, provides the detailed procedure for so cancelling, impounding or revoking a certificate. Full stop. It is provided inter alia in the said rule that whenever it appears to a certificate issuing authority on complaints by any person or suo motu that a person in whose favor a scheduled caste or scheduled tribe certificate has been issued does not belong to such caste or tribe, it shall hold a preliminary inquiry, italics preliminary inquiry by itself or by the officers as stipulated therein, and shall prima facie satisfy itself as to the truth or otherwise of the complaints as aforesaid, record the reasons of its satisfaction as to the truth or otherwise of the complaints, and if necessary, start proceedings for cancellation, start proceedings for cancellation, impounding, as etc. as the case may be. Full stop. While doing so, the certificate issuing authority shall, as per sub rule 2 of rule 3, comma, by written notice, comma, ask the person holding the certificate to deposit the same in original in its office, and when a certificate has been so deposited, a receipt in favor of the person depositing the certificate shall be issued. Full stop. Thereafter, the authority has to issue a notice to the holder to show cause within 15 days or within a period of shorter duration as it may think fit as to why the certificate shall not be cancelled, comma, impounded or revoked on the grounds stated in the notice. Full stop. A detailed modality of hearing is thus given thereunder, which has been palpably flouted in the present case. Full stop. Next para. The National Commission, comma, on some unknown authority which has been imposed by itself on itself, comma, the issued a recommendation by way of a directive on the SDO to cancel the certificate of the petitioner. Full stop. Let us now explore the provisions of Article 338 of the Constitution, comma, which is the genesis of the power of the National Commission. Full stop. The relevant provision, comma, as rightly pointed out by learned counsel for respondent numbers 9 and 10, is sub-article 5 of the same. Full stop. It says that it shall be the duty of the commission, comma, inter alia, comma, to inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled castes. Full stop. A bare perusal of the said sub-article discloses that the scope of operation and functioning of the National Commission is on a nationwide level and of a much general basis than individual complaints against individual persons. Full stop. Next para. For example, comma, clause A of Article 338 within bracket 5 envisages that the commission may investigate and monitor all matters relating to safeguards provided for the scheduled castes under the constitution or under any law and to evaluate the working of such safeguards. Full stop. Clause C speaks about participation and advice on the planning process of socio-economic development of the scheduled castes and to evaluate the progress of their development under the union and any state. Full stop. Clause small d speaks about presentation to the president annually and at other times as the commission deems fit, comma, reports upon the working of those safeguards. Full stop. Clause E speaks about recommendations. Full stop. The recommendations are restricted to making in the reports as dealt with earlier, recommendations as to the measures that should be taken by the union or any state for the effective implementation of the safeguards and other measures for protection, comma, welfare and socio-economic development of the scheduled castes as a whole. Full stop. Next para. Seen in such setting, comma, clause B has to be read in context and proper perspective. Full stop. Clause small b provides that the National Commission may inquire into specific complaints. Full stop. However, comma, the term within single inverted specific need not necessarily refer to specific individuals on allegations of such individuals having flouted the provisions of the law on any premise, but speak about deprivation of rights and safeguards of the scheduled castes as a whole. Full stop. Next para. Hence, comma, on a composite reading on the statute which governs the issuance of scheduled caste certificates in the state of West Bengal, that is the 1994 Act and Article 338 as a whole, comma, there is no need to confuse the wide powers and recommendatory provisions regarding the National Commission with the limited powers of the state authorities in issuance and cancellation of caste certificates, which merely enable a person to avail of the benefits available to particular castes, comma, which are comma, in turn, comma, dealt with on a wider footing by the National Commission. Full stop. The rules of procedure of the National Commission for Scheduled Castes cited by the respondent numbers 9 and 10 are virtually a replica of the provisions of Article 338 and do not exceed more than that. Full stop. Rule 1 itself clearly delineates the duties of the Commission to be as laid down in Article 338 within bracket 5 of the Constitution, which have been replicated further. Full stop. Hence, comma, on a composite reading of the provisions of Article 338 and the corresponding rules, comma, this court is of the opinion that the National Commission is not required, comma, duty bound or even empowered to usurp the powers of the local authorities regarding the nitty-gritties of issuance and cancellation of caste certificates to particular individuals. Full stop. Next para. As such, comma, the minutes of hearing dated May 1, 2023, bracket A, annexure P7 at page 56 of the writ petition, bracket closed, was palpably dehorts the authority and powers of the National Commission insofar as it related to the recommendation for cancellation of caste certificates of particular persons, including the present petitioner. Full stop. In a peculiar manner, comma, not sanctioned by Article 338 or any provision of law, including the 1994 Act, comma, the Commission clearly stooped down to the level of authorities much under it in hierarchy and directed and observed that the petitioner and another person, comma, as per the documentary evidence, have obtained fake caste certificates, for which the Commission strongly recommended the District Magistrate Paschim Bardhaman to cancel the fake certificate issued to the petitioner and another. Full stop. Not only stopping there, comma, the Commission went a step further by noting that in case the district administration fails to implement the recommendation within the stipulated time, comma, the Commission would be at liberty to exercise the powers conferred on it under Article 338 of the Constitution of India and file atrocities case against the concerned authority, including Section 4 of the Scheduled Caste and Scheduled Tribes within bracket Prevention of Atrocities, bracket close Act, comma, 1989. Full stop. Next para. The Commission also recommended that remaining 17 alleged fake certificates would require a caste scrutiny committee of 7 to 9 members at district levels to be constituted, comma, which favor, comma, unfortunately, comma, was not advanced to the present petitioner for some unknown reason by the National Commission. Full stop. The SDO, comma, which is the authorized authority under the 1994 Act and the 1995 rules, comma, surprisingly, comma, paid obedience to the recommendations without authority made by the National Commission, and solely on the ground of such purported recommendation, observed that therefore, within double inverted close, it was cancelling the caste certificate issued to the petitioner. Full stop. Next para. Such cancellation is not only unknown to law but palpably dehorts to Section 9 of the 1994 Act as well as Rule 3 of the corresponding rules of the state of West Bengal. Full stop. Peculiarly, comma, while doing so, comma, no prior notice was even given to the petitioner for the petitioner to point out the palpable lack of jurisdiction and factual aspects to the respondent authorities. Full stop. Such exercise is thoroughly deprecated by this court. Full stop. In future, comma, it is expected that the National Commission shall be more cautious in arrogating powers to itself which have not been conferred either under the Constitution, comma, which is the high authority quoted by the Commission itself, or any statute for that matter. Full stop. In any event, comma, having flouted the law, comma, the respondent's actions are required to be set aside and quashed, full stop. Accordingly, WPA 24330 of 2023 is allowed on contest, comma, thereby setting aside the impugned order of the subdivisional officer, comma, district Paschim Mednipur, dated May 4, 2023, whereby the caste certificate of the petitioner was cancelled. Push up, the caste certificate of the petitioner is hereby the schedule caste certificate. The schedule caste certificate of the petitioner is hereby restored as valid. Push up, next para. Needless to say, comma, the minutes of hearing of the National Commission for Scheduled Castes dated May 1, 2023, to the extent that recommendation was made for cancellation of the petitioner's certificate and the observations made therein regarding the petitioner's caste certificate being fake are hereby expunged and quashed. Full stop, next para. However, comma, nothing in this order shall preclude the appropriate authorities under the 1994 Act to take appropriate steps in future, comma, if so required, comma, strictly adhering to the provisions of the relevant statutes, comma, for the purpose of initiating proceedings against the petitioner, comma, if otherwise so entitled in law. No address to cause, Sergeant Seti.
May I submit one thing? But it says the commission recommends that 17 remaining alleged fake certificates, a caste scrutiny committee of 7 to 9 members at the district level need to be constituted. Well, let the caste scrutiny committee will also
say anything regarding that. What is my specific observations?
Yes, your lordship.
To the extent their caste certificate has been castigated and that recommendation has been made in their regard. Only that.
So, what I am saying, Lord, subject to your lordship.
Everything else remains.
So far as Lord, what I am submitting, Lord, that caste scrutiny committee, let caste scrutiny committee also
Who prevents that?
Your lordship.
You are not getting my point at all, Mr. Tiwari.
Yes, I got
I have limited my regarding the recommendation of this minutes dated May 1. Yes. I've clearly stipulated that only that portion where they have their certificate has been castigated as fake and recommendation for their cancellation has been made, that is being expunged and quashed.
Yes,
I've made it very clear.
Yes,
the rest remains.
The rest remains. What I am submitting, subject to that caste scrutiny committee, let caste scrutiny committee also inquire their caste certificates also, my lord. Caste, so far as that part is concerned.
Look into my order when it is uploaded, Mr. Tiwari will get all your answers there. Next one.
My lord, before your lordship's moves on, my lord, probably in the order it has gone down as subdivisional officer Paschim Medinipur. My lord, it will be subdivisional officer Asansol subdivision Paschim Bardhaman.
Oh. প্রথমে বলেছি লাস্টে যেটা বললাম সেখানে পশ্চিম
towards the end of the
thank you
grateful your lordship.
Mr. Tiwari, your answers are there in the order.
So yeah, happy Diwali.
Same to you.
Item number 16.
16, yes. Mr. Singh, very well are good. Yes.
Item 15.
15 কি হলো? ডাকতে হবে তো, ডাকতে হবে। 15 ফাইলটা কি হয়েছে? 15 probably was during the vacation. It was
taken up in the vacation, but there is one difficulty. Is an order passed by the respondent number 2 that has been stayed. I am for the state. State has no role to play. Just to be expunged from the area of.
No, I cannot do that because the file is not with me. Probably file and order has been passed.
Yes, as against the respondent number 2 order has been passed. I am the state. State has no role. It is just for the purpose.
No, এটা লিস্টে যেন না ছাপা হয় দেখো. This is wrongly appearing in the list. 15টা কি তাহলে? কোনটা ফাইল নেই? Have you any idea because the file is not here? Was it mentioned during the vacation also?
It was done in the vacation bench. There's an order passed.
File is not here. That's why.
This is the order.
Order passed against the respondent number 2. There is no difficulty. It has been stayed. Some order has.
Without the file, I cannot pass any order. It won't be recorded in the file. That is the difficulty. So mention before Justice Gangopadhyay for a modification, whatever modification.
No, it's not a modification. I just want the state's name to be expunged from the area of parties because state has no role to play.
Whenever the matter comes up next, before the appropriate.
It won't.
It was disposed of.
No. Affidavit sections have been given and.
Whenever it comes up in due course, it is appearing in the list, but the file is not here.
Fix
So I
it up
cannot
tomorrow, Lordship.
File কোথায় আছে? We don't have any idea. It has to be mentioned formally then. Yes, call on the next.
Item number 16.
For the petition. This is my
16 টা কি হয়েছে? 16 টা কি হবে তো? Yes. মনে করে দিও। Yes.
That my lord, a tender
18টা কল করো করে
but a tender has been floated by the Public Works Directorate
Yes.
for widening and strengthening the state highway. In the tender notice, there is a clause that if the applicant or the firm be declared blacklisted by any other authority, that has to be intimated by way of filing an affidavit in the prescribed form Y. So far my case is concerned, my lord, I have submitted the bid disclosing therein that in a previous tender, Panchayat and Rural Development Department in the month of May 2023 declared me blacklisted. And I made a representation on consideration of my representation within 2 months that blacklisted had been withdrawn.
You have disclosed that also?
Yes. And I have annexed the documents also. I have supplied the documents. But what happened, my lord, so far the Panchayat and Rural Development Department is concerned.
Yes.
But the job is concerned about the Pradhan Mantri Rozgar Yojana. Pradhan Mantri Sadak Yojana. In that case, my lord, the beneficiary name is also recorded. His PAN number is also recorded. Same form has been applied, Panchayat Rural Development and also Public Works Department. So far the beneficiary is concerned, my lord, he is the petition number 2. That is the, my lord, managing partner and power of attorney holder of the writ petition. In the cancellation of my blacklisting order, his PAN number has been disclosed as a beneficiary. And withdrawal order also, my lord, the PAN number of the beneficiary has been disclosed. Now the authority Public Works Department says that so far this PAN number of the private individual is concerned, who is the managing partner, is not matching with the PAN number of the partnership firm.
How can it match?
How can it be? This is the only ground on tick. I have all our other criteria fulfilled. On that single
But
ground,
there was no blacklisting. They are also not saying so.
No, they are not saying so also.
They are saying these are not matching.
Matching. This is the only ground.
Who applied? One applied. The firm applied.
Firm applied in both the cases.
No, in this particular tender, the firm
Also firm applied.
Only firm.
Same firm.
2 has an individual as an individual.
No,
also?
he is not an individual. He is the managing partner. Petition number 2. He is also a managing partner in respect of the previous tender also. My lord, kindly turn up to, my lord, the show cause notice. The explanation has been sought for.
Yes.
My lord, kindly come to at page, my lord, 152. 162, sorry, my lord. Sure. First of all.
Yes.
Just for a moment. But kindly see, 2 points are there. Page 162. I'm reading from 1st September 2023. But date is also my. Dear sir, in connection to the above noted work, you are hereby requested to submit the following documents, clarification, as shortfall documents at the official email within 48 hours from the issuance of this letter, failing which any legal lead to your bid is non-municipal. So far, my lord, one is concerned, way bill of the tender roller that has been satisfied by them on my representation.
In
Second
the
one.
previous, yes, I've seen the same. Mr. Sir, in the previous blacklisting, number 2 was blacklisted. His number was blacklisted.
Same firm applied for.
Achha.
But in the blacklisting order, the name of the managing partner, the PAN number of the managing partner has been disclosed. Why? In the Pradhan Mantri Rozgar Sadak Yojana, a beneficial list is being prepared. Who are the beneficiaries? Farm is beneficiaries and the partner is also beneficiaries. So his name has been disclosed. That has been intimated by the Panchayat and Rural Development.
If the petitioner number 2 was disqualified there, was
Even
blacklisted.
I agree to your lordship. There is no cause. Even my lord, petitioner number 2 is disqualified.
He was disqualified. Previously, he was blacklisted.
Partnership firm has been disqualified. Only PAN number of petition number 2
was
mentioned in the disqualifying notice.
Both in the disqualification and
withdrawal.
in the withdrawal.
Withdrawal. And Panchayat and Rural Development Department intimated the Public Works Department that so far this PAN number is concerned, so far contract is concerned, there is no requirement. The same firm applied for.
Yes, yes. And where is your clarification?
My lord, kindly turn up to page, my lord, first 163.
Yes.
My lord, so far the first part is concerned, they have satisfied. Kindly turn up to page 164. May I read, my lord, your lordship? Entire thing has disclosed.
Very well. Although the firm was blacklisted because you had represented the firm, your number was given,
Yes,
your PAN number was given, and that has been clarified in.
And have annexed. And the Panchayat and Rural Development Department also intervened. Identical matter has also been my lord, considered by this court. A coordinate bench has passed an interim order, if you lordship kindly see, and your lordship extended the same. On the same ground. There are inferior case, there are two grounds. First page, your lordship need not consider, second page. There are a
very well. Yes, what do you say, Mr. Singh?
Well, first of all, this order is concerned, this has obtained ex parte. We have
So that is not binding.
No, we have filed a vacating application to that extent.
Therefore, this is not binding as of today.
No, I am not.
No means not binding.
Sorry, Milord?
Not binding. Because it
this
was
is
expert, it is not binding.
No, definitely binding to that effect.
What is the next argument?
Now, Lordship, kindly take trouble to see, Milord.
What trouble? PAN number has been quoted of the partner. This blacklisting has been withdrawn. Whoever's PAN number was disqualified, the same PAN number that blacklisting has been withdrawn. So how does it matter to you?
Now, the another limb of the argument would be, Milord.
Yes.
The firm is having a different SSC number.
Different?
SSC number.
SSC
PAN
number, yes.
And the partner is also having a different SSC number. These two cannot be same and identical.
What cannot be? The SSC numbers?
SSC number. Two are different.
May not be. Individuals and firm.
Right. Now, Milord, when the construction company, the petitioner number 1, having a different the SSC number, according to the criteria of the tender, he has to provide that. What he did, he has given a different PAN number which was debarred.
The firm's PAN number was never given.
No, that was the form Y. The number was given of the partner.
Sengupta, if I understood it correctly, correct me if I am wrong. The firm participated in your tender.
My lord.
When the firm participated, it gave its own PAN number. But since there was a clause that if there is a previous disqualification, you have to disclose it. For abundant caution, they have disclosed that yes, this firm itself was disqualified previously in another bidding process, where that disqualification or blacklisting that was withdrawn. But while both blacklisting and withdrawing the blacklisting, PAN number of this partner was given. So either you can say that PAN number blacklisting or that PAN number withdrawal of the blacklisting, that is not material at all, you may say so. Then also they get a chance, the firm with its own PAN number is eligible. And if you say yes, that is material, then the blacklisting has been withdrawn.
Of these two.
At present, in your tender, the firm in its own PAN number has applied. So then why are they being rejected?
No, kindly come to the declaration of the Y.
Where? Page?
Page 17. No, 118 first. Yes.
Declaration, yes.
Yes. Lordship, kindly see.
Firm's PAN number was never given, Mr. Sengupta. Firm's PAN number was never given in the bid.
Lordship, before that, Lordship, kindly take.
Mr. Sengupta will continue after the recess. Just show me whether
they have at the time of filing of
at any point of time whether they have given the firm's PAN number. If they have given the firm's PAN number, then it's all right. This is technical. I'll just say
this is not their case also.
Apparently not, but you also check up Mr. Shara in the recess and show
they have
that
intimated me that
the firm's PAN number was given.
Their communication is that in both you have applied by giving the name of the PAN number of the partnership firm. But withdrawal and cancellation, that's the only issue. That is not their case also.
They have a short conference with Mr. Sengupta and his learned juniors also. So we'll continue.
I will.
Sorry.
Yes.
Yes.
Yes. Check up. Checked up.
Let me allow.
Yes, yes. What is it?
First, your lordship, kindly come to page 78.
Yes.
Lordship sees this is the criteria of the tender. Lordship sees the A. Duly filled up in the copies of the section B form 1 and such affidavit in prescribed format with proper date, signature, relevant spaces to be uploaded and electronically scanned. Signature will not be entered. Document in support of the information furnished in form of the 1 B and affidavit must be attached uploaded for evaluation of the file number and page number has to be indicated to the respective column of the forum. Now, this is one of these criteria whereby the affidavit is the has to be filled up with the prescribed form. Thereafter, lordship kindly come to page number 90. Section 8 I 90, yes. Now, the statutory one, if any document submitted by a bidder is found to be either fabricated, tempered, or false, in such case, the eligibility of the bidder will be outright be rejected at any stage without any prejudice, and the farm company shall be liable to be prosecuted under such and such, along with the section 71, 73 of Indian.
How are these relevant? These are all there in every contract.
That's right. Now, what exactly happened? Kindly
let us confine ourselves to the point in issue.
This
why beat about the bush?
No,
these are there in every tender.
Right. This is there is a difficulty. I tell you, lordship. This is a component tender was called for, financial and the technical. Once generally what happened, once the technical bid is open, thereafter the financial bid gets opened. Whoever becomes successful. Here the financial bid is also opened here. The financial
bid was opened after the challenge, after the repetition.
No, not much prior to that. Much prior to that.
No work order has been issued.
No work order has been issued. That's right. Once we came to know this matter is under.
Argue on the relevant point here. You insist that they have not given the proper PAN card. The partnership firm's PAN card has been given, but regarding the other aspect of the matter, blacklisting, they referred to that blacklisting and subsequent withdrawal, both of which referred to PAN card of 2. So what?
No, the thing is that they have filled up and participated in the tender by way of 2 different PAN numbers. One is their PAN number. While declaring the Y affidavit, there is a different PAN number was given. Now, rightly or wrongly, this was there. We tried to confirm that whether this PAN number was matching with the firm or not. We find that this PAN number was not matching. So thereby, as per the inconsistency and the confusion, we have to revert him. But this is very as simple as that.
In the communication at page 162,
yes,
you have cited 2 reasons. One is way bill of tandem roller, which is a non-issue now. Clarification for mismatch in PAN as mentioned in letter for withdrawal of department, and that uploaded in tender.
In the tender.
So they uploaded in the tender what? I mean, this is only confined to this department.
Department.
As per your communication.
Department was taken place
so
much
this
prior.
This is a new point you are taking that you.
No, I am not. I am not.
If the partnership firm's PAN number was given when applying, that is sufficient.
No, that is all right. There is a declaration
regarding the department. They are saying this. Very well, ignore that department. They say there is no department. Proceed on that premise. Let them.
No, kindly come to the kindly come to.
If the department does not tally with the PAN number of the Mr. Sengupta, let us. Mr. Sengupta, I am addressing you.
Yes.
If the department does not tally, the PAN number of the department does not tally with their PAN number, the partnership firms. In any event, that department is not German, then according to you. So let them participate in any event they are eligible.
It is their document which they have submitted, my lord.
Very well, let us dispose of the writ petition. You are not arguing on point.
Kindly come to me at 118 once, and two things I will show, nothing more.
Show those things only.
Yes,
I will beat about the bush. 118 declaration, yes.
Yes.
For me, only the relevant things, Mr. Shen.
I-
These
I-
are small matters. Did not waste the entire day for this.
Millet, the affidavit kindly come, Millet, the undersigned 118.
I'm there.
Yes. Lordship, kindly come. The undersigned also hereby declare that our firm, SB Construction and Company, had been debarred by the West Bengal State Rural Agency as agency under Panchayat and Rural such and such, of PRD dated such and such, of the period such and such, which has now been withdrawn, vacated in terms of the order number such and such, with effect from such and such, in accepting the no such debarment of the Department of the State of the Central. Now, Lordship, kindly, when we have checked the PAN number, Millard, we have found that this is the different PAN number they have given. This affidavit which they have relied upon, Millard, is this affidavit PAN number and the other withdrawal PAN number are not matching together. This is the difficulty, Millard, we are facing.
Withdrawal PAN number is not matching means?
Millard,
they have given the numbers.
Kindly come, Millard.
They have given the order of withdrawal and the order of
122. This is the Millet 122. This is the PAN number.
At item 5.
At item 5.
You will note 8850. 8850.
8850. Lordship would come, Millet, once again.
This is
Millard.
not the PAN number of SB Construction. That is what you are going. So they have clarified in their answer.
Kindly come to their clarification. 164.
Yes.
164, page number 1 to third paragraph. Therefore, in both the order, SB Construction was represented by the Sanjeev Rahman with his one single PAN. It's an internal concern and or online records of the WSA Government of West Bengal, where I was an agency contractor, have no role regarding the consideration of PAN number as beneficiary. Well, this, I would say, Millet, the furnishing of the Millet, the PAN.
See the next paragraph. Therefore, in both the orders, SB Construction was represented by Sanjeev with his one single PAN, and it's the internal concern and or online records of WBSRD of Panchayats, where I, as an agency contractor, have no role regarding the consideration of PAN number as
It
beneficiary.
cannot be, Millet, the internal contract. Millet, two different PAN numbers are there, Millet. One is belongs to Millet, the SB Constructions, and one is belongs to Millet, this Sanjeev Rahman. Sanjeev Rahman, one number, the partner. He has given his PAN number, individual PAN number, which is not tallying with the company's PAN number.
What was that page you showed me again, please? Please give me the page number. 150. Right now, you showed that page, the department list.
122. Kindly come to 122. Yes. Eight 8850 0L.
This is the debarment order of the other organization.
Now kindly come to once more the page 180.
118.
180.
180.
I will also got it, Millet. 180.
Yes.
Now kindly see Millet 1, 2, 3, 4. Fourth paragraph.
This is their explanation. Fourth paragraph, yes.
We say that it is the practice FM beneficiary name being followed, error of the such and such of the department to mention the PAN number of the managing partner of the representative power of the attorney holder of the company in all correspondence instead of the mentioning the PAN number of the respective of the sole companies. This is the admission for which we cannot be flouted. SB Construction and Company in WBCAT worked and working in the sole PAN number of such and such. Well, they are from the very beginning aware of the same.
Mr. Sengupta, suppose we take it as you are saying.
Yes.
Please come to 122.5.
122.
SB Construction has been blacklisted
Yes.
This is not the PAN number of SB Construction.
My lord.
At best, what could be that SB Construction itself has not been debarred then. This SB Construction has not been debarred.
My lord, wait.
So the PAN number under which SB Construction is now applying to you, it's a different SB Construction with a different PAN number.
True.
So then they are not debarred at all at any point.
But kindly see the
You are making much ado about nothing. The partnership, while blacklisting the partnership, the partner's PAN number was given. But there is no doubt that Besar's SB Construction was blacklisted. And subsequently, where is the withdrawal order?
Well, the withdrawal order, Your Lordship would find.
Let us see that also, whether the same name and the
156. 156.
156.
Same. And Panchayat and Rural Development clarified the position.
With a thumb. Clarified with a thumb.
Yes. Saying that original PAN number of the company is this, but in the withdrawal and we have mentioned the managing partner's PAN number. They have clarified the position because they are the beneficiary. The same PAN number in both the companies.
One thing, Millard. Had it been a case, this confusion was there, Millard. They have not taken any steps to clarify the position, Millard. This is not their position. But when they have, Millard, when we have, Millard, opened the Millard brief, the beat, Millard, it was on, Millard, 6/10. Millard, the technical bid was opened on 19/9. And they have, Millard, preferred this application, Millard, on the 12th October.
Oh, they gave the explanation before that.
Yes,
that's right.
Replied to you.
No, that's right.
You have sought for clarification, I have given.
Well, these.
Hey, Mr. Shanmugam, this is decided. Enough. Learned counsel for the petitioner contends that the petitioner number 1 is a registered partnership firm with its unique PAN number. Full stop. On the other hand, the petitioner number 2 is one of the partners, is the managing partner.
Managing partner and power of attorney holder.
Is the managing partner and power of attorney holder of the petitioner number 1 firm with his unique PAN number. Full stop. Next para. While participating in a tender floated by the present respondents, the petitioner number 1 firm so participated with its own PAN number. Full stop. However, in satisfaction of a clause in the tender document that any previous blacklisting was to be disclosed, the petitioners disclosed a previous blacklisting of the partnership firm in a different tender in respect of a panchayat work. Full stop. However, it was also disclosed that such debarment / blacklisting of the petitioner number 1 was subsequently withdrawn. Full stop. Since the petitioner number 2, as the managing director and power of attorney holder of the petitioner number 1 firm had given his PAN number as well, which was quoted in both the debarment order and the withdrawal of the debarment by the previous authorities, a doubt apparently arose in the mind of the present respondents, a clarification regarding which was sought vide communication dated September 1, 2023. Full stop. The relevant clarification was regarding mismatch, alleged mismatch in PAN as mentioned in letter for withdrawal of debarment and that uploaded in tender. Full stop. Next para. It is contended that since it has subsequently been clarified by the petitioner as well as the previous authorities that it was an internal error on the part of the said authorities in quoting the PAN number of petitioner number 2 instead of petitioner number 1, the same cannot be a deterrent in holding the petitioner to be eligible for participation in the present tender. Full stop. Next para. Learned counsel for the respondents opposes such contentions and submits that in the declaration within bracket affidavit -Y annexed at page 118 of the writ petition, which was given by the petitioners, certain numbers were given, which do not tally with the PAN of the petitioner number 1 firm. Full stop. In view of such palpable discrepancy in the debarment and withdrawal orders regarding PAN, which does not tally with the PAN number of the petitioner number 1, the petitioner's bid was held to be ineligible. Full stop. A perusal of the documents annexed show that in both the orders of debarment of the petitioner number 1 firm and the order of withdrawal of such debarment, comma, the PAN number of the petitioner number 2 was cited, although the name of the petitioner number 1 specifically finds place in both. Full stop. The petitioners have given sufficient explanation in writing upon the query of the respondent authorities to indicate that in both the orders of debarment and withdrawal, the name of the petitioner number 1 firm has been given, which was represented by the petitioner number 2 with his own single PAN, and it is the internal concern and stroke or online records of the previous tendering authority for which the petitioners were not responsible. Full stop. Next para. It is quite obvious that the petitioner number 2, comma, who is the managing director at all relevant times, managing partner at all relevant times, comma, acting as the constituted attorney of the petitioner number 1, might have very well been misquoted inasmuch his PAN number was cited as that representing the petitioner number 1 firm before the previous authorities. Full stop. Next para. Thus, comma, the present respondents are making much ado about nothing inasmuch as the purported discrepancy is concerned. Full stop. Even if it is assumed that the PAN number of the petitioner number 2 was cited in the debarment order and the withdrawal order, comma, it would not have affected any debarment with regard to petitioner number 1 if the version of the respondents is accepted. Full stop. There is no inconsistency, at least inter se, between the debarment order and the withdrawal of such debarment, comma, which absolves any debarment, comma, if suffered by the petitioner number 1 or petitioner number 2. Full stop. Next para. Thus, comma, the quotation of the PAN number of petitioner number 2, who is in any event the managing partner and power of attorney holder of petitioner number 1 in the previous orders of debarment and withdrawal, do not have any germane effect on the eligibility of the petitioner for the present contract, comma, since it has been substantially explained away by the petitioners as to what were the circumstances under which the petitioner number 1 was debarred and subsequently such debarment cancelled by the previous tendering authorities. Full stop. Thus, comma, the approach of the respondents in rejecting the technical bid of the petitioners was hyper-technical and ought to be set aside.
Page 184, dated 6th October 2023. Page 184. The final order of rejection.
Full stop. Accordingly, thank you. WPA 24772 of 2023 is allowed on contest, thereby setting aside the order of rejection of the tender of the petitioners by the respondent authorities dated October 6, 2023, within bracket annexure P14 at page 184 of the writ petition, bracket closed. Full stop. The petitioner shall now be treated to be eligible for the consideration of the final bid. Full stop. Necessary steps shall be taken immediately by the respondents for re-evaluation of the financial bids by deeming the petitioner to have succeeded as an eligible bidder in the technical bids. Full stop. It is expected that such exercise shall be concluded at the earliest with prior notice to the petitioner as well as the other successful tenders at the technical stage. No address to cause urgency.
They have already participated in the financial bid minute. It's a consonant chief. It was together.
They will just open the financial. Yeah, all right. What is
But affidavit of service may be kept on record.
Affidavit of service.
My
Item number 17.
17, yes.
My lord, in this matter, Gopal Rai is respondent, my lord, electricity matter.
Yeah.
Oh, my lord, due to his illness, he has not come. I'm praying, my lord, not this week, my lord.
Not this week. Order record করতে হবে, not this week. 18 টা কি হয়েছিল বলছি?
Already disposed of. It was disposed of during the vacation.
Vacation.
So Lordship.
You are the culprits.
I was not the culprit. I was initially
Your
appointed.
Leonard Junior was the culprit.
No. The new appointee was the culprit.
Anyway, so this no order can be passed since the file is also not here. 18 টা শুধু লিস্ট থেকে বাদ চলে যাবে already. Good. Thank you.
Item number 19.
19.
হ্যাঁ ও তো কিছু হলো না আউট অফ লিস্ট
Item number 19.
For item number 19, I am the petitioner appearing person. May I seek your lordship's leave to appear in person?
Yes.
My lord, we are appearing for all the respondents, my lord. Today morning we have received the brief without annexure, my lord.
If the annexures come back tomorrow.
And we have not received the instructions also. So
Your instruction come. What is their grievance?
Actually, this is a matter of relating to RTI Act, Right to Information Act.
Right.
One application was filed, your lordship. One application was filed on 28 June of 2022. I sought some inspection reports and some basic information from Eastern Railway. So railway authorities, my lord, please see page number 22 of the petition.
Page 22, yes.
Yes, page 22. That is the queries are there.
Yes.
Lordship, the food plate inspection report is the basic thing. The inspection reports may be furnished, but unfortunately, my lord, in page number 23, in the next page,
yes,
the PIO, that is the Public Information Officer,
right?
He denied. He said that it's a confidential in nature, and hence it won't be disclosed.
So you preferred a challenge.
Yes. So then I appeal to the first appellate authority. The first appellate authority. Now that is the thing is, my lord. Please see page number 25. The
25.
bottom of the page.
Yes.
Decision.
Do not agree with the content.
Yes, he is not agreeing. So when
direction given to provide the information.
No, the information has not been provided. Now what happened is in page number 27, my lord, please see annexation number P5.
Yes.
They are saying that now the PIO is saying that the inspection note made by the officials of an organization normally relates to the functioning of the organization. So they are denying. So the second appeal to the Honorable Commission. So Commission called for the hearing. That is hearing date is page 31.
No, but did the first authority had this right to do it? Because the first appellate authority direction was very clear.
Yes, but the PIO denied it, vehemently denied it.
So you preferred a second appeal?
Second appeal. But unfortunately, in the second appeal, the order passed by the first appellate authority was withheld. And the Commission said that whatever the information, whatever the reply served by the PIO is all right, and Commission will not intervene in this matter. And now the question is, my lord, whether the inspection reports ought to be furnished for the public view. That is the main question.
You are Mr. Dotto, aren't you?
Yes.
No, Mr. Dotto, if that be so, it requires a bit of hearing.
Yes.
So let them come prepared with the instruction.
Lordship.
Let us not take them unawares.
Lordship.
So how soon can we take the instruction? Day after tomorrow come back? Day after tomorrow. Give all the, please ensure, Mr. Dotto, that all the annexures, even if they have got it, please give annexures again to your learned friend.
I can give you another copy.
In the course of the day, please do it. Take instruction by today. I'm not keeping it tomorrow. I'll keep it on Saturday.
This is the copy, my lord.
Come back on Saturday. Saturday we are having court, so at least let me have one matter.
Then Saturday.
Yes. I'm ensuring that if there is urgency also, Mr. Pal,
Yes.
so all urgent. Saturday, come back only for this. Come to court, have this matter, lose the matter and go back. Learned counsel for the respondent authority submits that sufficient instructions have not been obtained by her in the matter, and she does not have copies of the annexures to the writ petition. In order to enable proper contest, the petitioner, who is appearing in person with leave of court, is requested to furnish a fresh copy with annexures to the learned advocate for the respondents during the course of the day, full stop. To enable the respondents to take instructions, let the matter stand over till day after tomorrow.
My lord.
Grateful.
Saturday থাকবে।
Item number 20.
Live activation.
Yes, Mr. Theory.
I'm for the state in this
Switching
matter.
sides very quickly.
Yes. This is our job, Lord. Your Lordship.
Obviously, it's your job, and I appreciate that. Yes.
My Lord, here, my Lord, what happened? My Lord, West Bengal Industrial Development Corporation issued a plot of land, given a plot of land to the petitioner, number one company. My Lord, a lease deed was executed on 13th of August, my Lord, 2021.
Right.
On the basis of that lease deed, my Lord, I have paid near about 1.91 crores. Now, my Lord, in the lease deed, there is a clause, 11.4, there is a clause that the lessee can take financial assistance or help from the concerned bank on on depositing this title deed or by creating lien in respect to the property in question. So, but there is a clause, clear clause. I shall place
Clause
that.
says you can.
Yes, I can. Subject to NOC.
Calculated this deed between yourselves.
Yes, yes.
All right.
Subject to the NOC to be issued by the WBIDC. Now, my Lord, after taking the land, my Lord, I have invested near about 7.5 crores. Now, my Lord, built my Lord, constructions. My Lord, it is a factory, my Lord, regarding ice cream and frozen dessert factory. Now, my Lord, construction was completed. My Lord, Pollution Control Board also issued certificate to that effect. Permission was given by the WBIDC for the construction to be made over the site in question. Now, my Lord, today, after investing 7.5 crores,
they are withholding that permission.
Yes. Well, until unless permission is given, I cannot complete.
So
Now,
show me the clause and the refusal.
Yes. Well, the clause is page, your Lordship, can you turn page 54? Page 54.
Yes.
Page 54, may I place creation of lien. The lessee shall be entitled to create charge, mortgage, hereafter referred to as lien, the leasehold interest in the demised land in favor of any financial institution or scheduled commercial bank, non-banking financial companies, government institutions, LIC, security trustee, debenture trustee as security for raising funds required for the purpose of setting up, running, development of the project on the allotted land as described in the schedule with prior permission, written permission of the lessor who shall obtain prior approval of the administrative department of the state government before granting such permission. Now, my Lord, I from time and again, my Lord, I just show my Lord one letter. Well, I asked for my Lord issue.
But the discretion was left with the state.
Yes. Now, my Lord, can you see? The discretion was for the purpose of setting up, running, development of the project on the allotted land as described in the schedule.
What is that?
But this is 11.
This.
Yeah.
Yes, same thing. Yes.
Now, my Lord, there are other clauses. My Lord, I must be candid to your Lordship. My Lord, your Lordship, my Lord, can you tell me, Lord? The other clauses, my Lord, I shall touch.
But the moment it is subject to prior permission, which is on prior approval of administrative department, that discretion is left with them.
Absolutely. My Lord, kindly consider one thing. Today, my Lord, after investing 7.5 crores.
I appreciate your point, Mr. Theory, but can we compel them? It's a legal right.
19 crores, my Lord, I require. 7.5 already invested. Until unless they grant NOC, I cannot complete my project. Well, they have refused NOC, my Lord. I have received this, my Lord. Kindly see this. Kindly, I am
annexed it here.
I am received it subsequently, my Lord. Supplementary affidavit.
So, what was the cause of action for the writ petition? They were withholding that.
No, actually, they were not given any reply after filing of the writ.
Yes, withholding reply. That's why you filed the writ petition. After that, it has.
Yes, after that, it has come. Now, my Lord, they are saying, my Lord, kindly see, my Lord, their rejection. My Lord, in this case, my Lord, may I just refer one page to your Lordship? Kindly take, my Lord, page 142 once before taking, my Lord, this rejection order. Page 142 once. My Lord, this is, my Lord, the letter written by my banker to the, my Lord, Managing Director, my Lord, West Bengal Industrial Development Corporation. Plus, what is he saying? This is a reference to the caption. We are to inform you that we have in principle sanctioned the term loan of 11 crores and CC hypothetical limit of 2.5 crores, subject to compliance of the extant guidelines of the bank and the terms and conditions therein. Since the end use created by the bank fund will be installed or fixed, allotted plot number such and such, Noihati, West Bengal, the same has to be mortgaged by the bank for creation of the equitable mortgage. Allotted plot is more specifically described in part number such and such, such and such. Therefore, we request your good self to issue no objection certificate for creation of the equitable mortgage on the allotted plot as per clause 11.4 of the registered lease deed in favor of such and such, so that we can proceed with the matter. So, well, bank is also saying, Lord, kindly.
No, they are relying on a letter dated 16th of August. What is that?
16th of August.
They say that by that they ask for a surrender of the land?
Yes. Kindly turn to page 112.
When did you first ask for this permission from them?
I asked for permission, Lord. (141), Lord, page. It is, Lord, dated 21st August. 21st August, Lord, 2023.
21st August. But before that, they had given this.
No, before that, Lord, kindly see, Lord, page 112.
112, yes.
112, they are saying. 112, they are saying that I was given a so-called notice. Number two options were given. They hand over the possession within 15 days, or otherwise you start so fully established and ready factory industrial unit with plant and machinery set up within 3 months from the date of issuance of this letter. If this option is availed, factory unit and the plant machinery is still not completed within 3 months, then the entire lease premium shall be stand forfeited and not no refund shall be made.
So you are trying to evade this by way of this exercise.
So, kindly consider this. This was issued on 16/8/2023.
Yes, immediately after that.
3 months. 3 months time. 3 months time is supposed to be expired today. That is on 16th of November 2023. Prior to that, I approached this Honorable Court on the last day, just on the eve of vacation. Subsequently, this letter was issued 7/11/2023. Now, today, your Lordship will kindly consider. I have constructed, kindly see page 113 and 114.
No, the filing of the writ petition did not prevent you from doing this. I mean,
I will kindly see.
When did you take the land? The lease?
I have taken land,
long back.
25. The lease deed was executed on
which date?
Lease date 13th of August 2021. 13th of August 2021. Kindly consider.
Have you got fully established factory industrial unit?
Fully, construction. I have kindly take 2 pages, 113 and 114. 2 pages, I have issued. I have given photographs showing the construction. I have what kind of.
It's not a fully established.
No, I cannot. I am admitting it. Total project is. I have to take plant and machines from various parts of India.
So what are you doing for these 2 years?
I have done.
You should have undertaken this exercise long back. Only after their letter you are doing this.
Kindly see page 110 once. My reply.
Reply to that show cause?
Yes. Kindly take page 110.
110, yes.
I have given first one. Date of possession of the undeveloped water field land measuring about.
This is prior to that. This is 17th July. Their letter was 16th of August. Even prior to that, you have written.
Yes.
So very well. Yes. What did you write?
This is not in respect of Socos. I am saying that
previous Socos also then.
Yes. Land development. I have done land development. With approximate 8 feet filling under condition of shortage of available goods such and such. COVID lockdown period was there. The revised possession was issued on 11th of February 2021. Development and earth filling on extra land during the times of partial opening due to COVID situations and such. Extra earth filling approximately 2 feet on total land due to revised level. New approach such and such. Consent to establish from the West Bengal Pollution Control Board. Next, fire safety recommendations I have obtained. Subsequently, sanction of the building, sanction of the industrial building plan from the West Bengal Industrial Development Corporation Limited. Next, commercial of construction of RCC structure building along with pile structure as required to maintain such and such. Completion of the construction of main RCC building. Construction of the internal walls, cement, sand cement plastering. These things I have done. Today, what problem I am facing? My lord, on the one hand, my lord, they are asking me, my lord, to complete the project. My lord, I requested for NOC so that, my lord, I can get financial support from the bank. So, my lord, until unless NOC is given, my lord, this is one kind of obstacle my lord, so that, my lord, I cannot complete the project itself. So, one hand, you are not issuing the NOC.
The land was allotted to you on 22nd of September 2017.
So 27th of September under double land, subsequently revised position was given. Revised position was given, my lord, on 11th of February 2021, page 42. Page 42, my lord, the land revised position was given on 11th of February 2021. Page 42, your lordship.
What is the meaning of revised position?
Actually, initially, my lord, land was 1.5 acres. Subsequently, it was found that fully water body more or less was given. On revised measurement, it was found 1.718 acres of land was given. And that position certificate was given, my lord, on 11th of February, my lord, 2021. So, my lord, my days count.
For all practical purposes, you got it on just
Absolutely
prior
correct.
to.
2017. Well, subsequently, my lord, COVID intervened, my lord, 2 years have
What
gone.
have you challenged here?
Here I have challenged, my lord, I have asked for two things. Number one, my lord,
Have you challenged the show cause notices also?
I have said, I have prayed for, my lord, page 25. I have prayed that for direction upon the WBIDC to issue, my lord, NOC so that I can complete the project. Number one, my lord, in the meantime, what I am submitting, they are saying the lease deed will be terminated and premium which I paid, that will be forfeited. So, my lord, I asked for, my lord, injunction, my lord, restraining the WBIDC from interfering my possession or from, my lord, cancelling the lease deed. My lord, as on date, my lord, your lordship, my lord, kindly visualize one thing. The until unless, my lord, NOC is given on the basis of the request made by my banker, I am not in a position to complete the construction.
Yes, what do you say to this?
My lord, I am appealing for the state led by Mr. HON'BLE Kumar Shen, my lord. The answering respondent here is the WBIDC, my lord. As far as the state is concerned, we have
Check good
Yes,
service.
yes, sir.
we have contacted the relevant office. We have tried to contact the relevant offices, my lord, but we couldn't get through, your lordship.
Mr. Tiwari, I'll stay the operation of 16.823 order and I'll direct affidavits because we have to get the clear picture. Otherwise, I mean, you may be also recalcitrant in some respects. You got the property in 2021. You were applying for the first time only after getting this notice of August 2023. You could have undertaken this exercise previously also.
No, my lord, actually, I request for NOC, my lord, to the bank and other financial institution, my lord, only after receiving this. Well, there is no doubt about that. And, my lord, your lordship, my lord, only one thing, my lord, may I subject to your lordship approval. My lord, today, my lord, your lordship, my lord, kindly visualize, my lord, this clause, this 11.4 is to be read, my lord, independently. And, my lord, they are saying that you have to complete the milestone. My lord, can you see the milestone? What is the milestone, my lord?
You say you have complied with the milestones.
Up to third schedule, I have completed. My lord, kindly see the milestone. Milestone, my lord, your lordship would get, my lord, page 77. Sorry, my lord, I have completed up to second milestone.
Second milestone.
Now, commission of plans and commercial operation. These two things, my lord, having directly linked with my, my lord, financial assistance, which I supposed to get from my banker. So, until unless I
not
get...
even started. Mr. Tiwari, according to this also,
yes,
you have to ask for this no objection from them from December 1st, 2021 onwards.
Yes.
So you waited for 2 years because for commissioning of plants.
No, I am just telling. There was a mistake in the plot of land. They have allotted plot number 6.
Yes. That's why you said that reposition and all.
Subsequently, the reposition certificate was given in the February 2021. Kindly visualize two things. Kindly see this page 77 with page 54 and page 66. Page 54 says this lien clause. Now, this until unless I just don't want to repeat, until unless NOC is given, I am not getting financial.
The question, Mr. Tiwari, is not about you not getting the NOCs. Right, you are right on that. They cannot play a dog in the manger policy by not granting you that that no objection at the same time. But the difficulty is the question also remains when you asked for it for the first time. If the schedule was you have to complete by 2023 and you ask for the first time in 2023 for putting it as a lien or mortgage, giving it in mortgage, I mean, you are also 2 years late.
Yes, yes. This too.
In the meantime, the difficulty is you do that immediately after that is also the timing is also coincidental, not coincidental actually. You do it immediately after they say that you have failed to set up the project and now we want you to give back the land. After that, you have
my lord, kindly see, my lord, when this certificate, my lord, kindly see, my lord, two documents, my lord.
Have you answered the 16th of August? thing?
Yes, yes, yes.
16th of August, you have not answered. No. That's what they have quoted in their refusal.
16th of August. Page 112.
I'll stay the operation of the 16th of August in the meantime, direct affidavits.
My lord, so far as my lord 16th August is concerned, my lord.
Yes.
16th August, my lord, there are two options were given to me.
Right.
First of all, option, my lord, handover possession. Second option, my lord, complete the project within 3 months. But it is humanly, my lord, impossible to complete the project, my lord, within 3 months. My lord, it is a 19 crores project. My lord, I have to procure plant machineries from various parts of India as well as from the foreign countries, my lord. But it is absolutely impossible, my lord. They are saying, my lord, you complete it within 3 months. It is absolutely, my lord, highly impossible, my lord, highly improbable, my lord, if I may say so. My lord, until unless, my lord, they issue NOC, my lord, I cannot inject, my lord, further amount, my lord.
Till then, you had not asked for NOC. That is the reason for them doing it.
Till then, my lord, what happened, my lord? Till then, my lord, I had fund, I have utilized my fund. My lord, frankly speaking, my lord, this is the fact.
It's an arguable case at best. একটা order record karo. Learned counsel for the petitioner has raised certain interesting prima facie questions for hearing the writ petition on merits. First up, text para. The petitioner was initially given a plot of land for industrialization by the respondent authorities in the year 2017. However, there were certain discrepancies in handing over the land for which reposition was given only in the year 2021. The petitioner submits that the petitioner has complied with the first two phases of the scheduled work as per the original agreement between the parties. An agreement of lease was entered into between the parties only on August 13, 2021, as per clause 11.4 of which, for the purpose of setting up, running and development of the project on the allotted land with, the lessee, that is the petitioner in the present case, with prior written permission of lessor, who shall obtain prior approval of the administrative department of state government, could very well create a charge, mortgage or lien over the leasehold interest in the demised land. Apparently, the petitioner applied for such permission from the respondent authorities you applied on August, when did you? August 30th. No, on August 21, 2023.
141.
The same was, however, refused on the ground that immediately previously, that is on August 16, 2023, a communication was made by the West Bengal Industrial Development Corporation Limited to the petitioner, asking the petitioner either to hand over possession of the land within 15 days or to show fully established and ready factory/industrial unit with plant and machinery set within 3 months from the date of issuance of the letter. Next para, it is contended with some justification that a period of 3 months was too short for completion of the work contemplated. Moreover, the petitioner has disclosed in the writ petition prima facie sufficient reasons for the delay in initiating the process of mortgaging the demised land, demised property for getting the loan concerned. Next para. Although clause 11.4 of the concerned agreement does not cast a mandate on the WBIDC CL to grant such permission, it is well settled that a commercial contract has to be read, if there is some ambiguity, in the sense which projects the commercial interest fully. Next para. In such view of the matter, keeping on balance the bona fides of the petitioner in completing all formalities by investing huge amounts and seeking permission to mortgage the property for obtaining loan to complete the project on the one hand, and that of the respondent authorities to ensure that the project is undertaken in terms of the agreement, comma, the writ petition shall be heard on merits and for such purpose shall be listed in the monthly list of January 2023. Full stop. Next para, affidavit in opposition, if any, shall be filed by December 15, 2023. Full stop. Reply, if any, shall be filed on the next returnable date. Full stop. Next para, there shall be stay of operation of the communication dated August 16, 2023 within bracket annexure P7 at page 112 bracket closed till disposal of the writ petition. Further, comma, the respondent authorities shall be restrained by an order of injunction from ousting the petitioners from the property in dispute, also during pendency of the writ petition. Thank you.
From cancelling the lease deed and or ousting,
No, ousting only. Cancelling the lease deed, I won't do it. Will reverse if necessary. Cancelling the lease deed without ousting it won't inure to anybody's benefit.
Well, leave be given to file a supplementary. Today I have used a supplementary.
Oh, acha. প্রথমেই একটা line আছে, leave is granted to the petitioner to file a supplementary affidavit. Have you served copies of that on the? Mr. Theory, have you served copies on state as well as the WBIC?
WBIDC, I send by in course of tomorrow. They will apply.
21.
No, I'm for the electricity company, WBACDC.
Yes, Mr. Mukherjee, what is the matter?
Lordship, this is petitioner is an farm. Lordship, the agriculturist. Lordship, the have some agricultural land. Lordship, the applied for. Lordship, supplying the form so that petitioner can apply for the new electric connection. Now, petitioner has been, Lordship, debarred from collecting the form first. The petitioner has installed the submersible. Now, for effecting electricity.
You've not been given a form for applying for electricity?
Applying the electricity.
Why?
I don't know, Lordship. I submitted then written, Lordship, representation. Now, Lordship, here in this writ petition, I very short prayer. Let this application form be supplied to the petitioner, and after getting the filled up form, let this after whatever Lordship the inspection and whatever the.
Why are you not giving the form?
Lordship, firstly, Lordship, as far as my instruction goes, forms are available at the section of, my lord, kindly see the SOF, my lord, once. Statement of facts. Forms, point number 2, point number 3, Lordship, they have not applied officially, my lord. The forms are available in the cash section, Lordship, at ₹5. And Lordship, furthermore, Lordship, this block, Lordship, it falls within the category of semi-critical zone, Lordship. After their application, a formal has to be taken from the SWID, Lordship. That is required.
They have received my application on 3rd October 2023.
That is
there is no communication.
That is a written representation, Lordship.
Yes, because listen, they had ought to have informed me that the application is ready, you collect the form.
Why should they not give you any the form? There is no reasonable basis of this allegation, Mr. Mukherjee.
Lordship, this is admitted fact. Lordship,
no malafidus have been. I mean, there is no cause of action for the writ petition. Take a form, apply. Apparently, your client thought that by way of this writ petition, we'll be directing them to give a connection.
No, I'm not. Kindly come to my prayer.
You did not think so. That's why you are modifying your prayer.
No, kindly
they
come
won't
to
be
my
giving
prayer.
a ₹5 form. Why?
But this is admitted position that they have not been issued any form.
Why should they issue? Go there, pay ₹5, take a form.
So that is the fact that in the lots of counter they refused to supply the form.
Shall direct the SP of the concerned area to
I'm not
give you police protection so that you get a ₹5 form.
Lots of kindly keep it pending. Lots of this is the fact. Lots of I went there.
One reason why you are being refused. There has to be some motive for that. You have to disclose some reasonable basis for this allegation. You cannot make rampant allegations against anybody. I'm not being permitted to enter the court.
I don't want
to be the reason for that malafidus. What is their motive? What can be their motive?
Lordship, this is the fact, Lordship. This is a 5 petitioner before your Lordship, 5 writ petition.
Not good.
No, Lordship, this is the fact. Lordship, I went there. I repeatedly requested. Lordship, this is kindly come page 7.
Counsel for the petitioner submits that the petitioner approached the respondent authorities but was not given any form for applying for electricity connection to operate his submersible pump.
No,
Full
for
stop.
applying the electricity to operate the submersible. I have one to apply.
Full stop. Next para. Learned counsel for the WBACDCL categorically opposes the same and submits that a form is available upon payment of ₹5 and there could not be any plausible reason why the petitioner was refused such favor. Full stop. Next para. Although I do not find any credible malafide alleged in the writ petition for the WBACDCL to refuse even the opportunity to the petitioner to take a form, to collect a form for applying for electricity, comma, in view of the petitioner having a right to so apply, comma, WPA 25205 of 2023 is disposed of by directing the petitioner to collect a form for applying for electricity connection to operate his submersible pump from the appropriate authorities of the WBACDCL, full stop, if so approached, comma, upon compliance of all formalities by the petitioner, including the price of the form, comma, the WBACDCL shall ensure that such a form is given to the petitioner, full stop, upon getting such application form, comma, the petitioner will be entitled to file an application for getting such electricity connection, full stop. Thereafter, the WBACDCL will process the said application in due course of law and only upon the petitioner complying with all due formalities in law shall the WBACDCL consider giving electricity connection to the petitioner. No rest to cause.
Grateful, Lordship. Lordship, item number 22 and 24, Lordship, they are the same matters, Lordship.
It will be called on 22. 22 why not given? Now the form, the price of the form will increase. Now 10 rupees.
Lots of same Mauja. There are different cultivators. Lots of these are also the same issue. That
when did you last visit that Mauja personally? When did you visit that Mauja? After that, this problem is being created. 22 same order.
22 same.
20, same allegations must. 22 and 24.
Yes. 22, 24, 25 and 27.
This is a new branch of jurisprudence.
25 and 27 I am appealing.
আচ্ছা একটু বোর্ডে দেখিয়ে দাও 22 পরপর দেখিয়ে দাও তো 22 give the numbers 22
22 24 25 and 27
25 and 27 happening
27 27 25
please give the item numbers and your names otherwise it will be confused. Udorpindi concept. 25 আরো আছে 22 25 27
my lord 25 and 27 I am appealing
22 22 তো হবে
22 lordship I am appealing 21 22 and 24 I am appealing lordship
একবার কল করে দাও ভদ্রতা করে প্রীতম
item number 22
সব বলো একসঙ্গে 22 তারপর 25
24 25
I am appealing
24 lots of
22 25 26 27
20 20 21 22
কাগজ নাও পেন নাও লেখো দিকে রাখো
21 22 24 25 and 27
লিখে নিয়েছো মাইকে ডাকো ওই অনুযায়ী তুমি ওগুলো বোর্ডে
item number 22 24 25 and 27
25 and 27 I am appealing for the license
কমা ফমা পড়ছে না নাকি
all the matters I am for the petition
same order in all the matters
grateful man
item number 23
Lord, I am appealing for the petition.
Yes, please.
Mostly the prayers are against enforcement directorate.
Lord, may I submit?
Yes, absolutely. Presumption is that he is wrong. What is it? Is this regarding your inaction or something like that?
No.
Yes. Yes, it is. His allegation is my inaction.
Let us see.
Cannot be termed directly as inaction.
Take the microphone towards you, not away.
Yes, yes. My lord, I am a proprietorship business which deals in export and import of gold jewelry. My lord, I import gold and then export it after transforming it to jewelry. My lord, I take the making charges mostly. That is my profit. My lord, I have dealt in gold transportation and transaction with 2 foreign companies, mostly 2019 onwards. Till date, there are 50 transactions. Now, there is a regulation of Reserve Bank of India that all those transactions are to be channelized through AD Bank, Authorized Dealer Bank. Now, my authorized dealer bank is Axis Bank. Each and every transaction of mine was channelized through proper customs, everything, all documentations are there. There was no issue, there was no question. Out of those 50 transactions, 32 transactions could not be set off. There is a rule that each and every transaction needs to be set off with the between the parties within a year. There may be multiple set-offs. Like set-off is a kind of settlement of dues
between you and your
the party,
foreign
party. And after multiple set-offs, then need to be an annual net off. With
net off is the balance of the set-offs.
Yes, now in order to go for the set-off, I need to get clearance from the bank. BRC is to be issued by the bank. Reconciliation statement kind of a thing.
Bank reconciliation.
Yes. So
that is BRS.
No, BRS, but BRC.
BRC is some technical term.
Yes. My lord, subsequently, when I approached my bank, there was an issue during COVID that I could not receive payment within time, the period stipulated for set-off, and I also could not make payment within time to the concerned company within the stipulated period of time due to COVID, and subsequently there were fund issues and all. Those 32 transactions, period of payment was not complied.
So it's like this: the payments have to come first, then the BRC, then the set-off. At the end of the period, net off. Very well.
This is the crux of the thing I have understood.
Yes. So your transactions could not go through in
go
time.
Through the
in time.
entire channel.
Then
in
what
time.
happened? Yes.
Then, my lord, I approached the AD Bank. Allow me to set off whatever the charges or penalties are required. I am ready to pay off. The AD Bank said that I do not have jurisdiction. Once it goes beyond the stipulated period, you have to approach the RBI. It was communicated to me verbally.
For getting the BRC.
No, for getting the BRC, for going for the set off and net off, entire transaction to be regularized. My lord, I approached RBI through email and everything. RBI said, you approach your AD Bank. We are forwarding it to your AD Bank. We again went to AD Bank. AD Bank said, we have been informed you are maintaining other AD banks which you are not authorized to do, as has been informed by Enforcement Directorate.
All right.
My lord, my business organization had 3 more bank accounts, current accounts, which were not used for any export-import transactions. In order to prove that I have never transacted through any other bank, you are the only AD bank for mine. My lord, I made a query before those 3 banks. One is Union Bank of India, the other one is Yes Bank.
Your accounts in the other banks were for other purposes.
Other purpose,
not
current,
for this
current account. There was no import-export.
Very good. Then
Union Bank of India, Yes Bank and ICICI Bank. They replied back that there were no such transactions.
Yes Bank has to say yes. The others also said yes.
He said no. So Yes Bank also replied in negative that there was no transactions. I again approached with representation that allow me to then say the actual outcome is since it, my lord, kindly comes to page 41 once.
Yes.
Under the heading, under the point C26.1, then clause 2, then G. My lord, these are the criteria which are to be fulfilled. AD category 1 bank shall ensure that import payables and export receivables are outstanding at the time of allowing the set-off. Further set-off shall be allowed between the export and import legs taking place during the same calendar year. And my lord, in the event there is a C, my lord comes to C. C, The invoices under the transactions are not under investigation by Directorate of Enforcement.
Acha.
Right, my lord. Now,
So
my
if it's under investigation,
yes,
then
my lord.
this cannot
Now
be
I'm coming to that question. My lord, in the year 2021, I was served with a notice from the Enforcement Directorate.
right.
They asked for certain documents. Page 53, my lord.
Yes.
Yes, I complied with that notice. I given all set of documents. Since that day, no notice, nothing, nothing was, no closure, nothing was intimated to me. I am actually under the impression that there was nothing to hide and everything is open to the Enforcement Directorate. So I am not being allowed to set off my transactions. Charges are.
What is the relief you are seeking?
My lord, I am seeking the primary relief that I may be allowed to set off and net off those transactions.
But if an investigation is going on, how can it?
They are not saying that. I have also alternatively prayed that let them come to the conclusion, whatever they are doing.
Mr. Bhumik, you only have to disclose that an investigation is going on. Is it going on? Right.
My lord is at page 41.
41, yes.
Kindly come back.
Yes.
C 26.1. Paragraph C 26.1.
Yes, yes.
My lord, AB category bank may deal with the following request received from their exporter-importer constituents for allowing setup of outstanding export receivables. Mean the export has taken place, receipt has not come. Here the case is completely different. They received advance payment. That is to the tune of US dollar 94,850. Against that advance payment, there was no export. We started investigation. Since 2021, investigation is pending. Last summon was issued to him for his appearance on 3rd of November this year.
No, my lord.
Have
Wait,
some patience.
Sorry. Yes, 3rd of November, yes.
Now, this clause of set-off is with respect to, my lord, where the goods have been exported, foreign remittance did not come.
Right.
This has no manner of application in this present case, number one. Number two, my lord, there is what he is asking from me. He is asking for a no objection certificate to the bank by saying that I have no objection if you set up the liability. Well, that I cannot do because my investigation is pending. That's why he took so much of huge export advance remittance and there was no export. So that investigation is going on, my lord. That is my specific instruction.
My lord, may I reply with?
This is his only scope. I mean, only that he has to disclose that yes, the investigation is going on.
No, there is a prayer. My lord, may I reply it with 2 lines?
Very well.
My lord, one thing he has referred to a notice of 3rd
Summons,
November.
yes.
3rd November.
3rd November.
That 3rd November notice is with regard to a organization which is named Mizan. It is SB creation.
Not against you.
No. And it was sent to me only on the pretext that I used to work there in Mizan, which is owned by one of my distant relative who is looking after
There
that
may be a
business.
connection.
No, my lord.
Investigation, they make ask.
Certainly.
He is the proprietor.
No, I am not the proprietor.
SB creation.
SB creation, I am the proprietor.
They may very well summon you.
Certainly. It was not connected with SB creation. And that is a separate file number, not related to this file number. That may be a separate investigation.
They caption it as investigation against Messrs. SB creation at
Yes.
22.
Yes.
Exactly.
Yes, it has a reference number also.
Yes. So the investigation also concerns you.
Yes, my lord, file number T3 Miss 56 2019 4844.
So you cooperate with the investigation?
Absolutely, I have visited them. And my lord, one thing, after I filed the writ petition, they are coming up with the notice on 3rd of November in respect of another company where I was employed till 2016. After that, I have no connection with that.
So
even if
maybe
whatever
their investigation will fail against you, that That may also
100%
happen.
it has to fail.
I mean, it may also happen. ED cannot have any personal interest in you.
Certainly.
I mean, your name has cropped up. They're doing
Certainly.
the investigation. They have disclosed also the details here at
Yes.
page 53.
Yes, my lord.
So
I
let
have
that
given
be
all the
complete
details.
first.
I have given all the details, and for this new notice,
But the difficulty is before that is completed.
yes,
the G is satisfied, so we cannot direct the setup to be done.
my lord. Then, my lord,
The setup is for other thing.
Then, my lord, kindly may direct for a stipulation for conclusion of the investigation.
Difficulties in investigations. Personally, I have some reservations regarding giving time frames. I mean, it's not possible. We are not the experts.
Yes.
Yes, definitely we can express a hope and trust or the usual thing which does not work.
That much only.
Yes.
Because, my lord, since 2021, they did not given a single notice. They did not act a single step further after that notice. And after I filed this writ petition, they are coming up with a notice in respect of a separate business organization which is owned by my distant relative. And I was employed there till 2016. After that, I left and started my new business.
Where is that language again, please? If an investigation is pending.
My lord, page
41.
41, right? Yes.
Paragraph 2C.26.1, clause C.
And my lord,
Mr. Bhumoy, tell me something. In transaction, this transaction is under investigation also.
There is no transaction. What I want to say, this paragraph,
Wait.
this paragraph does not apply in his case.
If that be so, then the setup, there cannot be any bar in the setup. We can record that.
If the bank does that.
Yes, if the bank does that. Okay.
I have nothing to do with that.
So I can record your submission that your investigation, it is going on against their concern, definitely. But that investigation has no nexus with this clause because that is not regarding set off.
Correct. Because our case is
advance receipt.
Advance receipt, against which there is no export.
So very well, no. So we'll clarify that. We'll clarify that. Yes. Nothing in this order shall prejudice the investigation. Obviously, they will continue with the investigation and it will reach its logical culmination.
And they have, my lord, the fact is this, they stated in writing to us that we have no outstanding remittance. Thereafter, when we investigated, we found from the Axis Bank that till date, $94,865.
Regarding the investigation, I'll not say a word. I cannot prejudice that.
Correct.
That will definitely go on.
Correct. And my lord will kindly also record on my submission, maybe or from the finding of your lordship, that this investigation is under FEMA 1999, where there is no such provision which enables my officer to issue any no objection certificate.
No, at least give a closure to the investigation.
Giving a no objection is very
difficult. At least give a closure to the investigation. Say bank that there is no investigation pending.
Can give an objection.
Investigation is pending.
Objection is very
My lord, they can at least say that there is no investigation pending.
Very risky.
There is no investigation.
Investigation is
no, right now pending after closure of it. I am talking about that. And your lordship kindly segregates that they are objecting to a transaction with regard to an advance.
These invoices, there is no invoice to investigate.
No investigation, no invoice.
Learned counsel
was given.
Learned. Oh, I'm sorry. Yes.
There are 32 transactions.
If there is this investigation is not in connection with this, what is the difficulty in setup?
Whether this is connected or not.
They are saying
ED says.
ED says because we have received this letter from ED wherein it mentioned that all the specific transactions in those particular accounts or the records, the documents are
that advance export.
Specifically mentioned in the order that this setup and the investigation is not, there is no connection in between. Then there is no problem to apply to the RBI to obtain the PRC, means the certificate.
We had applied.
Until the setup is done, we cannot approach the RBI. And
setup has to be done first.
Yes.
By you.
Yes, your lordship, there is no connection.
I mean, by the bank.
Yes.
If there is no connection between the transactions and the investigation, because setup means transaction. Transaction means, as of now, I have understood that all the transactions are connected with the investigation.
No, they are not referring to any transaction in this communication. The ED says.
And the details, that is.
Yes, the undersigned hereby directs, undersigned with them, directs the records stroke documents of Messrs. SB Creation and others having bank account number such and such to be categorically furnished to the undersigned within 10 working days.
Correct.
Yes.
So documents regarding the furnished that bank.
If all the transactions are not
it is very clear. They have received certain accounts which is rather apparently unaccounted for. I mean, they have received in advance, but not done any transaction in that regard. That's why their investigation is going on. Let it go on.
Our investigation is with respect to the advance receipt of US dollar,
And we have already,
where there was no export.
we have already communicated this thing. Lordship kindly comes to 61, page number 61 of the petition,
Communicate to whom?
to SB Creation. That
That?
request you to please, get in touch with, directly with ED officials.
That's why they have asked for a no objection.
Yes, that is the point.
Very
Set off is
My lord
connected.
my lord will kindly make it clear
Yes.
that the advance remittance what we are investigating, for that there cannot be any status change by the bank.
Yes. Status change means?
My lord, what they are asking for, my lord, I am again repeating. Page 41, what they are showing.
Yes.
That is not at all connected.
This has no connection with that advance receipt.
That cannot be applied. That is what I am on. And the advance receipt, what we are investigating, that advance, for that advance receipt of 94,000 US dollar, the status of those transactions of advance receipt cannot be changed.
No, how can it be?
But can you make it clear?
Learned counsel for the petitioner, please point out if I miss out anything, Mr. Paul, regarding your submission.
I'll try.
Learned counsel for the petitioner contends that the petitioner has gold transactions with foreign entities, and for such purpose, set-offs are necessary. First up, next para, by pointing out to clause C 26.1, in particular subclause Roman 2, ছোট হাতের Roman 2. C. Yes, small c of the master direction hyphen export of goods and services issued by the RBI initially on January 1, 2016 and updated till May 12, 2016, it is argued that if the invoices under the transaction in question are being investigated by Directorate of Enforcement / CBI or any other investigative agency, the process of set-off cannot go through. Next para, when the petitioner insisted upon such set-off being carried out from the end of the AD bank, the respondent bank refused to do so and sought a clarification to be obtained from the Enforcement Directorate in that regard. Next para, learned counsel appearing for the petitioner submits that from a communication dated October 22, 2021 to the petitioner by the ED, it transpires that an investigation is ongoing against the petitioner, whereas the petitioner has no connection with the to the subject matter of the investigation. Next para, learned counsel for the bank contends that since a communication was made to the bank by the Enforcement Directorate, whereby details were directed to be furnished by the bank regarding certain bank accounts of the petitioner with the respondent bank, the bank asked the petitioner to obtain such clarification from the ED.
My lord, may one thing. My lord, your lordship has mentioned that petitioner has submitted that he has no connection with such investigation. Instead of that, that is my company.
Subject matter of the investigation.
Yes, my lord. Subject matter, I am connected, obviously, because the entire transactions are made through my company.
The counsel for the petition
the investigation has not been closed.
Petitioner has no connection with the subject matter of the investigation. We sent a secretary. Continue. It transpires from the relevant clause, that is clause C 26.1 of the Master Direction of Export of Goods and Services issued by the RBI, that there is a deterrent to set off being carried out if, within double inverted, the invoices under the transaction, double inverted clause, are under investigation by Directorate of Enforcement or any other investigative agency. Next para, however, learned counsel for the ED categorically points out that the ongoing investigation, as reflected in the communication dated October 22, 2021, pertains primarily to certain receipts, certain unexplained receipts by the petitioner, comma, which have not been unaccounted for by corresponding transactions of export. Full stop. Next para. It is argued that as such, comma, the investigation in question does not relate to any invoice under transaction as envisaged in clause C 26.1 within bracket small c of the concerned master direction, and as such, comma, the ED has no authority to issue any no objection certificate as such. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is evident that the ED is justified in arguing that the scope of the investigation does not directly pertain to to the restriction stipulated in clause C 26.1 within bracket small c of the master direction, insofar as the investigation does not relate to any invoice under transaction with regard to set off as envisaged in the said provision. Push up next para. It is important to note that clause Roman 2 of C26.1 speaks about set off of outstanding export receivables against outstanding import payables with overseas group stroke associate companies either on net basis or gross basis. Pushed up. On the other hand, comma, subclause Roman I of clause C.26.1 contemplates set off of outstanding export receivables against outstanding import payables from or to the same overseas buyer stroke supplier. Push up. None of the said provisions have any nexus with the ongoing investigation against the petitioner by the ED. Push up. As such, comma, there is no occasion for the ED to give any no objection and or the bank refusing to carry out the process of set off insofar as the outstanding export receivables against outstanding import payables of the petitioner is concerned. Full stop. Next para. However, comma, it is made clear that nothing in this order shall tantamount to the bank changing the status of the, what is the expression?
Advance transactions.
The advanced transactions received by the petitioner.
My lord, one thing.
By the advanced transactions received by the petitioner. Full stop. Yes.
My lord, ED is talking about 90.
No, that is
no. To 94,000 USD advance transactions. I am asking for setting off of an amount which is more than 2 lakhs USD.
Whatever.
That is for the bank.
My lord, that may be allowed. Your lordship kindly segregates that advance payment with regard to 94,000. Otherwise, bank won't do the set off. The rest of the transactions, which it is not bothered about.
I have never said we had not bothered about.
1 minute.
Just now it is said.
It said that regarding the set off of the imports, the regarding the set offs of the outstanding import dues, those will be carried out by the bank.
No, dues will be. There are several transactions, 32 transactions.
Yes.
Out of which, according to ED,
yes,
there was an initial transaction of advance.
This will only be, they will only grant the set off regarding outstanding export receivables against outstanding import payables.
Segregating the advance amount, that transaction, let them continue the investigation.
Obviously, that has to be segregated.
Unless it is segregated by your lordship, bank won't act. Right now, they are saying. They're already saying.
They segregate the advanced receipt.
Yes.
It was mentioned in the communication also that
accordingly, WPA 25210 of 2023 is disposed of by directing the bank to go ahead with the process of set off of the outstanding export receivables of the petitioner against outstanding import payables from and to overseas buyers and suppliers by segregating the amounts received by the petitioners
in advance.
And
deeply obliged. Great.
Thank you. No rest to question. Thank you.
My lord will kindly, my lord has made it clear that the investigation will go on.
আরেকটা লাইন অ্যাড করে দিন। It
No,
is
it
further
will obviously
clarified
go
that
on.
nothing in this order shall preclude the Enforcement Directorate to carry on with its investigation, and no observations have been made herein pertaining to the merits of such investigation.
And come to a logical conclusion within us expeditiously. Well, that much on my part.
That's a status symbol. ED investigation going on against
It
you.
will go on for
You'll get more
indefinite
business.
period.
You'll get more business if the ED carries on.
Grateful.
Yes.
Deeply.
Oh, what did I say?
Original side matters. Any mentioning?
No, no mention. Call.
Listed matter, item number 1, court applications.
Yes, sir.
For the respondent number 1 and 2. This matter, my lord, had occasion to deal with, my lord, just prior to us, he was giving over for the vacation. And my lord has recorded an order, prima facie holding against maintainability, subject to seeing a copy of a plaint.
Take your seat, Mr. Banerjee. I'll just go through my order once. Please take your seats. I'll just go give you 2 minutes.
Yes.
Yes, what is that? You are the borrower.
No, I'm not the borrower. I am the person who owns
yes,
the property in question.
Which was mortgaged by the
The borrower is a purported purchaser of that property by a conveyance. His conveyance is under challenge, and the purported mortgage made by him is under challenge in this suit. The plaint of which I didn't have on the earlier occasion. Now that's there in the suit. In that suit, I have sought injunction. At the ad interim stage, it has been refused. I am up in appeal. Matter is pending. In the meantime, sale notices have been issued. My prayer was, there's only one thing which my lord has held here. I really, my lord, if one were to be an officer of court, there is everything that has been held here is gilded in gold. Only one particular thing which might militate against me is this. At the maintainability stage, saying that your legal standing depends on your proprietary right over the property, and therefore you cannot be seen to be a petitioner approaching the writ court pointing out blemishes for non-publication of encumbrances under 8.6. My lord knows 8.6 says that whenever a property is put up for auction by the bank, the secured creditor, all known encumbrances.
bank is a party to this litigation. This litigation predates the notice, and therefore they ought to have put this litigation squarely in the notice. Non-putting of that litigation as an encumbrance is the notice. I cited two.
Auction purchaser will be affected.
Yes, everyone at large will be affected because the property, the value, the viability, the zone of consideration, everything changes. If a particular property is shown to be subject matter of a litigation in which the title deed itself to the property.
Even then, Mr. Manager, how are you affected? Suppose the price decreases or increases due to encumbrance. It decreases, obviously.
Yes.
How are you affected? How are you benefited or affected by that?
That price is used to set off.
Non-disclosure of
if that price is used to set off the total loans that are there.
Yes, even then.
Any variation in that price will affect the total amount which is under.
Borrower can be affected.
Borrower can be affected.
You cannot be affected. You claim a right over that property of the borrower.
Yes, but a clear disclosure of whatever is the nature of the property.
You are not in any way affected.
Okay.
Definitely, you have taken out a point, taken out a challenge here regarding that.
The mortgage is the title deed is also challenged. The title deed by which the borrower says he had acquired title to the property is challenged. I say that myself, the plaintiff number 1, 2, and 3 in the suit.
So any prospective purchaser or some participant in that tender e-auction may take up this point.
Take up this point and say, my lord, I am asking myself this question. In auctions of this sort, even I am a prospective purchaser. It doesn't debar me from coming.
But you know.
I know.
Therefore, you don't have a cause of action of non-disclosure.
Privately, no. But then, as regards others who do not know, this, my lord, if one sees, my lord, statutory compliances, I am at one with your lordship. If this were a question of only civil disputes and a civil right and obligation, that complex would appear. If you are a person directly affected by a proprietary right infraction, you are the person who can only come up. You can't espouse the cause of others unless you champion it under section 92 or public nuisance or other things. You cannot espouse the cause of others. Your private cause of action is something which you want redressal against. Plead that, plead your relief, get your relief before the competent court. That's the law. I bow down. In writ jurisdiction, non-compliance of statutory provisions is an error. Now it has been held to be a fatal error, an error which vitiates. Now, my lord, I am one of the pool of people who could have participated. I have come up and brought this to the attention of the Honorable Writ Court. This vitiates inter alia, this vitiates the sale notice and affects inter alia me, I say, including the entire body of people who ought to have responded, who would be responding to that notice, because they would be shown a red-colored bag which they are required to purchase, when the color of the bag is actually blue. And red and blue over here have huge determinants in the market. A red bag is costlier than a blue bag.
May ultimately tantamount to black and blue for the bank.
It will black and blue for me as well.
Without showing the incomes and then
now, therefore, subsequently, Lord, in order to bring it to the black and blue stage, we are here. I am a person who's affected. My humble submission is my affectation does not get reduced, and the straight section 9 CPC approach of affectation here in the context of the present jurisdiction may require a bit of enlargement, in which I will not slip in through the door. The second part is trite. Bank says that after this, pursuant to the sale notice, there has been a sale. I have found out that there has not been registration of any conveyance. So I don't have public notice of any sale. Bank says that the transaction has taken place. That was the learned counsel of the bank's submission on the previous occasion, noted by your lordship in the second page. Now, if there's a sale, I am required to challenge the sale in an appropriate forum in accordance with law, which would depend, which might also be a forum under Article 226, if so advised, or under Section 17, as the case may be. But my right to challenge it in my present capacity of being the person who's the owner of the secured asset.
You get this injunction in that suit?
I didn't. 34 stood in the way. I have filed an appeal. In that misappeal, I am languishing, trying to show them that in cases of this nature, 34
remedy lies in this injunction, Mr. Banerjee.
Well, we are prosecuting.
You have a right in aid of this suit. Definitely have a right to get injunction. Definitely have a right,
because that emanates from my proprietary right.
That's right.
My proprietary right over the immovable property. The second part, which my lord said that the door is shut as far as you are concerned, because number one, you are a person who is not a person who would be directly affected. You are a person who are not, you are not buying your own.
The ground of challenge, at least no. That is the only ground of challenge here.
Here, my only cogent ground of challenge. Second one is non-disclosure and the fact that the bank ought to have come clean and brought the entire thing to a notice. Boils down to 8-6.
That is the ground. Rule 6 is 8-6 is there.
All boils down to 8-6. the concept was caveat venditor. Now the seller will have to also take recourse to the provisions of fair disclosure as much as provided in the statute. It's been held by 2 division benches and cited that. That law, my lord would perhaps not dispute. The only difficulty is, as far as I am concerned.
So why didn't you didn't get any injunction? You didn't prefer an appeal against that refusal?
Yes, this appeal I am told is pending.
Then your remedy lies there.
Yes, records have been called for. If I get a,
If you don't get a remedy, lies in 227.
227 again, and then
This is
I'm telling you, I'm not multiplying the same litigation over again in order to create pockets of remedies.
Don't have a locus standi here.
Here, my lord, locus standi, only on the question of locus standi. I'll tell you why, because my lord will dismiss my writ on the ground of locus standi. That might come to hit me, my lord, subsequently whenever I come up in this transaction, subsequent transaction, the sale, etc., in 17 or in writ. This
I'll
might come
keep
to hit
everything open regarding the other litigations. That is the ground on which you don't have your relief lies there.
There's just a small sliver of difference, my lord, kindly bear with me.
Yes.
In that other litigation, what my lord is wanting to secure is my right to get relief there. My right to get relief, interim or final in nature in that litigation. That would also take me home. I am on the second aspect. My right to enter the arena in order to get relief in the jacket of a complainant complaining about infraction of 86 when the complainant can be a prospective participant in an auction.
You claim a right in the secured asset.
I claim a
existing right in the secured asset.
This is that is one. That is the fulcrum. Number one. Second, I also claim to be a person in the body of persons, in the pool of persons who gets an opportunity to participate.
That would be too wide. Then locus standi does not retain any meaning.
In 86 cases, anyone who comes up, my lord. If I were debarred, my lord, kindly sees the right and remedy rule. If I was debarred by some logic, if I could not have gone into and participated in that auction, then my lord, perhaps not that particular thing would have been correct. But kindly see, my lord, from this point of view, if I am a co-runner in the race, anything else that the others can complain of is something which I can also complain of. And if the others have not done it, that can't prevent me from complaining. And if I am a co-runner, it opens the door for me to present it to your lordship. This is maintainability. Your lordship looks at it and says, no, Mr. Banerjee, your grievance, I feel, should be redressed by X forum. That's a different issue. That's non-entertainability on the ground of alternative remedy. I am on the ground of maintainability of an attack under Article 226.
Well, I'll call it not entertainable. Not maintainable, but not entertainable. I'll say that if you prefer that. Maintainability, you're right. Technically, maintainability we cannot say maintainability in any 226 for that matter.
No, if I can't show, let us say, if I can't show any sort of nexus, any connection, any legal grievance, definitely not maintainable. Here, my lord can test it in the jacket of proceeding presented by me. I am a co-runner. Other runners may have come up, may not have come up. I do not know. My right as a co-runner doesn't go. This right I gain not as the owner of that immovable property. This right I gain as a participant, as a co-runner, being a citizen who's open to participate in such an auction notice put up. Why only a citizen?
You participate at all? You did not. If you had participated, Mr. Banerjee, that might have given it has been over. The sale is over. Only the sale certificate has not been issued.
I am told that not the sale certificate is.
You did not participate. You lost your chance.
My friend says that the sale certificate has been issued. It has not been registered.
Mr. Banerjee, could you actually participate in that auction sale without compromising your rights in the suit?
Lord,
could you?
My remedy.
Would you advise your client to participate in that auction sale despite your suit saying that no, you have a title that it could not be mortgaged?
Average life of a human being, male human being in India is 72 years. The average life of a civil litigation in India sometimes is almost close to 72 years.
And don't extend it to pi.
If I don't get my interim relief, then flogging the lispendence horse for 30 or 40 years and then getting the relief will become an infructuous relief. It will be an illusory relief.
You could not have asked for that. You could not have participated in the auction without compromising your suit.
Yes, I had every right to participate in the auction. No one can. I can
say that the mortgage is bad
and
to participate in the suit on the basis of that mortgage.
Suppose I acquire whatever title is there because that gives me peace of mind, and conclusion of transaction. My lord, kindly.
Sufficient arguments.
Kindly ask this then.
Not entertained.
My lord, on this, if your lordship kindly does not hold that it is not maintainable.
Not entertain. I'll not entertain.
Lordship does
I'll
not
give the
entertain
reasons.
The lordship does not entertain it on the ground of availability of some remedy.
I'll think about the reasons as I go on dictating.
No,
but I've clarified to you, Mr. Banerjee, these are the reasons basically. First of all, you don't have any locus standi. Secondly, you could not theoretically have participated in the auction at all, and you did not participate.
I did not. Whether I could have or could not, would your lordship kindly keep it over? I'm only saying this for
hypothetically, not even obiter. I mean, my thoughts.
Would your lordship kindly keep
my
that
formal thoughts?
Formally keep that door open for me, in subsequent litigation, so that I don't get hit by this order or no sort of.
Then you have to compromise your suit. I'll say that you can compromise your suit, your rights in the suit, and then do it. I mean, in law, you cannot do both together.
Yes, I have challenged a particular deed of the person who's the borrower. Keeping that suit alive, I cannot participate in that particular sale by which through his title I will get title. I can understand that. But I may choose to do it. I may choose to do it if I find that that is a larger procedure practically. I can abandon that and take title from here. That is something which I may choose to do. My lord, this is something, these and ancillary issues, my lord. If your lordship, my lord, rejects my application, which your lordship, my lord, would perhaps do, kindly, my lord, rejects it in a manner that it doesn't affect any of my other.
Very difficult. The nuances I can't manage so much.
I leave it to your lordship.
Then counsel for the petitioner contends that the petitioner stakes a substantive claim in the property which was shown and this as the secured asset by the borrower in question for getting a loan. First up, for non-repayment of such loan, the secured assets were put up on auction sale by the respondent bank, challenging which the present writ petition has been preferred. First up, in the meantime, it is pointed out by the bank, the auction sale has gone through, although apparently no sale certificate has yet been issued.
Sale certificate has been issued a month ago.
Oh,
not registered.
Although apparently থেকে যেখানে বললাম, although apparently থেকে যেখানে বললাম, although থেকে কেটে দিন, although থেকে কেটে দিন, ওই sentence continue, and a sale certificate has in fact been issued in favor of a third party.
May I hand over a copy of the sale
No,
certificate?
you're saying I'll record.
May I just take a copy? So at least
Keep it with you. Keep it with you.
May I just take a copy? Just take a copy.
Have you got extra copies?
Yes, yes.
If he has a copy, then hand over to the court also. I'll have to give it.
I will just.
A copy of the sale certificate is handed over by learned counsel for the bank and is kept on record. First up, next para. It is contended by learned counsel for the petitioner that as a prospective participant in the e-auction sale, the petitioner has every right to point out the infirmity in the process of sale, primarily being the violation of Rule 8.6 of the relevant rules. First up, next para, it is argued that as per Rule 8.6 of the security interest within bracket enforcement bracket closed rules, 2002, any encumbrance in the property has to be clearly disclosed in an auction sale notice, which was not done by the petitioner, by the bank. First up, the pendency of two suits at the behest of the petitioner is sufficient encumbrance to have been disclosed, non-disclosure of which clearly vitiates the process of sale. First up, learned counsel cites নামটা দিয়ে দেবেন reported at এখানে আছে reported at 2017 SCC online MAD 1549 for the proposition that Rule 8 within bracket 6 within bracket small a and 8 within bracket 6 within bracket small f are mandatory in nature. First up, the purchaser should be put on specific notice about all the encumbrances and other materials so as to enable him to take a conscious decision with regard to his participation in the auction and the amount to be quoted in his bid. First up, the disclosure, it was held, is not an empty formality, and the auction notification is defective and improper in case the encumbrances and known litigations are not disclosed. First up, next para. Learned counsel also hands over a copy of the plaint of title suit number 988 of 2022 pending before the fourth court of civil judge junior division at Howrah, initiated by the petitioners, where the bank is also a party, comma, inter alia seeking the relief that the charge and or mortgage created over the subject land in favor of the defendant number 3 therein is null and void. Full next para. Learned counsel next cites the judgment of Devosri Das versus State of West Bengal, where a division reported at 2011 1 CHN 10, wherein a division bench of this court observed that where a citizen of India has been harassed and was dispossessed from his lawful property at the instance of a financial institution who had acquired no interest over the property in question, so as to enable it to exercise power conferred under section 13 within bracket 4 of the Surface Act, comma, such a citizen is not required to go to the alternative remedy provided under section 17 of the act. Full stop. Next para. Learned counsel for the petitioner next cites a judgment of a coordinate bench of this court reported at 2023 SCC Online SC 95, where it was observed inter alia that where the controversy is a purely legal one and it does not involve disputed questions of fact but only questions of law, comma, then it should be decided by the High Court instead of dismissing the writ petition on the ground of an alternative remedy being available. Full stop. Next para. In the backdrop of the above judgments, comma, this court now considers the entertainability stroke maintainability of the writ petition. Full stop. Learned counsel for the petitioner is justified in contending that there is no absolute bar to maintainability of a writ petition under certain circumstances, comma, just because of availability of an alternative remedy. For next para, the question is whether the court will resort to a self-imposed restriction where an alternative remedy is not only available but has been availed. Full stop. The present question also revolves not only around entertainability but also the locus standi of the petitioner to prefer the instant challenge. Full stop. Next para. It is an admitted position that at least one suit is pending at the behest of the petitioner, where the bank is also a party, comma, challenging the very charge and or mortgage created over the subject matter in favor of the bank. Full stop. Next para. The petitioner has canvassed his title, comma, which is the plinth of the relief sought in the said suit. Full stop. Next para. In the event the petitioner is correct in submitting that the petitioner has a right to participate in the auction sale of the self-same property by the bank, comma, which is on the basis of the self-same mortgage which is challenged in the suit of the petitioner itself, comma, the same will create an absurdity, comma, unless the petitioner elects to abandon the relief claimed in the suit. Full stop. In the said suit, comma, the primary relief, comma, based on the title of the petitioner in the property revolves around the declaration that the mortgage created of the subject land is null and void. Full stop. Hence, comma, an abandonment of such relief will tantamount to the petitioner having the suit dismissed for non-prosecution, which the petitioner chose not to do till date. Full stop. Next para. On the other aspect of the matter, comma, the petitioner, comma, naturally, comma, did not actually participate in the auction sale which was conducted by the bank and has now attained finality by issuance of the sale certificate. Full stop. Next para. Hence, comma, theoretical conjecture on what could have happened if the petitioner had participated in the auction sale carries no present meaning apart from being an academic discussion. Full stop. Next para. In any event, comma, as discussed above, comma, the petitioner would have to compromise on the entire claim made in the suit still pending, which is still pending, comma, in order to enable the petitioner to participate in the auction sale. Full stop. That apart, comma, the petitioner definitely has knowledge of the pendency of the suit, which is the encumbrance as claimed to attract the provisions of Rule 8 within bracket 6. Full stop. Since the petitioner itself had knowledge of the same, comma, the petitioner does not have the locus standi to urge that non-disclosure of such within single inverted encumbrance of litigation could vitiate the auction sale insofar as the petitioner is concerned. Full stop. Next para. Hence, comma, the petitioner does not have locus standi to prefer the present writ petition at all, comma, being not affected, comma, since the petitioner is not a participant in the auction sale at all. Full stop. Next para. That apart, comma, the petitioner has prayed for an interim relief of injunction as well as a final relief to the tune of injunction in the suit which has been discussed above, restraining the defendants, comma, including the bank and its men and agents from dealing with any part or portion of the suit property, comma, which is actually the secured asset of the bank. Full stop. Having failed to obtain such an injunction, comma, the petitioner cannot resort to the present writ petition to get indirectly what it could not get directly. Full stop. A subtle distinction has been sought to be drawn quite ingeniously by learned counsel for the petitioner between the personal right of the petitioner with regard to the claims made in the suit and the rights of the petitioner as a citizen in general to bring to the notice of the writ court the flouting of Rule 8 within bracket 6 by the bank in the auction process. Full stop. However, comma, the interests of the petitioner merge in such respect, comma, since the claim of the petitioner to the property and the claim of the petitioner as a prospective participant in the auction purchaser clash and are mutually exclusive, and it cannot be said that the subtle distinction sought to be carved out by the petitioner has any germane effect on the present adjudication. Full stop. Next para. In such view of the matter and also keeping in view the fact that the sale certificate has already been issued pursuant to the auction sale which was sought to be challenged in the writ petition, comma, this court chooses not to entertain the writ petition on the ground of non-entertainability at the behest of the petitioner as well as lack of locus standi of the petitioner. Full stop. Hence, WPA 1693 of 2023 is dismissed on the grounds as indicated above without any orders to cost.
So only one submission, my lord.
Yes.
Your lordships kindly see the paper publication of the sale notice by which, my lord, my learned friend was alleging that order a Rule 8.6 was not complied with the right side of the year that the suit is pending. Whenever bank has, my lord, came to learn regarding the pendency of the suit, my lord, that was there.
22
And
suit
number
is not
two is, my lord, his only suit is only for 3 feet. 3 feet place, my lord, that is the main case of the main.
That's the
Anyway,
after
after
not
the
the
order is
22.
passed. Thank
My only one friend.
Yes.
The observations that your lordship has made are only for this purpose, but will not affect me in the suit.
Now, how can this affect you in any event? It cannot affect you anywhere. The premise of this order is that your right lies elsewhere. So how can that be affected?
May I have, my lord, a copy of the sale certificate? I can make out a copy right now.
Give another copy to him.
My lord, may I take a copy of the plaint which he has not given?
Yes.
Exchange copies.
Definitely.
Call on the next one.
Item number 2, Tirumalla Spinners Private Limited versus Bamalori and Company Limited.
Yes, Mr. Da, what is it?
So,
You're for the
dispute,
respondent.
I'm for the respondent number 1. Dispute arising out of warehouse contract.
Right.
Well, the dispute actually related with the invoices which has been, according to us, inflated invoices and not in accordance with the contract. My lord, the thing is this dispute has been arose in the year 2022, in the month of December. We have been constantly complaining of all these disputes regarding services and etc. everything. My lord, what happened? They have formed a committee behind our back, and they did not inform us. No opportunity of hearing, no decision has been communicated, and straight away issued the inflated bill, impugned bills for payment. And when we raised a specific dispute, indicated them that they please convey all the
But this is a money claim. I mean, how
not
can
money claim, my lord.
they have claimed money? You are asking for an injunction of that, basically.
No, my lord. My lord, my application is this. I have filed an RTI applications and asked them to convey all these reports and the committee decisions, etc. They
Mr.
have
Kam,
not.
we cannot go into this in a writ court. How can we? Because they have made a money claim. They say certain amounts are due from you. The papers have to be gone into evidence has to
My
be
lord,
taken.
the committee has taken a decisions. No opportunity of hearing has been heard.
Where is the
given.
decision? Where is the decision? Please
My
show me
lord,
that.
that decision has been communicated to us. My
What
lord,
is that?
My lord,
Must have
my lord,
annexed it.
my lord, kindly see the reply of the RTI, page 187, my lord. Kindly see at volume 2. What I am on, my lord, kindly give us the opportunity of hearing, because the committee has taken decision on the basis of my complaint.
No, where is the complaint?
Complaint, my lord, on page 30 onwards. Page 30 onwards.
What is
My
the
lord,
crux of the complaint? What is the
crux of the complaint, my lord? The area. One is a fixed area, another is a variable area. We are tenant to with regard to the fixed area, and we have
you
been,
use their warehouse?
yes,
Right.
and the dispute with regard to the area, variable area. It is a container contract basis. And they raise the invoices, inflated invoices, the area measurement, everything.
Was
My
there
lord,
any arbitration clause between you?
no, my lord. My lord, the page number 49, 51, 55, 62, 69, if your lordships kindly consider that, that indicate the disputes with regard with the measurement of the area. And pursuant to such disputes, such complaint, my lord, they formed a committee, and no opportunity of hearing has been heard.
Committee decision is at page 187.
No, my lord, that's the informations given to us pursuant to the.
You have not got any copy of the committee decision?
No. No opportunity of.
Oh, they say that it cannot be made public to protect the.
Yes.
Yes, how can you say that?
May I just indicate his initial complaint, if your lordship see page 32, he says, I have made a complaint against your officers. How can he be there? He's still in the company. These are the complaint, my lord. He goes on, my lord, vigilance. What he's trying to project before today, your lordship, is regard to, my lord, the area. That was not the complaint.
Yes,
never
that was
raised that
there. That
complaint.
was there.
That
Page 49.
May I just indicate, my lord, my learned friends, the letter start, my lord, you will see this is the beginning. Page 32 is the first letter. Mr. Seth, I'm surprised to see
The
Mr.
beginning, let us forget the beginning. Let us come to the end. They have stated in several communications.
May I just indicate, Milord?
Yes.
We have asked them to be present in Milord a joint measurement. He says I cannot be made remain present.
Without giving them a hearing, you cannot.
Yes, we have asked them. If he do not Milord turned up, Milord, what can I do?
Where is that?
My lord, you'll see. First, initially February, Milord, the measurement one done.
You say that the details of the committee cannot be made
That
public.
is not with regard to Milord. This complaint with regard to area, that was never a committee for. He made a complaint in CVC for vigilance. That is what I'm showing, my lord.
That is different. That has no nexus with
That
this.
has not, my lord.
No,
My
nothing to do with this.
My instruction is that the committee the report is this saying is nothing to related with, my lord, the area measurement.
My
Because area
complaint is
measurement
with
has been
regard
done
to the
upon
area
giving him
measurement.
prior notice.
My complaint is with regard to the
Where is
area.
that complaint? Is area measurement?
My lord, page 49, kindly see, my lord.
49.
Before that, my lord, you'll kindly see page 45.
No,
my lord.
49. Let us see.
Page
Yes.
45. This is, I am calling him for my measurement, my lord. He do not turn up. Then page 47, he say, I'll not be possible to appear, my lord. We share, my lord, the joint measurement report at page 49. These are my report. What he has, my lord,
The page 49 is their email.
is my report.
Oh.
Obhrujit Shet is my officer. I shared it with him. Before that, I asked him to be present.
We raised the dispute.
My lord, asked him to be present. He do not remain present, my lord. Thereafter, my lord, I shared it with him. He, my lord, then disputed. Thereafter, again a meeting was held. He again turned up. Then, my lord, when it was found excess, he did not sign and went away, my lord. And, my lord, I have the photographs. What was given to him, my lord, he is enjoying the excess and he has to pay for it. My lord, if your lordship sees these photographs,
not necessary. What is the penal measure contemplated?
Milord, I can hold the good. I am not releasing the good unless I am getting the money, Milord. Today, Milord, even Milord, there are two parts. One is Milord monthly rent, one is Milord variable rent. He has stopped making payment even the monthly rent.
No, that's not
my instruction, Milord. It was appeared just before the vacation the day. As on that date, Milord, it was 17 lakhs of rupees which they have due and payable to me.
What is the other rent they're not paying?
There are two parts, Milord. There are one part where there is a aisle, Milord, and there is a area passage, and other is, Milord, the variable. That whatever amount the quantity
The dispute is regarding the variable.
Both. Because in the aisle we have given a passage.
No, Mr. Da, you have to approach the civil court. We cannot interfere.
Milord, an opportunity.
Approach civil court.
Committee has been formed behind our back. I am not asking for any monetary relief. And they have withheld our 1 crore rupees of worth of 1 crore rupees, the goods of worth of 1 crore rupees,
time to appear
12 lakhs rupees.
We don't even, you haven't even annexed the report of the committee. What is
Report of the committee has not been communicated to us.
The report has nothing to do with, Milord.
Constantly they are saying like this. It's an vigilance, it's an vigilance.
My lord, see, I have shown, Milord, page 59.
What is your decision regarding this?
That is why I'm telling, Milord, there was no committee formed. That was for other purpose.
Look,
that is, Milord, kindly take page 32, Milord. These are the reasons, Milord, a committee was formed. His case is not today. Milord, page 32, he makes a complaint against my officer. Said, I made a complaint earlier occasion.
How are you mixing up those two?
He has done, Milord. My lord,
he is not saying so. Vigilance committee, vigilance reports may be there. His complaints regarding your officers may be there.
Yes.
That is on a different footing. Why are you mixing up the two? He has also alleged regarding the areas which is in
that is, Milord,
the only German thing. Let us forget the vigilance report.
Initially, Milord, on April, Milord.
Where is your adjudication on you? Have you given him a hearing on this area? And
I have asked him, the pilot, you kindly see page 59. I have asked him to meet me. My office. He went there. We made another measurement. Then also he did not sign.
No.
Pilot will page 59 and onwards. Refer to page 59, Milord. In case there is a doubt, you may set up a discussion on a predetermined date within 5/4/2023 to clarify all doubts. This is my letter, Milord. He then says, Milord, I will come on 12th of April 2023. Page 60. And then, Milord, another, Milord, measurement was done. Then he started, Milord, saying that though this measurement was incorrect, and we have given a reply to him on page 71, Milord.
After the dispute, Milord, we raised a specific complaint saying that the committee has been formed and you have decided all these things behind our back. And for that, we raised an applications for RTI. And they have communicated to us at page 186 and 187.
Committee formed for what?
Committee formed to dispose of our complaint.
Complaint regarding?
Complaint regarding measurement, complaint regarding
measurement, a committee is being formed.
Yes.
Or regarding vigilance.
They are saying like this.
Where have this?
Kindly see page 186. They have replied to our RTI applications.
Let us see that.
The final report of investigation is for internal consumption and cannot be made public.
That is regarding the allegations against the officials.
Not only official, they
no reflection here.
Milord, the complaint is twofold. One is service, another is measurement. Their entire grievance is this twofold. One is service.
Yes, some of the replies pertain to that also.
Yes. And now they are saying like a different thing. It is not true. It is not true.
Where will file your affidavits? Any interim order, Mr. Da?
My lord, my goods worth of rupees 1 crore are being withheld. I am submitting, my lord, 12 lakhs rupees, worth of 12 lakhs rupees may be withheld and rest of the amount may be released.
He has to pay
My entire business has been stalled.
How soon can you file affidavit?
in 2 weeks, Milord.
A report, a report.
No, 2 weeks is very reasonable. Learned counsel for the petitioner raises certain important issues and disputes as to the respondents allegedly withholding the goods of the petitioners on the basis of alleged unpaid charges on the part of the petitioner. First, it is contended that the petitioner raised specific disputes as to the square feet to ascertain the square feet of area used to ascertain the variable payables, comma, which was apparently decided by a committee of the respondents behind the back of the petitioners without giving any opportunity of hearing to the petitioner. First up, next para, learned counsel for the respondent number 1 disputes such allegations and submits that the petitioner's allegations were primarily relating to vigilance and certain purported acts of the officials of the respondent number 1 and had no nexus with the square feet. First up, insofar as the measurement of area is concerned, comma, a joint inspection was held upon which a report was furnished. First up, it is submitted that despite being invited to join, comma, the petitioner chose to abstain from the inspection of the area. First up, since certain arguable issues have been raised by the parties, comma, the respondents are directed to file their affidavit in opposition within November 30, 2023. First up, reply, if any, shall be filed by December 7, 2023. The matters shall be listed for hearing on December 11, 2023.
Interim order.
What interim order?
Kindly ask them to release my goods.
No.
At least a half of it. At least a half of it.
No.
It's a 50 lakhs of rupees.
Wait till December.
My
First
business has been jeopardized.
No, interim order.
Kindly.
That will be amounting to granting the main relief.
Affidavit of service.
Affidavit of service filed today be kept on. Hey, okay, affidavit kept on record.
I'm grateful.
Thank you. Next.
Item number 3, Dalmia Securities Private Limited and another versus Calcutta Stock.
My petitioner and my GA, at the outset, my lord, I have a slightly unreasonable request. I was being led by Mr. S.N. Mukherjee. He is not in the country. He's supposed to come back tomorrow. May this matter be taken up anytime next week, subject to your lordship's convenience.
Whenever you say.
I wouldn't be standing in the... If he was...
For the petitioner?
Yes, I'm for the
On the prayer of the petitioner, the matter is adjourned till... when? Tell me. 22nd November?
Very well, my lord. Whatever comments...
Till November 22, 2023. Grateful.
I'm so grateful. Thank
you. Item number 4, Lord's Blue Tech Company Private Limited and another versus the authorized officer Export Import Bank.
Yes, my lord.
My lord, I appear for the petition.
Your lord, actually. You are for lord.
I am for lord.
Yes. And
My
you
lord,
are
I
for
am
the usual
challenging.
victim.
I am the victim.
The usual victim of Mr. Dutt.
No, I am the victim, my lord, here for a change, my lord. My lord, I am challenging, my lord, a rejection order which lordship will find.
No, you don't have Lucas Sene to appear for any bank. You can only appear for SABY. Yes, what have they done?
My lord, I am a borrower.
Right.
My lord, 13-2, 13-4 proceedings initiated. I
Very
went
good,
to my lord
excellent.
DRT with a SARFACI application under 17.
Yes.
My during pendency, my lord, bank took steps for sale of the property. My lord, borrower, the secured creditor got a purchaser. My lord, who deposited 1,81 lakhs towards the property. At that stage, my lord, DRT stayed the process. Till there, my lord, the money was deposited. That is, my lord, the stage of the proceeding before DRT. Then, my lord, there I wrote, my lord, 2 letters to the bank asking for a one-time settlement. I proposed and I asked for a settlement. My lord, ultimately, bank did not respond. I come to the writ court. Writ court says you have not responded to the letters. Give him a hearing and take a reasonable decision.
You can match that amount.
My lord, after that, my lord, after the writ court's order,
they have, my lord, entered into a one-time settlement.
Oh,
The figure is, my lord, crystallized. The only issue here is not the amount, but the, my lord, mode of payment. My lord, because there was, my lord, a auction purchaser, a party who had already, my lord, proposed 181, the settlement amount was 2.10. I said that I am already, my lord, not in a position to pay the dues. Sell the property to the purchaser. Balance I will pay. I write this letter to them within the validity period of the settlement. They reject it only on the ground that
sell the property to the purchaser, so they'll sell.
it's my property ultimately.
They
My right
realize,
of,
yes.
no, my right of redemption is there.
Right.
My lord, if I could have, my lord, the moment a 13.2 is issued, my lord, by reason of 13.13, my lord,
You
there
say
is
you
a
pay off the rest of the amount.
I pay the rest of the amount. That is the, my lord, proposal which I gave. So, my lord, the figure stands as it is. The bank receives whatever money bank had.
So
My lord,
isn't it a win-win situation for them, or do I miss something? I mean,
no, it's a win-win situation for both of us. My lord, bank is not losing anything because bank gets, my lord, the entire settlement amount.
How could you be affected if you don't pay? I mean,
My lord, I
other
get
properties,
affected.
Other properties.
There are no, my lord, leaving apart other properties, my lord, I want to, my lord, be released of these, my lord, liabilities. My lord, the one-time settlement is, my lord, the dues, actual dues are something much more than what has been ultimately agreed to.
Obviously, yes.
So, my lord, bank has agreed to that figure.
So now what is the issue?
The issue is, my lord, they are not agreeable to this, my lord, mechanism that property sold to the person who has deposited the money at 181 and balance 1.81 crores and balance money I pay. Bank is not losing on money because bank is getting 2.10. The purchaser was also willing because the money he had, my lord, indicated the order record that he was willing to deposit. Now, my lord, at this stage, my lord, can bank reject?
You cannot dictate the terms to bank.
I am not dictating, my lord. I am not
Bank
dictating.
says you have to pay the entire amount.
My lord, in law, my lord, I understand my difficulty. In law, I was only looking at this, my lord. There are two things, my lord, factually here. One is 13.13 staring at my face. Unless bank permits, the secured asset could not have been sold because there is an automatic injunction. Second, my lord, there is an order of the tribunal. I could not have. So in any event, even if, my lord, there is a one-time proposal and I go and tell the bank that I want to meet the liability
They are
by
not losing
disposing of.
anything. They are getting the money, the total money.
I am losing the property, but at least I am getting discharge of the bank's liability. This is, my lord, the rejection why I challenge.
Why can't you agree to this?
My lord, firstly, my lord, kindly comes to page number 46, my lord. Just make two. Firstly, my lord, actually, my lord, I want
Because they lose if they pay the entire amount, they get the property and pay the amount to you.
Initial submission is on regards to the jurisdiction of this court, my lord. My lord knows which.
If you agree to this jurisdiction,
my lord, my instructions are not. We are not agreeing to this, my lord. The facts, my lord, I'll my lord submit before this court. My lord, kindly comes to page number 46 of the petition.
46.
My lord, kindly sees, my lord, the terms and conditions of the settlement, which, my lord, term number 3, my lord, it's within 20 days of receipt of this letter. They have to make the payment. That is 2.10 crore. My lord, their loan amount was 9 crores, to which, my lord, the OTS has been given to 2.2, 2.10. That is what has been proposed to them by them to us after the order of Justice Bhattacharya, my lord. So, my lord, the bank has actually accepted the amount which they have said. Now, my lord, they have paid that 5 lakhs which they were supposed to pay. At this point of time, my lord, they have said nothing about all this, my lord, to how to make the payment and how to receive it, my lord. Now, my lord, just before the expiry of, my lord, the 20 days, that is of this letter, my lord, is of 27 December 2022, my lord. So, my lord, before the expiry of this 20 days, my lord, on 6th, my lord, that is just after the 7 days has passed, they are giving us this proposal, my lord. So now, my lord, there are a lot of judgments. My lord also knows that bank has the right to reject it. Once, my lord, they have not accepted it. But this option of their making payment was not given to the bank at the time of entering into this OTS settlement, my lord. It's just after the OTS settlement has been come into, and at that point of time, they suddenly feel that let's sell that property.
Suppose the OTS does not go through, you do not agree. What happens then?
My
You
lord,
sell the property.
becomes due. The whole amount becomes due, and we are going to sell it, my lord. And that's the reason.
You sell it but can't recover the entire amount.
Yes, my lord, because there is a stay. And my lord, in any case, my lord.
What is the total amount? The
My lord,
property
now
will fetch only 1 point something.
No, my lord, now the due is, my lord, around 13 crores with interest and all.
So you will get only 1.586 something from that
That
sale.
is, my lord, what they are saying, that from the sale we are getting 1.86, which they contend that is a lesser amount. They contend that it's the property is of a higher amount. So, my lord, they can very well sell their property if they want. And but one of the crux of my submission is that my bank is not going to enter into selling of a property, getting some money from the property and rest with them, because my lord, the bank knows that they are not going to pay the rest amount, my lord. It's going on for a very long time. And my lord, they are
Malad,
not
if
going
that
to
is
pay
the
the amount.
situation, I undertake to first, Malad, keeps it pending. I undertake to
they
deposit
accept the
here.
So we don't have a legal right to enforce the bank to
And my lord,
accept
they're
your
forcing
OTS.
the bank to take
These are
it.
new
Since I
OTS
did
you're
not,
saying.
Malad, get the opportunity to show documents, 3 documents I want to show your lordship.
Can the court compel them to accept your, because
Malad,
this is a
this
new
is,
proposal.
Malad,
New
right of
proposal.
redemption is a, Malad, constitutional right now recognized under Article
Right of
300.
redemption, you get a right of redemption.
It's a right which is recognized under the constitution.
But you are not proposing a right of redemption
My lord,
as such.
my predicament is that I am out of fund today. My lord, lordship kindly realizes
So for
I am.
redemption, you will have to pay the entire amount.
My lord, I understand 34 principles. Lordship is.
Yes, definitely. And what you are seeking, that's a new.
No, my learned friend
new
said,
proposal.
I
They're not
never,
agree.
my learned friend says, I never said that this is the mechanism with which I wanted to, my lord, settle the dues. That is possibly not correct.
See,
when I come to writ court, my lord, with those 2 letters, my lord, kindly gives me, my lord, 2 minutes. I want to show, my lord, 3 documents.
Right.
My lord, kindly comes to, my lord, page 30, my lord, page 33, 34. This is the order of the DRT.
Right.
8th of December 2020. A second paragraph. Advocate Mr. So-and-so appears for the bank, submits that rupees 1 crore 81 lakhs has been received from the purchaser. My lord, he is the purchaser.
32 you say?
My lord, 34, my lord, 8 December 2020. 32 is the first order. My lord, for the time being, I need not, my lord, trouble your lordship with this, because court permitted to go with the sale process, not to finalize it. That was 32. 34 records, my lord, 1 crore 81 already received. This is prior to, my lord, the OTS being sanctioned. Then, my lord, status quo order, my last penultimate, my lord, sentence, status quo order passed earlier stands extended. So, not to give, my lord, confirmation. Now, my lord, kindly sees one letter prior to OTS, which was considered by the writ court, the first round of writ petition. My lord, 36, the letter starts. One paragraph, my lord, at page 37, the third last paragraph. Third last paragraph, starting with the payment, my lord. My lord has found it.
Page 36.
36, the letter starts, my lord. At page 37, my lord, the third last paragraph.
Yes.
The payment will be made by an authorized party on behalf of a company to whom we will sell mortgage our property, which is currently mortgaged to you. We also like to encourage bank to issue NOC against our dues if you accept our proposal. I reiterated this in another letter at 38. I am not bothering your lordship. Last representation was 40. Then, my lord, the writ court's order, my lord, first order at page 41. My lord, the paragraph starting with, however, the penultimate paragraph. Since there is nothing in writing forthcoming from bank is directed to give a hearing to the petitioner so-and-so at a designated time to be informed by so-and-so. Bank shall dispose of request of the petitioner by way of writing, which is to be given to the petitioner within so-and-so. Now, after this, my lord, this order, my lord, we approach the bank and bank gives me this OTS. The terms of the OTS, which my learned friend shows, my lord, kindly comes back to 46. Clause 2 and clause 3. Settlement amount is 2.10 crore, out of which 5 lakhs I have already paid. And payment schedule is 20 days from the date of this letter.
You failed the OTS.
Now, my lord, this OTS, when this OTS amount 2.10 crore is being, my lord, this amount is being crystallized. Bank already has in its possession 1.81 plus 5 lakhs, which I have paid. I only say that I will abide by this, my lord, amount. I will abide by the payment schedule. I write within this 20-day period, which is granted in the payment schedule, that please accept this because the purchaser is also willing to buy it. This is the only modality of payment.
You brought the purchaser.
My lord, the purchaser was, my lord, in the SABYASACHI proceeding.
Right.
I don't know, my lord, whether I brought it or, my lord, the purchaser was there. But, my lord, the purchaser was there and purchaser was willing to purchase the property at that same price, 181, which bank was retaining. My lord, what would have bank done? My lord, if I had, my lord, paid this 2.10, bank would have returned 1.81 to the purchaser, saying that no, OTS has been, my lord, arrived at.
Balance 2.10 minus 1. Whatever.
2.10 minus 1.86 it has to be, my lord, because 5 lakhs I have deposited. So that comes to around 24 lakhs. No, 14 lakhs. 14 lakhs. my
14
lord.
lakhs.
How soon can you pay it? Pay by tomorrow, day after tomorrow.
It's 24 lakhs. 24 lakhs. I'm sorry.
24 lakh, pay by Saturday. Come back on Monday.
What client is it?
Agree to it. Your OTS is being fructified, basically.
My lord,
You agreed at 2.10, right?
My lord,
Now
we agreed.
1.81 is already in your hand, 1.86.
My
They'll
lord.
pay the entire amount the OTS because you are to recover money. If otherwise if it fails, suppose the OTS fails, what happens?
My lord,
You
the
sell
whole
the property at 1.81.
Yes, my lord. We sell it, my lord. We get the money, whatever it is, that the sale proceed goes on, my lord. In that case, but my lord,
you will have to go on selling other property.
My humble submission, my lord, that if this order is passed by this court today, my lord, tomorrow all the borrowers will come together in this court and ask the same order, my lord.
No, I am only.
But my lord, the
only
whole
my statement comes only because you agreed to 2.110 crore as recently as on last December.
my lord,
Not
that
recently, not
because of my lord, there is a my lord, their account has been my lord declared NPA, my lord. After my lord NPA, my lord, they have no right to ask for any
definitely.
OTS.
Otherwise, what is the
So,
question
my
of
lord,
all
it's
this?
only because of this High Court's order, Honorable Court's order, my lord, we have given them an OTS as per their choice, my lord, in which my the bank is actually losing.
No, High Court
on
did
the
not say that.
High Court only said to consider.
We have considered. We have considered and listening to their hearings, my lord, we have considered it to be a 2.10 crores.
No, you apprehend that they would be failing again.
My
Now,
lord,
you have this 1.81 is already in your hand. So
My
there is no question of the purchaser resulting from that. Now, if they pay the entire amount, if that be a precondition, because I can keep the writ petition pending, they can pay
I
that
will
amount.
first satisfy payment, then my lord
They'll
will
have
ask
to
for.
pay that amount only then.
My lord, I will just take instructions. Keep
Please
this
take
matter
it.
tomorrow, my lord, I'll just take instructions.
Fair enough. Learned counsel for the petitioner contends that as per a previous direction of a coordinate bench, the bank agreed to a one-time settlement to the tune of rupees 2.10 crore, out of which rupees 5 lakh was paid by the petitioner. However, the petitioner failed to pay the balance amount in time, for which the bank is resulting from the OTS. It is further pointed out that already a purchaser has come up to purchase the secured asset and has deposited an amount of rupees 1,81,00,000 as purchaser, which is in the hands of the bank. First up, learned counsel submits that the petitioner, although failed to honor the OTS in time, is agreeable to pay the balance amount after the purchase on consideration of rupees 1.81 lakh. It should be crore.
Crore.
1.81 crore goes through. First up, next para, learned counsel for the bank submits that the petitioner has failed to honor the OTS and is already a defaulter. First up, as such, it is contended that the petitioner cannot claim any right to compel the bank to accept the terms of the petitioner. First up, it transpires upon hearing both sides that the option given by the petitioner to the bank is not altogether unfair. First up, insofar as the consideration for sale of rupees 1.81 crore is concerned, the same is already in the hands of the bank, along with rupees 5 lakh, which has been cleared off by the petitioner. First up, insofar as the balance amount out of rupees 2.10 crore is concerned, the petitioner can be directed to pay such amount within a limited period to show his bona fides, upon which the bank may agree to the satisfaction of the dues on the part of the petitioner. First up, next para. In any event, the cardinal aspect of a recovery proceeding is, as per definition, recovery of the amount. First up, if the bank can recover at least a substantial fraction of the amount, even in terms of the OTS agreed by the bank previously, the bank cannot be said to be affected heavily insofar as recovery is concerned. So be that as it may, comma, in order to enable learned counsel for the bank to take appropriate instructions on such issue, comma, let the matter stand adjourned till tomorrow.
My lord, keeps it on Monday because it's a
Let the matter stand adjourned till November 20, 2023, when it will be listed under the same heading.
Grateful, my lord.
Take instruction. If you take instruction that yes, this can be, otherwise you will have to go through another, I mean, the sale will go through in any event. They will not be able to redeem, but you will have to go recover the rest of the amount also.
My lord, I'll just take instructions.
Take instruction about the balance of convenience on your part also. I'll direct them to put in the amount maximum within a fortnight, Mr. Dotto.
Very well. I will not, my lord. I'll
Take
put it
instruction.
within, my lord, that time. Less 5 lakhs, which I have already deposited. Grateful, my lord.
সব বলেছি টপে না নর্মাল হিয়ারিং লিস্টে থাকবে নর্মাল
Item number 5, MK Developers versus Union of India.
Yes, Mr. Dotto.
My lord, item number 5, on behalf of the author of Banerjee, on behalf of the respondent, my lord.
You are there.
I am feeling for not today, my
You
lord.
are there. You are also on the
No, my
panel.
lord, only full satisfied, my lord, author of Mr. Author of Banerjee. He is a senior advocate, my lord.
My lord, I think they are not opposing my writ petition because they are not filing their opposition in 2 occasions. You are giving, in last occasion, your lords, you given the extension as a last chance. If they are not opposing, then my lord, my can be heard and be necessary order be passed.
Affidavit in opposition has not been filed.
Yes. Despite 2 occasions.
He will be in a difficulty. I'll keep it tomorrow.
Yes, I have.
What happened to him, Mr. Banerjee?
My lord, he is doing another matter, court number 15. Plus,
We'll wait for him. Tell him we are waiting for him. Whenever he finishes, we'll wait.
I inform him, my lord.
Possible.
Court applications. Item number 6.
Item number 6 and 7, mother, I am being led by Mr. Orajit both on this matter, mother. He had to leave early today, my lord.
Not today, not today.
Mother, kindly gives me 22nd, my lord.
Why 22nd?
Mother, this is what he has requested, mother.
Tomorrow, if not tomorrow, then Saturday. Saturday you have court.
My lord, can it
Well,
be
kindly
kept any day after 23rd of November?
After 23rd, you ask for 26th.
22nd, my lord.
On the prayer, order record. On the prayer of learned counsel, the matter is adjourned till November 24, 2023.
Item number 8, Jagdish Prasad Kanu versus the official liquidator High Court.
Not to, no order. Not to record.
Item number 9, Griham Food and Hotel Private Limited.
My lord, the side is not there.
Other side is not there. That's a difficult. Very well. Not today. Then. You are there. Oh, you are for the petitioner.
Would I appear for the petition? The side is not there.
Both sides are there. We can start. Yes, yes, come. You're invited. You, 9?
10, my lord.
So what shall you do, Mr. Dotto? Let us make it not today. Nobody is happy. Tomorrow.
Tomorrow, not on Saturday.
Why not on Saturday? Come on Saturday.
Well, I'll be coming. Not that I.
You have, yes.
But I have arbitration fixed for the entire day because we did not know that 18
right.
will be a working. That is the reason. I will be Millard out of home in any case.
Yes. Anyway, not today. Not today.
Item number 10, OPT Solutions Marketing.
Lordship, I am praying not today because there is a fever in my
Fever?
Fever. I have a fever.
All not.
Not any event. This is not maintainable as well.
That is the reason of your fever.
Wait, this was taken up on the last occasion also. Anyways, no,
not.
Oh, acha, to diye gelo na?
Not today.
Sir, Mr. Banerjee came.
Yes, Mr. Banerjee.
Passover matter.
Passover matter.
Passover matter.
Passover matter. Item number 5.
Yes. Move the matter, Mr. Dotto. Mr. Banerjee is here. Your prime target for the day.
বলুন কিছু বলবেন কিনা, না বলার পরে আবার কিছু টাইম নেবেন, আগে বলে দিন। আগে বলে দিন।
20. You have failed your time to file opposition, so we'll have to hear without opposition.
Subject to Lordship's kind sanction. You cannot do it in a proper way. But 1 week adjournment, my lord, if your lordship allows.
Why?
Can it be taken up on 23rd, my lord, so that he can affirm the affidavit?
23rd আমার একটা প্রবলেম আছে।
Because interim order is there. Already my lord has passed the interim order.
Yes, Mr. Datta.
Interim order is there.
On the prayer of learned counsel for the respondents, the time for filing opposition is extended till November 23, 2023. Reply, if any, shall be filed by November 29, 2023. Let the matter be listed under the same heading on November 30, 2023.
First December, my lord, kindly.
23rd, 29th, 30th.
1st December, my lord, kindly.
Why 30th? What is the difficulty in 30th?
No, interim order is there.
No, I have some other.
তাহলে returnable
First
টা
December.
30th November না করে
1st December.
on December 1, 2023. First.
Much older.
Right.
ঠিকই আছে। ঠিকই আছে। Size ঠিক আছে।
Item number 11.
Not today.
Item number 12.
Yes.
Tomorrow, my lord.
Tomorrow. Could have said that earlier. My officer would have been saved from another.
On Monday, kindly.
On the prayer of learned counsel for the parties, let the matter stand adjourned till November 20, 2023.
Grateful lordship.
Appearance clear. Item number 13, Kothari Medical Center.
13, I'm led by Mr. Shuddhaswata Banerjee, my lord, for the petitioner. Anytime, my lord, lordship keeps it.
Not today. In any event, we cannot finish the matter. We cannot finish any short matter which can be done in 5 minutes. I can take it up. পাঁচ মিনিটে না হলে একটা অর্ধেক শুনিলে আবার পাটা রয়ে যায়।